Forget the Constitution. Let's just talk politics, you and me.
It's very hard to answer. You began this line of questioning by answering me, never mind what the right of privacy consists of. I can't answer that question without knowing what you mean by the right of privacy.
Sure, you can acknowledge whether or not you believe there is, in fact, let's start over again. Clean the slate. Do you believe that Americans as a whole believe that there is a right to privacy that they have, inherent, that they think they have a right to privacy? Do you think that's a deeply and profoundly held belief by American society? Whether it's found in the Constitution or found in natural law or found in their Bible or found in the Talmud, as a society. I mean, do you have any doubt that Americans believe?
I'll give you that, Senator. I think
Good man, I tell you, we're getting there. All right. Now, having said that, do you believe that is there any doubt in your mind that the Ninth Amendment, in conjunction with other amendments as it relates to particular assertions of particular rights of privacy? If I can find the Ninth Amendment here so I don't misquote it. Do you have the Ninth Amendment sitting there? Dig it out for me, will you? Roman numerals confuse me, Judge.
Let's see if yours is the same as mine. I have one here, too.
All right. I almost read the 11th. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Is there any doubt in your mind that the people, at the time and now, believe they have retained the right to privacy, whatever that means?
This morning, the committee begins its consideration of the nomination of Antonin Scalia to be Associate Justice of the Supreme Court of the United States. If Judge Scalia is confirmed, he will become the 106th person appointed to the court. Last week, during the hearings on Chief Justice Designate Rehnquist, I again described the qualities I believe are necessary for a member of the court: integrity, courage, knowledge of the law, compassion, judicial temperament, and an understanding of and appreciation for the majesty of our system of government. I believe Judge Scalia has these qualities. During his appearance before this committee 4 years ago, and during his tenure as a member of the United States Court of Appeals for the District of Columbia Circuit, Judge Scalia has always exhibited these qualities. Judge Scalia has an outstanding educational and legal background. He was first in his class at Georgetown University and graduated magna cum laude from Harvard Law School, where he served as an editor of the Law Review. He has been involved in the private practice of law and has taught at the University of Virginia and University of Chicago Law Schools. Judge Scalia has also held important positions in government. He has served as General Counsel in the White House Office of Telecommunications Policy, as the Assistant Attorney General for the Office of Legal Counsel, and as Chairman of the Administrative Conference. In August of 1982, he was appointed to the Court of Appeals for the District of Columbia Circuit, which many call the second highest court in this country. A review of Judge Scalia's actions and record in these endeavors indicate he does possess the qualities to be a great Supreme Court justice. In addition, those who have been associated with Judge Scalia throughout his life, even if they might disagree with him philosophically, consistently describe him as a person who is open-minded, a consensus builder, and an individual with a keen intellect and sense of humor. These are unquestionably qualities we desire in a person who is to be elevated to the highest court in the land. Finally, Judge Scalia is now cast in the role of a symbol. Certainly, he creates great pride by being the first Italian-American who will sit on the court. However, he also serves as a symbol in an even larger context. Judge Scalia, a first-generation American and the son of an immigrant, has been chosen by the President to be a member of the Supreme Court. By dedication and hard work, Judge Scalia has reached the apex of his chosen profession and stands as proof of the vitality of the American dream. Judge Scalia, we again welcome you to the committee, along with your wife, Maureen, and your family. And I believe 8 of your 9 children are here, are they not?
Yes, Senator. I don't know what happened to the 9th. He's supposed to be here too, but oh, he's here. They're all here, Senator. We have a full house. I was worried about that.
We have several senators here to introduce you, and we'll hear from them and then excuse them. The senior senator from Virginia, Senator Warner, in which state you reside.
Thank you, Mr. Chairman, and members of the committee. It is indeed a privilege to appear before this committee to represent and introduce this distinguished American who we are privileged to have as a resident of Virginia, together with his family. I'd like to emphasize that Judge Scalia has long been a distinguished citizen of the Commonwealth of Virginia. Indeed, his first teaching position was at my university, the University of Virginia Law School. In 1982, President Reagan named Judge Scalia to the United States Circuit Court of Appeals for the District of Columbia. Since that time, Judge Scalia has proven himself to possess the qualities essential to success as a member of the Supreme Court. He is respected by his colleagues as a brilliant legal scholar, as a man of impeccable ethics and integrity. Furthermore, Judge Scalia's judicial philosophy is rooted deeply in those strong principles upon which our Constitution was founded and has existed these 200+ years. He is a thoughtful, deliberate, and gentlemanly scholar who has served throughout his public life with great distinction. Looking ahead to the docket facing the Supreme Court as it begins its first Monday in October, one of the great assets Judge Scalia brings with him is a willingness to face difficult issues head-on, and he's had a long tradition of hard work. Finally, as the chairman pointed out, his ability to successfully manage, together with his lovely wife, a family of 9 children, may indicate something about his temperament as a future justice of the Supreme Court. From his experience as a teacher, private practitioner, a published author, and a member of the U.S. Court of Appeals, Judge Scalia represents the ideal combination of credentials for membership on our highest court. I thank the chairman and the committee.
Distinguished junior senator from Virginia, Senator Tribble.
Chairman, I too am pleased to join my colleagues this morning in presenting to this committee Judge Scalia. Judge Scalia served with distinction as an attorney, as a teacher, and most recently as a judge on the U.S. Court of Appeals for the District of Columbia. In every position, Judge Scalia served with distinction. As a scholar and as a judge, he has demonstrated a rigorous intellect and a mastery of the tradition of American law. He will bring those same qualities to the Supreme Court. I have no doubt that Judge Scalia will build a long and distinguished record of service to the court and to our nation. I urge this committee to act promptly and positively on this nomination.
The distinguished senator from New York, Senator D'Amato.
Thank you, Mr. Chairman. And I'm going to ask, Mr. Chairman, that the full text of my remarks be included in the record as if read in their entirety. Mr. Chairman, it's a great honor and indeed a privilege for me to be here with my colleagues to present to you and to the committee Judge Antonin Scalia as President Reagan's nominee to be a Justice of the United States Supreme Court. It's a source of great pride to all Americans, and particularly to all Americans of Italian descent, that this brilliant son of an immigrant is being nominated to our nation's highest court. Judge Antonin Scalia is the first Italian-American ever nominated to the Supreme Court and is a source of great, great pride to the Italian-American community. And Mama D'Amato, Judge, sends her best.
Thank you, Senator.
Judge Scalia's father, Mr. Chairman, came to this country through Ellis Island, as did so many millions of our ancestors. His grandfather brought his family to America seeking only the opportunity to work hard and to make a better life for his family. When Judge Scalia's father became a professor of Romance languages at Brooklyn College, he moved his family to Elmhurst in Queens, New York. Antonin Scalia attended high school at St. Francis Xavier Academy in New York City. He attended Georgetown University and graduated first in his class. At Harvard Law School, he was note editor of the Law Review and graduated from Harvard magna cum laude in 1960. Antonin Scalia has excelled at every area of the law to which he has turned his attention. After practicing with the well-known Cleveland law firm, he taught at the University of Virginia for 3 years, and thereafter had an exemplary career in the law as a professor, as a practitioner of the law, and as a noted jurist. Mr. Chairman and members of the committee, I submit to you that Justice-designate Scalia has earned the great honor that the President has conferred upon him, and I am confident that Judge Scalia will be outstanding, not only as the first Italian-American justice to serve on the Supreme Court, but as one of the greatest justices of any background to serve on that court. And indeed, it's a great honor for me to be able to present him to this distinguished committee, this very distinguished nominee. Thank you, Mr. Chairman.
Thank you. We appreciate you gentlemen being here and speaking and introducing Judge Scalia, and you're now excused. Of course, remain if you care to. Senator Manchin, Senator Moynihan on the way, but we cannot wait. We'll proceed. Distinguished ranking member, Senator Biden of Delaware. For an opening statement.
Thank you, Mr. Chairman. Judge Scalia, congratulations on being nominated by the President, your family must be proud, and they're a good-looking family, all of them. I have a brief statement. I ask unanimous consent that my entire statement be placed on the record as if read.
Not objection.
Let me say to you, Judge Scalia, and to my colleagues on the committee, that this hearing, although equally as important, is different than the hearing we had last week, in my view. We last week looked at the Chief Justice and the role of the Chief Justice. As one senator, I believe there's a distinction between the role of the Chief and the role of an associate. And secondly, we do not have 15 years of Supreme Court decisions to look at and to pore over, to make judgments about what your jurisprudential philosophy is, Judge. You do have 4 years on the Circuit Court, most of which the decisions I have read, a vast majority relate to administrative questions, very important, but nonetheless does not give us quite the full range of review that we have with regard to Justice Rehnquist. And therefore, I believe it very important that we spend some time today discussing, and you discussing with us as freely and as openly as you have a reputation for doing, your judicial philosophy. Therefore, I'm going to pursue about 6 areas, Judge, with you, based upon my review of your writings and your opinions. At the heart of my inquiry will be an effort to obtain a better understanding of how you view the Constitution as limiting the role of the federal government, or the government at all levels for that matter, in solving societal problems. First, I will seek to better understand how you view the Constitution as limiting the use of independent regulatory agencies and protecting the health and welfare of Americans. For example, there are constitutional limitations, are there constitutional limitations on what Congress can and should delegate to these regulatory agencies? And secondly, what is the proper role of the statutes in solving the problems that face this nation? How specific must Congress be in crafting these solutions? Would you place a straitjacket on my colleagues in terms of requiring such specificity that normal political processes could become, in fact, a logjam? Or where Congress by design leaves ambiguity, what role does the executive branch, the court in particular, and the legislative history have in determining how that ambiguity should be fleshed out? And thirdly, I want to talk to you about what standards should guide the Supreme Court in determining original intent, or to use your phrase, original meaning, as you prefer to say, of the Bill of Rights or of the Civil War constitutional amendments. And what do you mean by the notion that the courts should not create new rights under the Constitution unless a societal consensus, as if I read your writings correctly, exists for that new right? What would this have meant to the court that wrote Brown versus the board, or Baker versus Carr, or any number of other decisions? And what should it mean to a court which is going to face reconsideration of Roe v. Wade? And the fourth thing I'd like to talk to you about is what are your personal views on the proper scope of the concept of executive privilege, something we have some interest in of late here in this committee, especially when Congress seeks documents on a nominee pursuant to its constitutional responsibility to exercise its advise and consent function. The fifth area is what are your views on the First Amendment, especially as it relates to the freedom of the press and expression of speech through symbolic acts. And the sixth and last area I'd like to raise with you, Judge, as we go on today, is what is your view of the most elusive, but in my view, one of the most cherished principles, and that is the right to privacy. In every case, I will view your answers through the lens of their relationship to the settled judicial notions and the overall balance of the court, but I will do so with the full recognition that in each of these areas there's plenty of room for healthy and principled disagreement, and I truly look forward to discussing these areas with you and hope you find today a pleasant undertaking and that your family concludes that also.
Distinguished Senator from Maryland.
Thank you, Mr. Chairman.
Just a minute, let me make this statement. And we have a right to make an open statement. I'm not going to try to curb any of them. At the same time, there's no use to tell what you're going to go into, just wait and go into it later. You'll save a lot of time. Senator from Maryland.
Mr. Chairman, I'm glad to join with you and other members of the committee in welcoming Judge Scalia here this morning. Judge Scalia comes before us with an impressive record of achievement and persuasive endorsements, not to mention the recommendation of the President of the United States. There is, from the outset, I think, no doubt that he has the intellectual attainments and the legal and judicial experience to serve effectively on the Supreme Court. His strong credentials make it all the more important that we pause at the beginning of this process to reflect on the importance of the task that the Senate is about to undertake. No responsibility entrusted to the Senate is more important than the duty to participate in the process of selecting the judges of the United States courts. Our role in this process is different from any other business. Most of the other decisions we make are subject to revision either by the Congress itself or by the executive branch. Statutes can be amended and budgets rewritten and appropriations rescinded. But of the legislative sins we commit in haste, we can repent most in leisure. But a judicial appointment is different because it's for life. The decisions of a judge of an inferior court are subject to correction in the appellate process. If the system works as it should, no lower court judge can stray too far from the law of the land. But a Supreme Court justice is different. In Justice Jackson's famous dictum, that tribunal is not final because it's infallible, but it is, in the constitutional sense, infallible because it's final. Precedent controls a lower court's disposition of a constitutional controversy. But for the Supreme Court of the United States, precedent is a path that the court may usually, but need not always, choose to follow. Judge Scalia, if he is confirmed, will be charting new routes, correcting old courses. So the Senate has an obligation to find out as best we can where the nominee would take us before we decide whether to empower him to take us there. The Supreme Court has an unparalleled power under our constitutional system to advance the cause of liberty or to impede it, to strengthen the foundations of Republican government or to undermine them. And that may help to explain why the framers of the Constitution thought that the power to appoint justices was too important to be reposed in the hands of one branch of government alone. Of this sharing of power, the President's to nominate, the Senate's to confirm, Hamilton wrote that it is not easy to conceive a plan better calculated than this to produce a judicious choice of men for filling the offices of the Union. That process begins today, and the nation once again puts Hamilton assertion to the test. Judge Scalia merits our congratulations. He's the President's choice for an office of unsurpassed importance. He also deserves our wishes for good luck, for the scrutiny of this nomination will be and should be thorough and exacting. The Constitution and our oaths to support and defend it demand no less. When we carry out our duty to give the President advice and to consent to his nomination, as our predecessors first did nearly 200 years ago, our first loyalty, like theirs, is neither to the party nor to the President, but to the people and to the Constitution that they have established. If we cannot act and recognize that higher loyalty when we confirm judges, then we cannot demand it of the judges that we confirm. Thank you, Mr. Chairman.
Our next opening statement by Senator Kennedy. Senator Kennedy, I know Senator Meneses has come in, and Senator Moynihan, where is here too. Would you mind giving them 3 minutes each before you start?
Welcome, my colleague.
Senator Meneses and Senator Moynihan, you all come around, and we took the senators before we started opening rounds, but you're not here, but save your time.
Give that to Pat.
And we'll take you now for 3 minutes each. You can put a full statement record if you want to, but if you'll take 3 minutes to give us the thrust of it.
Thank you very much,
If I
Mr. Chairman.
could, the outset, we welcome Senator Domenici, we've had Senator D'Amato, and we have Judge Scalia, who all come from a certain ethnic background. If this establishes a precedent, I want the chair to understand we have 32 Irish men in the Senate. When there's an Irish nominee, the agenda will be very filled, but we're delighted to have Senator Domenici here this morning.
Senator Kennedy, if that happens and I'm up there, I would welcome all 32. First of all, Mr. Chairman and members of the committee, I'm not here to discuss Judge Scalia's legal abilities, actually, because he's lucky that I'm not going to do that, because I heard that he wrote the opinion striking down Graham Rudman Hollings. But in any event, this is a great day for me, because I wouldn't miss this unless you wouldn't let me talk. You're all aware of the litany of successes, all the way from graduated summa cum laude from Georgetown, cum laude at Harvard, fellow at Harvard, prestigious law firm, professor at the University of Virginia, and on and on and on. That's many lifetimes worth of achievement for most of us. As a scholar and a judge, he's made many major contributions to our jurisprudence on administrative law, separation of powers, libel and slander law, and many other areas. And as I see it, he's now poised to proceed to the pinnacle of his profession. It's a distinct pleasure for me to speak on his behalf because he's a personal friend. I have no doubt that you've read about his wonderful tributes to him, such as articulate, energetic, gregarious, brilliant, intelligent, quick-witted. They're there all the time whenever you read about him. But actually, Judge Scalia's nomination is meaningful to me for another reason. Judge Scalia is the first American of Italian extraction to be nominated to serve on the Supreme Court in the history of the Republic. I believe this is a magnificent tribute to the Italian Americans of this nation. Our president has repeatedly said that he will pick the very best men and women he can find to serve on this court. In this case, he has fulfilled that promise. He is the very best. In this case, he happens also to be an Italian American. There are millions of Italian Americans in this country, many of whom started with nothing, many of whom started with immigrant parents who may not have even spoken English, such as mine. Clearly, his father came here as a very young boy. His mother was an immigrant from Italy also. And obviously, it is with great pride that we witness one who shares our history and our traditions nominated to serve on the highest court of our nation. And of course, Italian Americans are Americans first and last, and it is because we are Americans that we applaud a fellow Italian American's achievement of the American dream. This is truly a success for Italian Americans and obviously a magnificent success for the American tradition. I have no doubt that he will serve with distinction on the Supreme Court and will make all Americans proud to call him one of their own. I thank you very much for permitting me to testify in his behalf.
Thank you very much, Senator, the distinguished senator from New York.
Mr. Chairman, I appear to express the satisfaction and indeed high expectations and gratification of another ethnic group in our country, which is, say, the academics, at the appointment of Judge Scalia. He comes from a distinguished academic family. His father was a professor of Romance languages at Brooklyn College. He himself graduated from Xavier High School in Manhattan, went on to Georgetown, then to Harvard. He did practice law with great success for a period of about 8 years, but thereupon went into the teaching of law, which has been his avocation ever since. Judge Scalia's nomination by the President, by President Reagan, marks the first time a professor of law has been nominated to the court since Felix Frankfurter was nominated by Franklin D. Roosevelt. That's 47 years, sir. And 47 years between law professors is long enough. And I'm sure, on that note, I'd like to let you get on with these hearings.
Thank you very much, Senator.
Whilst, may I say also, expressing the appreciation of this member of the Finance Committee. Over the years, we've had more than one occasion when Judge Scalia has advised us, testified before us on constitutional issues regarding taxation. He has invariably been a source of counsel and guidance and good judgment in our view, and I commend him to this honorable committee.
We thank you both for your presence and for your testimony. We'll now hear from Senator Kennedy.
Thank you very much, Mr. Chairman. I want to begin by commending Judge Scalia on his nomination to the Supreme Court. At the outset, let me say that this nomination, certainly at this stage, raises fewer of the concerns that have led me to oppose the nomination of Justice Rehnquist to be Chief Justice. In my view, Justice Rehnquist's career of relentless opposition to fundamental claims involving issues such as racial justice, the equal rights for women, the freedom of speech, and the separation of church and state places him outside the mainstream of American constitutional law as an extremist who should not be confirmed as a Chief Justice of the United States. Judge Scalia has been on the bench only 4 years and has not ruled on many basic constitutional issues. His record in these areas is less complete than Justice Rehnquist. On the available record, I disagree with Judge Scalia on women's rights, and it's fair to say that his position on this issue seems as insensitive as Justice Rehnquist. I'm also concerned about Judge Scalia's writings on two important areas in administrative law, his apparent views that the independent agencies are unconstitutional and the courts can undo the New Deal by denying Congress the power to delegate authority to regulatory agencies. But in other areas that are a major concern to me, it's difficult to maintain that Judge Scalia is outside the mainstream. Should he be confirmed as a justice, I'd hope that as a result of these hearings and his new rank, he will look with greater sensitivity on critical issues, especially on race discrimination, the right of women to escape their second-class status under the law and to share fully in the protections of the Constitution. Finally, as far as I can determine from the investigation carried out so far, the nomination of Judge Scalia presents none of the troubling issues with respect to the truthfulness and the candor, judicial ethics, and full disclosure that have marred the nomination of Justice Rehnquist. And as a scholar, public official, federal judge, Mr. Scalia has demonstrated a brilliant legal intellect and earned the respect and the affection of colleagues whose personal philosophies are far different from his own. I look forward to his testimony.
Distinguished Senator from Nevada.
Judge Scalia, welcome to the committee. I couldn't have been more delighted when I was informed the President has settled upon you for this very high position. Looking at that wonderful family out there, they all must be proud. Really experiencing the American dream today in many respects. to have the son of Italian immigrants rise to this very high position has to be a singular experience for each of the members of the family. I have a strong suspicion that these are going to be very civil hearings, far more so than last week, because I can't think of one of my colleagues who would dare arouse the ire of the Scalia clan. As far as the family is concerned, at times these questions are going to be hard and they're difficult. There's a reason for that, because under the Constitution, we on this committee and the full Senate has a serious, fundamental constitutional responsibility. It's up to us not to rubber stamp the recommendation of the President, but to take an independent look, and we do that. And it's a trying experience very often for all concerned. But please understand that every one of the members of the panel here is attempting to discharge his responsibilities he sees fit as a member of this very important committee. I feel very strongly, Judge Scalia, you're going to quit yourself well because you're a pro. You're a thoroughbred. I look forward to a speedy confirmation. I thank the Chairman.
Distinguished Senator from Ohio.
All right?
Judge Scalia, we're happy to welcome you here and welcome your family as well. Parenthetically, I'd like to say that looking out at that youngest daughter of yours, young sons, I don't think there's any requirement that they sit through these laborious, tedious hearings. Anytime they leave, I think every one of us on the committee will full well understand that they still support you, but it is a rather tiring process with young children. Judge Scalia is an accomplished scholar, a former Assistant Attorney General, sitting judge of the Court of Appeals, and well known in my own community of Cleveland, practiced law there for 6 years. There can be little question about the fact that he is qualified for the position of Associate Justice. To my knowledge, there are no allegations of impropriety or misconduct. Consequently, I believe the integrity of the nominee is not an issue. Judge Scalia, you know personally of your one area of bad judgment, and I think it was bad judgment in whipping me on the courts, not in the courts, but I think that too can be passed over and not made a major point of issue.
It was a case of my integrity overcoming my judgment, Senator.
Touche. My only area of concern relates to some of the views Judge Scalia has stated in a number of critically important areas, such as the proper approach to constitutional interpretation, separation of powers, the circumstances under which citizens may seek relief in federal court for government actions. Judge Scalia seems to take the view that there should be very little limitation on the authority of the executive branch. That view concerns me, because the framers of the Constitution clearly had in mind that the three branches of government were to be co-equal. No branch would be able to dominate the other. I also have concerns about his approach to interpreting the Constitution. Some of your statements suggest that the role of the courts is to carry out the will of the majority. Yet this country was founded on the principle of individual freedom. The Bill of Rights was adopted as a permanent guarantee that the majority could not limit certain basic rights of individuals. I have no doubt that I disagree with Judge Scalia on many issues, not simply issues of political philosophy, but of statutory and constitutional interpretation. But whether or not we agree on these issues is not a valid question as I exercise my advice and consent responsibility. The question is whether he will be faithful to fundamental constitutional values, even if he may apply those in particular cases differently than I or any other senator may prefer. I have an open mind on this nomination. As in the case of the nomination for Chief Justice, we have an obligation to conduct thorough and complete hearings, even though the process is a demanding one for the Senate as well as the nominee. Finally, I note that some senators, including myself, have requested documents from the Justice Department, including certain memoranda prepared by Judge Scalia when he was in the Justice Department. As in the case of Justice Rehnquist, these memoranda were prepared while Judge Scalia was head of the Office of Legal Counsel. In this position, he was the chief legal advisor to the executive branch on highly significant legal issues, issues that are of direct concern to the Senate in considering this nomination. I sincerely hope that the President will not choose to assert a claim of executive privilege in denying us access to those documents. The country will be better served, and this process will be expedited if the President does not assert the privilege. I might also point out that based on his own, that is the President's own 1982 executive order regarding executive privilege, it should not have been asserted in the case of Justice Rehnquist, and it should not be asserted in this instance. I believe the Senate is determined to carry out its obligation in a responsible way, and I hope the President is as well. We welcome you to these hearings, Judge Scalia, and look forward to working with you.
Senator from Utah.
Thank you, Mr. Chairman. Welcome to the committee, Judge Scalia. We really look forward to this confirmation proceeding. And I do hope it won't be quite as strenuous as the one last week. Let me just say this, Mr. Chairman, perhaps I won't take very long. I would ask that my full statement be placed in the record. But perhaps no standard speaks more eloquently to the merits of this nomination than the performance of Judge Scalia on the Court of Appeals for the District of Columbia Circuit. In more than 4 years on that esteemed court, he has written 86 majority opinions, and only 9 of them has been accompanied by a dissenting opinion. In other words, Judge Scalia has won unanimous approval for his views in nearly 90% of his written opinions. Another 90% measure of success is found in the rate at which Judge Scalia's positions have been sustained on appeal. The Supreme Court has adopted his views 6 out of the 7 times his cases have been reviewed on appeal by the court that he is now being asked and appointed to join. This includes his courageous opinion in the Sinor case, which identified the separation of powers problems in the budget-cutting Graham-Rudman law. Now, these facts are high praise for Judge Scalia from those best positioned to adjudge his legal stature and ability. Those are his fellow judges. Now, these judicial actions speak a lot louder than even the words of his judicial colleagues, among whom is Circuit Judge Abner Mikva, who hails this appointment as, quote, good for the institution, unquote, of the Supreme Court. I think that's high praise. I have a lot more to say, but let me just cite the report of the Almanac of the Federal Judiciary. The Judge Scalia is highly respected in all categories, admired even by those lawyers who disagree with him. Over and over, the same qualities are admired in Judge Scalia: his fairness, his integrity, his openness to varied viewpoints, his amazing mastery of the law. Judge Scalia is respected as a lawyer's lawyer by lawyers, and as a judge's judge by judges. In the words of the American Bar Association, this committee is privileged to consider the nomination of this individual who, quote, is among the best available for appointment to the Supreme Court, unquote, having given you the highest rating the American Bar Association can possibly give to any candidate for this position. So I'm happy to welcome you to the committee. I respect you, read your opinions. I think you will add a great dimension to the court, and I agree with my colleague, Senator Laxalt. There's no question that this is a happy day for millions and millions of Americans. As a matter of fact, I think it should be a happy day for all Americans. Thank you, sir. Thank you, Mr. Chairman.
Thank you, Senator Hatch. Senator DeConcini.
Mr. Chairman, thank you. Mr. Chairman, I want to first not only welcome Judge Scalia, but I want to thank Chairman Thurman for the way he operated and conducted the hearings last week on behalf of Justice Rehnquist. I know that my colleagues and I have had, I think, an excellent opportunity to question the witnesses at length and go into almost any subject matter, or for that matter, go into any subject matter. I know there's great pressure to move these nominations along, but I particularly want the record to show my deep appreciation to Chairman Thurman in his fairness. Mr. Chairman, I realize that I'm sure as we all do, that the equal responsibility now lies with us in the hearings of the nomination of Judge Scalia for Associate Justice of the United States Supreme Court. Judge Scalia, if confirmed, will likely spend many, many years on the court, sharing an equal vote with the Chief Justice and the other Associate Justices. It is therefore our responsibility to keep up the steam. Our constitutional mandate, role, and advice and consent on the nomination of Judge Scalia is as important as the deliberation we undertook last week in respect to Justice Rehnquist. Indeed, Justice Rehnquist will remain as a voting member of the Supreme Court regardless of the final action of this committee and the Senate in his confirmation for Chief Justice. Judge Scalia, however, is a new voice for the court. It's tremendous important that we give this hearing the full energy and attention. Let no one say that the Judiciary Committee ignored its duties to examine the President's nominee for Associate Justice. I must say that I'm very pleased that the President has nominated a person with the experience and credentials of Judge Antonin Scalia. Clearly, we have before us a nominee with legal experience, public service, academic experience, and judicial experience. The American Bar Association has found that Judge Scalia meets the highest standard of professional competence, judicial temperament, and integrity. And I'm pleased to concur that he is indeed among the best available candidates for consideration. Judge Scalia comes to us from the D.C. Court of Appeals with an outstanding reputation. He frequently writes his own opinions without the aid of the first draft prepared by a clerk. He prepares extensively for his oral arguments on his briefs himself. He is clearly a man who will make his presence felt on the Supreme Court. He's a hard worker, but one who is personable, and he shares a great deal of friends across the political spectrum in this town, and I'm sure in his own communities that he's lived. I take pride as an Italian American in noting Judge Scalia's heritage. In this year that our country has shown so much pride in celebrating the 100th anniversary of the Statute of Liberty, we can take note of the contribution of Judge Scalia, the son of an Italian immigrant. He is but another example of immigrants who have risen to outstanding positions in our government and served in the judiciary. As a first-generation Italian-American, Judge Scalia demonstrated that the rapid assimilation of immigration people pumps strength and vitality into this great nation. So I wish to join my colleagues in extending a warm welcome to you, Judge Scalia. Regardless of your personal opinions on the operation of the branch of governments, I hope you look forward, as I do, to these hearings. There will be some tough questions asked of you, and I'm sure you will meet those questions head-on as you have in your past life. But I believe that you are eminently qualified for this position and will serve this country well. Thank you, Mr. Chairman.
Thank you, Senator Giussini. The distinguished senator from Wyoming.
Well, welcome to the pit. Privileged to welcome you here and your fine wife and family. This is our role of advice and consent, a function we perform which is of great import and significance. I very much enjoyed my visit with you prior to these proceedings. I've come to have great respect for you when you appeared before this committee in 1982. I won't go on to relate your extraordinary background, most impressive to me. Your decisions are most impressive. I've actually read some of those, and it's marvelous the way you have that ability to bring that remarkable brilliance to a form where the common person can understand. That's what the law is all about. What good are we as lawyers or judges if the things we do for our clients or for a case cannot even be understood? So I'm impressed by that. Well, I would just share with you, I missed a day or two of the action last week while I was marrying off the oldest son. And I assume that you have been watching the attempted evisceration of William Rehnquist. The great hunters have been out to tack the pelt of Bill Rehnquist on the wall of the den. What an exercise. It's like that old Clint Eastwood movie, The Good, the Bad, and the Ugly. And it was, and it is. How curious to see how tough and ringy and red-faced we can get, to point and posture and pontificate, ruffle up like a sage chicken, and even take a shot at the poor old alfalfa club. That is named after the plant that sends its roots deepest for liquid refreshment, thus the name. A patriotic and fun-filled evening which is held once a year and attended by every president for nearly 80 years. So that's very frustrating for me because these are my friends here at this panel, Democrats and Republicans alike. I admire, I respect them and enjoy them, regardless of their ideology, and we have broken bread together. None of them are perfect, I can assure you. I am not perfect, I can assure you. Then why the ritual? The known human frailties that beset us all, just the known ones, are enough to confound us and confuse us in our own lives. The unknown ones we do worse with. Who appointed us the scorekeepers? Who appointed us the judge? Who writes the exams here? And who grades them? Those roles are all self-appointed here. Well, we certainly washed all the laundry on Bill Rehnquist. I assume we'll do that with you. And yet not one of us here would want to sit right there at that table. We couldn't pass the test. We couldn't stand the heat. It's easier up here. Here we can brag and bluster and blather and almost like a comic book character you could invent to Captain Bombast. Pull the cape around the shoulders and shout the magic words, "Get him," and rise above it all on a blast of hot air. Now that's what we see. It's funny, but it really isn't very funny at all. Human beings are involved, real families and real hurt are out there in the real world of the inquisitors and the accused. And that is the word I wish to use. Not presidential nominee, the accused. How can we demand perfection of others now or in the past when we don't have that in ourselves? How can we expect perfection in legislating or in judging on a court or in the world of business or sports or assembly lines? Any task when we don't have it in our own lives? Well, not me. I've flunked out on perfection. I can tell you an awful lot about my imperfections, but not much about the perfect Simpson. And so we have listened, and I don't know what the mixed bag will be for you, but it will be curious. But we have listened before to ballot security in days when you were by law to ask people if they could read the Constitution of the United States before they could vote. That may be harassment in some other state. In Wyoming, it was the law. Repugnant, bad law, but the law. Memos of a young law clerk, memos of a young lawyer, memos to a judge, memos that fit, memos that didn't fit, memos and decisions that were made were ill-considered, ill-advised, or a little dumb or dull. Restrictive covenants contained in deeds on my family home in Cody, Wyoming in 1931, yours somewhere along the line. That's the way they used to do their tricks in those days. Repugnant, unconstitutional, disgusting, but there. in the home of every one of us, or our parents, or our grandparents. How fascinating. Stonewalling, wiretapping, cover-up, Lord's sake, didn't one of us here at this table had dabbled in all that mystery. And then the documents of a confidential nature, a sinister connotation that documents about documents, they've never been released under any administration. Well, enough. 3 sitting members, though, of this United States Senate, right now, voted against the sweeping Civil Rights Act of 1964. Do we keep score on them? Do we let them know we will never forgive? They changed, they listened, they adopted, they adapted, and they learned. Don't others get that leeway in this particular arena? Oh, I tell you, I can hear it now. Oh, Simpson, you old silly. There is a higher standard here for the Attorney General or for the Supreme Court or for the District Court. There is a nobler and higher yardstick for the Chief Justice or the Justice or for any presidential appointee. Well, what bosh and twaddle that is, what arrogance that is, true arrogance. A higher standard than that for a United States Senator? A proud office we all cherish and lusted after and try to honor? Just because we get elected? Well, we have a word for all that in Wyoming. It's succinct, scatological, and searing when it's said in the proper Western twang. What a spectacle. A spectacle it is. And some of it is planned for you, sir. So dig in and keep your fine humor. Tell them you did play the piano, and they will likely ask you where, and when, and whether the place was properly licensed or were there girls there. But through all the heavy guff that you will get, just recall that all of us, every single one of us, right here, sitting here now or outside, and me too, who are your inquisitors, have already flunked the real test. The real full and mature test of a full life lived, and none of us now could or would or did escape the barrel of the weapon turned back in our face. I think it was stated rather simply in an old and powerfully and never outdated classic by a chap named John, whose last name escapes me this time, who said, "He that is without sin among you, let him first cast a stone." Seems fair, doesn't it? Well, we shall see. Sure hasn't happened yet. America knows it, and they're galled by it, and they're offended. Thank you.
Distinguished Senator from Vermont.
Thank you, Mr. Chairman. I compliment the senator from Wyoming in giving his typically long, eminently quotable, and highly entertaining statement, but it was a statement to ask one question: who appoints us to ask these questions? The answer, of course, is simple. The Constitution appoints us. And it is a constitutional duty that I think all of us, Republicans and Democrats, take very, very seriously. We will in your hearing. We did in the ongoing Justice Rehnquist matter. And I suspect that next month and next year and 10 years from now and 30 years from now and 100 years from now, the Senate Judiciary Committee will be doing it in further such hearings. The Constitution requires it. We take an oath of office to uphold the Constitution. I think each one of us will have to answer to ourselves, are we doing our best to uphold the Constitution, just as you take a similar oath? And I'm sure you ask yourself the same questions every time you write a decision. The Senator Kennedy has commented we want, that he'd like to have some time. We have an Irish nominee.
I would say, Judge Scalia, my mother's family came here from Italy. We're very, very proud of that. They came as stone cutters. My Italian ancestry is a source of pride to me, and it's a source of pride to my family. I know how hard they worked as immigrants, stone cutters in Vermont. Ironically enough, my Irish grandfather was also a stone cutter in Vermont at the same time. I would say also welcome to your children. I would assume in reading Mrs. Scalia's maiden name that your children had really the best of all possible worlds, an Italian parent and an Irish parent. If you follow the tradition around here, that whichever one of you reaches 34 first should be a member of the United States Senate. That's the way it works in Vermont, and I would hope that it might work that well for you. I would also join with what Senator Metzenbaum said earlier. You also have young children, and I know it's a source of pride to you, and should be a source of pride to you, to have all your children here, and I'm sure that it's a source of pride to them to see their father nominated for what has to be one of the highest offices to be held in this land. But none of us would take it amiss, and I direct this also to Mrs. Scalia, if any of the children get tired and want a chance to go elsewhere, and I'm sure that any one of the senators on here would be willing to offer their office, I certainly would mine, for a place where the children could take a break. Just so that you know the areas, you and I have discussed this before, but I will go into questions on your work in the Office of Legal Counsel, as Assistant Attorney General in the Office of Legal Counsel. We'll probably be discussing your views on the Freedom of Information Act and openness in government, and your philosophy about opening the federal courts, litigants suing the government, especially with regard to interpretation of such concepts as standing and sovereign immunity, the standards you would apply in recusing yourself from cases. I, too, am extremely impressed by your impressive background, scholastic background, just as I was impressed very much by the scholastic and academic background of Justice Rehnquist. I think you will find, as you will find in these, that our questions will be pertinent to the point, and I would assume that you see your meeting here as not stepping into a pit, but rather fulfilling one of the highest obligations under our Constitution, both for you and for us.
Criteria which I mentioned with respect to Justice Rehnquist, namely those of Senator McClellan, in which he asks about personal integrity, professional competency, and abiding fidelity to the Constitution, I will ask that the rather lengthy propounding of this candidate be included in the record as if read.
Without objection, so ordered.
I congratulate you, Judge Scalia. You have said that the culmination of a dream for any attorney is to be appointed to the Supreme Court. I won't run through your qualifications at length, but with respect to your integrity, I would lean more toward a nuance of that, your personality, which I think will bear you in good stead here. One rather liberal colleague on the circuit court characterized you as one who is, quote, fun to work with, who enjoys the dialogue going back and forth, unquote.
Thank you, Mr. Chairman.
The distinguished senator from Alabama.
Thank you, Mr. Chairman. Welcome, Judge Scalia. I will ask to include in the record as if read my rather extensive comparison of this appointee with the three criteria which I mentioned with respect to Justice Rehnquist, namely those of Senator McClellan, in which he asks about personal integrity, professional competency, and abiding fidelity to the Constitution. I will ask that the rather lengthy propounding of this candidate be included in the record as if read.
Without objection, so ordered.
I congratulate you, Judge Scalia. You have said that the culmination of a dream for any attorney is to be appointed to the Supreme Court. I won't run through your qualifications at length, but with respect to your integrity, I would lean more toward a nuance of that, your personality, which I think will bear you in good stead here. One rather liberal colleague on the circuit court characterized you as one who is, quote, fun to work with, who enjoys the dialogue going back and forth, unquote. Good luck in the next few or many hours. Your professional competency, even as a young man in high school, your intellectual capacity far exceeded those around you, and one classmate commented that in the case of this judge, ultimate judge, his classmates just competed to be second, that Antonin Scalia was so superior academically. He graduated magna cum laude from Harvard Law School, highly recognized for vigorous and prolific writings, 84 majority decisions written on the District Court of Columbia Circuit Court of Appeals, dozens of concurrences and dissents. And then this one, I think, will stand you in best stead here. On the bench, Judge Scalia has developed a reputation for meticulousness in preparation and ferocity in questioning. Presuming that ferocity in questioning also applies to answering, I think that'll help you. One colleague characterized you by warning, quote, pity the attorney who's not prepared. He is tough and formidable and gives no quarter. He's fair and he's intelligent, but he's not deferential, unquote. That might be too harsh on you, but I think that that will stand you in good stead here, because I don't think you will be as meek and mild as some of the victims who have preceded you here. I am particularly sensitive about one of those, a man, and again I would identify myself with the senator from Wyoming in that I respect my colleagues, all of them. I think that what has been done here lately, and rather obviously, conspicuously to the American public, is use a barrage of charges for partisan purposes, political purposes, to establish unjustified doubts among some very outstanding individuals nominated for federal judgeships or the Supreme Court, the Chief Justice of the Supreme Court. We had ends justifying the means. If their end is to perpetuate the kind of liberal judges who were appointed before President Reagan took over, I think they're flying in the face of the mandate to Reagan and the very clearly expressed misgivings about the people in the United States as to the effect of those judges in overprotecting the victim, overprotecting the offender and underprotecting the victim of crime, among other things that we could talk about. But in the case of one after another, we had, Fitzwater, we had Sessions, Mannion, Rehnquist, and now you. We are seeing stonewalling. We are seeing In the case of Sessions, a campaign begun 9 months before he even got here in certain newspapers, charges delivered the day before his hearings, and ultimately the irony of it all resulting in a man being condemned for being a bad guy precisely for the very reason that he is a good guy. So it was unfortunate for our country, for Alabama, that Mr. Sessions was not able, through me and others trying to defend him, against that barrage, which effectively represented the weight of charges, appalling charges, simply exceeding the weight of attention given to the refutation of those charges. I hope you don't suffer the same fate. I do not think you will suffer the same fate from the characteristics I've already mentioned. I believe that you will, on television, prohibit the disporting of you. I think you have enough toughness, enough intelligence, enough qualities that will not abide your being defeated here. I think the backlash, national, which will not be in the many powerful electronic and print media, which side with those who have the philosophies and ends in mind, which some here do, and they are entitled to those, just as I'm entitled to mine. But I believe there will be a backlash evident, perhaps during your own hearings, and I hope before the end of Justice Rehnquist's. With those remarks, I encourage and I'm confident my colleagues will review carefully the excellent record of this candidate and join me in giving wholehearted support to his confirmation. Thank you, Mr. Chairman.
The distinguished senator from Alabama.
Judge Scalia, I believe that almost every senator that had it as an Italian-American connection has come forward to welcome you to this or to participate in this hearing thus far. I would be remiss if I did not mention the fact that my great-great-grandfather married a widow who was married first to an Italian-American.
It's not going to get you in the club, Howell, let me tell you.
Senator, I've been to Alabama several times, too.
So, Judge Scalia, it is with pride that I welcome you on behalf of the 4,322 Italian-Americans in Alabama and the other 4 million people to this hearing. I also am delighted to welcome your wife and your 9 children. Looking at the number of your children, it appears that you have had much experience in working with groups of 9. However, 9 is enough, at least for the United States Supreme Court justices. If confirmed, I know that your experience, family and otherwise, will help you build a consensus when justice requires it and to resolve the minor differences that may arise on the court. I believe that there are 2 underlying questions to bear in mind throughout these proceedings. First, what is the role of a United States Senator in the confirmation process of a Supreme Court nominee? And second, what qualifications should a nominee ideally possess in order to be confirmed? In addressing the first question, there is no greater duty of the United States Senate than its confirmation of Supreme Court nominees. The Constitution states that the President shall nominate and by and with the advice and consent of the Senate shall appoint judges to the Supreme Court. Many have looked to the past to determine the Senate's proper role in the confirmation process. Many look to present times to support the argument that all areas of inquiry are subject to Senate review. But when considering my role as a United States Senator to confirm or deny, I look to the future to see what this nominee will bring to the court and whether the individual will be a vigorous enforcer of the cornerstone of individual liberty, the Constitution. In my examination of a nominee to the United States Supreme Court, I am in agreement with the opinion of the late Senator John McClellan of Arkansas. He stated that there is room on the United States Supreme Court for liberals and conservatives, for Democrats and Republicans, for Northerners and Southerners, for Westerners and Easterners, for blacks and white, and men and women. These and other factors should neither qualify nor disqualify a nominee. To live under the American Constitution is the greatest personal privilege which has ever been accorded any member of the human race. Therefore, I believe the men and women to whom we entrust the opinion of our Constitution should be chosen with great care. In my opinion, only a handful of men and women are both qualified and capable of wearing the weighty robe of a Supreme Court justice. In each era, there arises particular threats to our constitutional democracy. Those whom we place on our highest tribunal must be able not only to meet these challenges, but also through their wise jurisprudence to prepare for future challenges. In order for a judge to accomplish these goals, I believe that a nominee should possess three criteria. First, an understanding of the proper role of the judiciary in our Constitution. Second, a deep belief in and unfaltering support of an independent judiciary. And third, an abiding love of justice. Paraphrasing Tennyson, we are a part of all that we have met. If confirmed, you will bring to the court a wealth of experience which will provide you with a solid foundation in your service to the people of this nation and to the Constitution of the United States. I understand that as a professor, you concluded your class each semester with a quotation from Robert Bolt. I think it is appropriate to cite another of Bolt's quotations here. The law is not a light for you or any man to see by. The law is not an instrument of any kind. The law is a causeway upon which, so long as he keeps to it, a citizen may walk safely. Judge Scalia, as a final arbiter of what the law is, keep that causeway forever straight, forever clear, and forever safe. Good luck.
Thank you, Senator Heflin. And now I believe Senator Grassley, Senator from Iowa, please.
Thank you, Mr. Chairman. First of all, let me personally congratulate you again, as I did in my office, on your nomination to serve on the Supreme Court. By all accounts, you are an individual of great intellectual firepower, an energetic scholar, full of thoughtful as well as thought-provoking ideas. Most recently, in your 4 years on the Court of Appeals for the District of Columbia Circuit, you authored more than 80 majority opinions and dozens of concurring and dissenting opinions. Your colleagues on the D.C. Circuit, it's my understanding, have found you a most reasonable and fair judge, congenial and easy to work with. This is the view even among those with a different philosophy than yours, like Judge Wald and Mikva. It's been said that you especially enjoy the give and take of lawyerly dialogue. This will make you well suited to the operation of the court as I understand it. Before your appointment to the Court of Appeals, you proved to be a formidable legal scholar at both the University of Chicago and the American Enterprise Institute. You have had nearly 24 articles published. I also note that you are the son of an Italian immigrant, and that's been played up as it legitimately ought to today. If confirmed, you will be the first Italian American to serve on the Supreme Court. Undoubtedly, this is a source of great pride in the Italian American community, as it should be. I believe it's further evidence of our truly pluralistic society. In sum, from what I know about your intellect, experience, and ability, it seems to me that President Reagan has made a wise choice. Thank you, Mr. Chairman.
Thank you, Senator Grassley. And now the Senator from Illinois, Senator Paul Simon.
Thank you, Mr. Chairman. First, if I may, and I regret he's not here, just respond very briefly to my colleague from Alabama on the partisanship. The charge of excessive partisanship, I don't think is frankly a fair charge. We have had, prior to the Supreme Court nominees, if my statistics are correct, 264 nominees for this body. We have had a roll calls on 4 of 264. I might add, in one of those 4 where there were serious questions, I voted with the president. The nominee who was held up longest from this administration was Judge Sporkin, held up by Senator Denton. We welcome you here, Judge Scalia. Reference has been made frequently to your Italian heritage, but I think it is a healthy thing that the Supreme Court be a representative body. Just as when Justice Marshall was named, I think it was a healthy thing for our country. You might even call it affirmative action, I don't know. But I welcome that, and there is no question on your ability. Let me just add, because the question has been raised, are we properly getting into views? Are we getting into things that we should not? In March, and let me just read 2 paragraphs from a statement I made in the Senate floor in March. There are 2 fundamental reasons that nominees' legal views should not be altogether off limits to the Senate. One is that just as we know that a nominee's competence and integrity will affect his views as a judge, we know that the nominee's individual views about legal matters will in some measure affect decisions the nominee makes as a judge. The reason is that judges inevitably have leeway. They must fill in gaps in the law and must resolve ambiguities about what the law is. And in doing so, a judge inevitably draws upon his or her starting point views and outlook. This is true of all judges, and it is especially true of Supreme Court justices, whose leeway in giving meaning to the majestic general commands of the Constitution is particularly great, and who must resolve conflicts among lower courts on a daily basis. A second reason a nominee's views may be relevant to the current Senate is that they were relevant to the President's own decision to nominate. As an active partner in the judicial appointment process, as the authority that must advise and consent to nominations in our systems of checks and balances, should the Senate evaluate any factor the President does? And if the President is trying to shape future judicial decisions by self-consciously nominating people with particular legal views, should the Senate, at least to some extent, consider whether those views are appropriate ones and good for the country? I think that is our role. I think Judge Scalia would agree that that is our role. I look forward to this, and I think you will, my impression is you're going to come out of it well in terms of votes, but I think the process is an important one. With all due respect to those who were critical of the hearings last week, I think they were healthy, good for the nominee, good for the court, and good for our system. I thank you, Mr. Chairman.
Thank you, Senator Simon. And now Senator Arlen Specter of Pennsylvania.
Thank you, Mr. Chairman. Judge Scalia,
join my colleagues in welcoming you and your beautiful family to these proceedings. The great thing about America is that it is a melting pot, and I think that it is about time that there was an American of Italian extraction who sat on the court. In saying that, I don't want to express a final view, but what has been said here today has been very complimentary, considering your outstanding record, even considering your law school was Harvard, but you have brought an extraordinary record to this point in your life. I'm especially pleased to have seen the emphasis on the fact that you are the son of an immigrant, as am I, and I think that's one of the greatest things about this country of all, that opportunity is unlimited. And I think one of the things that we have to do in the Congress and on the court is provide opportunity for the future, equal opportunity, and that involves all of the minorities that we focus on from time to time in these hearings. I will have some questions really about the authority of the court and the jurisdiction and the commitment to the preeminence of the court as the final decision maker in our society. We have a great many conflicts in our society. It seems that we have 230 million people and 231 million ideas. I know that as a senator from a state like Pennsylvania, which is really some 6 states and 12 million constituents, that there are many, many differences of opinion. And we vote in the Senate many, many times, some 2,400 times since I've been in this body. But there has to be a final decision maker, court, which has jurisdiction, unquestioned authority to be the final word on the constitutional issues, which is rock bed in our society. We've got a great country, we've got a great court, and when my time comes from the line of questions, that's the area of concern which I will address myself to. But I congratulate you for being here and the outstanding record that you bring to this point in your career. Thank you, Mr. Chairman.
Thank you, Senator Specter. I believe that the opening statements have been completed by our colleagues, and therefore, on this side of the aisle, I'm saying, yes, yes, I realize there are more of us than there are them. Hopefully for quite a while. Oh, no, shoot. No, please, no. Senator McConnell of Kentucky, Mitch McConnell.
Thank you, Mr. Chairman. Judge Scalia, I too want to congratulate you and your family. Our association, as you may recall, goes back to the days when we served together in the Justice Department during President Ford's administration, and I recall at that time everyone in the department, without exception, felt that you were not only the brightest lawyer that we had in those days, but had the best sense of humor. And of course, those were days when we needed a good sense of humor. I never will forget one morning at the staff meeting, we all had to suffer through the embarrassment of the morning Washington Post, which revealed that only the day before 2 illegal aliens had been arrested working for the Immigration and Naturalization Service. So we had to maintain a good sense of humor, and you were clearly the one who made those meetings entertaining as well as informative. You know, much has been said about your nomination and that of Justice Rehnquist in terms of the philosophical balance on the court. Since President Reagan announced his nominations of yourself and Justice Rehnquist, the question was, what kind of impact is this going to have? I think it's important to ask whether judicial conservatism really means the same thing as political conservatism. Judicial conservatism denotes a philosophy that treats the intent of the Constitution, the actual language of the Constitution and statutes, cautiously and with respect. In short, strict construction. Judicial conservatism also encompasses a healthy regard for the doctrine of separation of powers. This conviction holds fast to the proposition that the role of the judiciary, of the courts, is to merely interpret the law as written and not to act as a super legislature and substitute its own judgment or social preference for that of our duly elected representatives. Judge Scalia has often pointed out that this philosophy does not necessarily advance a conservative political agenda. For example, Writing early last year on the issue of judicial activism in the realm of economic rights, he observed in a magazine article, and I quote you, Judge Scalia, "Though it is something of an oversimplification, I do not think it unfair to say that this issue presents the moment of truth for many conservatives who've been criticizing the courts in recent years. They must decide whether they really believe, as they have been saying, that the courts are doing too much, or whether they are actually nursing only the less principled grievance that the courts have not been doing what they want." For Judge Scalia, it would appear that judicial conservatism speaks more to the judicial process than to the substantive political consequences of the court's holdings. Judicial conservatism is politically neutral. Judge Scalia has clearly demonstrated his adherence to this philosophy in practice. A cogent illustration is the recent holding referred to earlier this morning of the U.S. Court of Appeals for the District of Columbia Circuit in Sinar versus the U.S., better known on the Hill as the Graham-Rudman-Hollings case. In an unsigned opinion generally attributed to Judge Scalia, that court voided the key provision of that law for being unconstitutionally violative of the doctrine of separation of powers. This holding came as a blow to political conservatives interested in effectively reining in a runaway deficit. Yet, there was no hesitation on the part of Judge Scalia to strike it down. So too does Judge Scalia's judicial conservatism make him an opponent of the legislative veto, another pet project of political conservatives. Judicial conservatism hinges upon a tight and principled reading of the Constitution and does not turn on political considerations. It rejects judicial activism, either of the left or of the right, as constitutionally repugnant. Mr. Chairman, that leads to one additional issue that I believe ought to be put to rest. It's been asserted dogmatically by members of this committee and certain sectors of the media that candidates such as Justice Rehnquist and Judge Scalia are too extreme in their judicial philosophy, and that they are far removed from the mainstream of contemporary judicial thought. Such characterizations, to be blunt, are nonsense. Main Street America has spoken clearly and unequivocally throughout the decade of the 80s in articulating a new set of priorities for this nation. Part of the mandate that the citizens of 49 of these United States entrusted to President Ronald Reagan has been to rein in the extreme activism of our federal judiciary. The President, in nominating Judge Scalia, is carrying out that mandate. I would respectfully submit that those who maintain that the President's nominees are outcast from the mainstream of contemporary judicial thought are themselves so far adrift on the fringes that they have lost contact with the prevailing currents of American society. Judge Scalia's credentials and qualifications place him squarely on the crest of the new wave. Mr. Chairman, last week I set forward the 5 criteria that I believe should be weighed by members of the Senate in carrying out their constitutional duty to advise and consent in the matter of the nomination of a Supreme Court justice. I'll not go through those elements in detail today. I would like to go on record, however, in stating that based upon his competence, professional achievement, a judicial temperament that places a premium on fairness, courtesy, and congeniality, and just as important, his personal and professional integrity and high ethical standards, Judge Scalia is set apart as being among the most distinguished and eminently qualified individuals ever to aspire to sit on the highest court of this land. Judge Scalia has not only shown himself to be academically and professionally a lawyer's lawyer, but a judge's judge as well. He is highly regarded among his peers as an exceptional judicial craftsman, skilled in the arcane art of cogently drafting judicial opinions. It is this ability, no less so than his other ample qualifications, that distinguishes him from his peers and establishes him as uniquely fit to serve on the Supreme Court. It is this talent that lends practical substance to his abilities, permitting his colleagues on the lower courts to clearly carry out the edicts of the Supreme Court. It makes him a leader. Thus, without reservation, I can confidently go on record today as supporting the confirmation of Judge Scalia. I hope this committee will act favorably on your nomination and act quickly on your nomination. Congratulations again.
Distinguished Senator from North Carolina.
I thank the chairman, and I want to welcome Judge Scalia to the committee. I've received a number of comments in my office with respect to your nomination by the President. The comments that I've received is that you're highly intelligent, well-prepared, congenial, and of course praise for your ability to articulate your views with respect to the legal issues that are brought before you.
I note that in your legal career that you have served in a number of capacities, including on the faculty of at least 4 law schools, that you have served in the Justice Department, as well as in the private practice of law. And of course, as a result, have come into contact with many, many attorneys from around the nation, and generally I find that you're highly regarded in the bar. In short, you're well qualified professionally, and of course we're going to have a long line of witnesses here who will be giving their views with respect to your nomination. I find that a great number of these, of course, are going to be in support of you, and in fact you have been given the highest evaluation by the American Bar Association, which has conducted a most exhaustive investigation of your background. But there will also be a parade of witnesses who will come and will disagree with you. And I found that already in looking at some of these comments that they say that you are closed-minded, and apparently they're basing that on the fact that because you are able to study the facts that come to your attention and come to a firm conclusion, that somehow you're to be faulted for coming to a conclusion. I don't agree with that assessment. I admire your professional and your academic, your personal qualifications. I think that you will bring to the court a strong voice for reason. I think that the President is making an excellent choice, and applaud that choice. Thank you very much.
Judge Scalia, when we recess, we will take you as the first witness after the recess. All the members now have made statements, so we'll go into your testimony. And we're going to recess now until 1:45. That's an hour and 15 minutes. What is that? Keep going. Come to the floor. You haven't screwed up. The committee will come to order. Judge Scalia, if you'll come around, please. Come forward. If you'll hold up your hand and be sworn, will the testimony you give in this hearing be the truth, the whole truth, and nothing but the truth? So help you God. It will. Have a seat. Would you like to introduce your family? You've got a lot of children there, and they may want to...
I would, Senator. They've taken a lot of trouble to get dressed up and come downtown. I think the little ones would probably want to leave after the first recess, but I did want to give them their moment in the limelight here, if I can remember all the names.
We'd like for those present to see them all. You have 9 children. I believe you have 8 of them here, don't you?
I think all 9 are here, Senator. I think we have a full committee. My wife, Maureen, is at the right in the front row. Next to her is Meg. Her real name is Margaret, but she said I should introduce her as Meg because when she's called Margaret, she's usually in trouble. Catherine, Christopher, Matthew, and in the next row from the other end, Mary, Ann, my oldest, Eugene, John, Paul, and that's it.
You have a good memory.
But don't try me on the ages, Senator. I'd also like to introduce, Senator, behind me, my law clerk, Patrick Schultz, who's helped me in getting together the materials I'll probably need for this hearing.
Judge, do you care to say anything before we begin questioning? Do you have an opening statement you'd like to make?
No, I don't, Senator, except to express my honor at being nominated by the President and the fact that I'm happy to be here and look forward to answering the committee's questions.
Now, I believe Senator Biden suggested we have 20 minutes for the opening round until we get around. Then if we have a second round, it'd be 10 minutes from then on. Same way we did in the relinquish hearing. Senator Grassley, did you ever make an opening statement? Sure. Thank you. Judge Scalia, there are some very obvious differences in the roles of a Circuit Court of Appeals judge and an Associate Justice of the Supreme Court. The most glaring difference, I suppose, is that the Supreme Court has the final word on what the law is. It is the final ruling in the appeals ladder and can be overruled on constitutional interpretations only by a later Supreme Court decision or by constitutional amendment. What do you view as other major differences in the role of a Circuit Court judge and an Associate Justice?
Well, I think you've correctly identified the major one, that there's no one to correct your mistakes when you're up there, except the constitutional amendment process. In a way, there's a lesser body of law to look to as a circuit judge. I accept as precedent not just the opinions of the Supreme Court, of course, but the earlier opinions of my own circuit, and accept as very persuasive the opinions of other circuits. So it's a much more vast body of law that I have to consult in order to make my decisions. At the Supreme Court level, the most persuasive precedent is just Supreme Court precedent, although to some extent lower court opinions are looked to, but it's not nearly as important. I think you put your finger on what the main difference is, and that is that at the circuit court level, the opinions of the Supreme Court are the last word, and we follow them unwaveringly. At the Supreme Court, that is not quite the situation. The Supreme Court is bound to its earlier decisions by the doctrine of stare decisis, in which I strongly believe. Other than that, I suppose it's more difficult to be sitting in a panel of 9 judges all the time. On my circuit court, we now have 11, and when we sit in bank, it's a much more ponderous group to bring to a consensus than is a panel of 3, which is the normal panel. I expect that would be quite a difference.
Judge Scalia, as we rapidly approach the 200th anniversary of the Constitution of the United States, many Americans have begun to express their views about the reasons for the amazing endurance of that great document. Would you please share with the committee any views you may have regarding the success of the Constitution and its accomplishment of being the oldest existing Constitution in the world today?
I'd be happy to. I think a lot of Americans don't realize what a
and I don't have to go into the whole history of it. Just
I won't do it. I won't do it. I think most of the questions today will probably be about that provision of the Constitution that's called the Bill of Rights, which is a very important part of it, of course. But if you had to put your finger on what's made our Constitution so enduring, I think it's the original document before the amendments were added, because the amendments by themselves don't do anything. The Russian Constitution probably has better, or at least as good, guarantees of personal freedom as our document does. What makes it work, what assures that those words are just not hollow promises, is the structure of government that the original Constitution established, the checks and balances among the 3 branches in particular, so that no one of them is able to run roughshod over the liberties of the people as those liberties are described in the Bill of Rights. If I had to put my finger on what it was that's made the difference, that's it.
Judge Scalia, under the Constitution, certain functions are reserved to the federal government and others to the states, or rather they've been delegated to the federal government and others reserved to the states. Would you describe in a general way your view of the proper relationship between federal and state law?
The proper relationship, of course, is that federal law is supreme. If the federal government acts in a field over which it has authority, state law has to step back. When that should happen, of course, is most often a question of prudence, and that means that it's most often a question for this body to decide when it wishes to displace state law and when not. When it does so, that's the end of the matter.
Judge Scalia, since the announcement of your nomination to be an Associate Justice of the Supreme Court, you have been criticized by some for decisions you have rendered regarding the First Amendment and libel. Would you please give the committee your view as to why your interpretation of the First Amendment with regard to libel led to this criticism?
Well, I have to say it must have been misunderstanding, Senator. I don't know of anything in my opinions or my writings that would display anything other than a high regard and desire to implement to the utmost the requirements of the First Amendment. As a matter of fact, Senator Moynihan mentioned this morning I'm the first academic to be nominated to the court since Frankfurter. I've spent my life in the field that the First Amendment is most designed to protect. In addition to having been a scholar and a writer as a scholar, I think I'm one of the few Supreme Court nominees that's been the editor of a magazine. So why anyone would think that I, if anything, if I were to have a skewed view of the First Amendment, Senator, it would be in just the opposite direction.
Judge Scalia, the Supreme Court's decision in Marbury versus Madison is viewed as the basis of the Supreme Court's authority to interpret the Constitution and issue decisions which are binding on both the executive and legislative branches. Do you agree that Marbury requires the President and the Congress to always adhere to the Court's interpretation of the Constitution?
Well, Marbury is, of course, one of the great pillars of American law. It's the beginning of the Supreme Court as the interpreter of the Constitution. I hesitate to answer, and indeed think I shouldn't answer, the precise question you ask. Do I agree that Marbury versus Madison means that in no instance can the either of the other branches call into question the action of the Supreme Court? As I say, Marbury versus Madison is one of the pillars of the Constitution. To the extent that you think a nominee would be so foolish or so extreme as to kick over one of the pillars of the Constitution, I suppose you shouldn't confirm him. But I don't think I should answer questions regarding any specific Supreme Court opinion, even one as fundamental as Marbury versus Madison. If you could conclude from anything I've written or anything I've said that I would ignore Marbury versus Madison, I ought to be in trouble without your asking me specifically my views of Marbury versus Madison.
Yeah. Judge Scalia, 20 years have passed since the Miranda versus Arizona decision, which defined the parameters of police conduct for interrogating suspects in custody. Since this decision, the Supreme Court has limited the scope of Miranda violations in some cases. Do you feel that the efforts and comments of top law enforcement officers throughout the country have had any effect on the Court's views? And what is your general view concerning the warnings this decision requires? Now, I want to make this statement. Any question that's asked about decisions of the court, if you prefer not to answer them, if you say so.
No, I don't think, I didn't take that
anything that
question
may come before the court, I don't want you to feel obligated to answer.
As to the second part, Senator, what do I think of those warnings? I'm happy to answer it as a policy matter, assuming the question is not, what do I think as to the extent to which those warnings in one circumstance or another are required by the Constitution. As a policy matter, I think, as far as I know, everybody thinks it's a good idea to warn a suspect of his rights as soon as is practicable. I don't know anyone that thinks it should be otherwise. As soon as the suspect is brought within the control of the police, he should have knowledge of what his rights are as a policy matter. The other part of your question, if I recall, was do I think the Supreme Court has been influenced by the views of police officers and law enforcement officials? I suppose. I don't think the Supreme Court lives in a vacuum. It reads the newspapers. I suppose it's influenced by the reaction of the society to its decisions. At least I hope it is. I think it should be. One would not know whether one's decisions are doing good or bad unless one consulted the effect of them.
Judge Scalia in 1972, the Supreme Court in Furman versus Georgia struck down the death penalty provisions in federal and state law on the basis that under the statutes the death penalty could be imposed in an arbitrary and capricious manner. In 1976, the Supreme Court in a series of cases beginning with Gregg versus Georgia held that the death penalty was constitutional when imposed under certain procedures and criteria. In the years subsequent to these decisions, the Supreme Court has reviewed many challenges to death penalty statutes. Do you feel the Supreme Court has now provided sufficient guidance in this area?
Whether it's provided sufficient guidance, I'm not sure I have the data that I'd need in order to answer that question. It's always a difficult problem. One of the hardest problems, I think, for an appellate judge is how broadly one wants to write an opinion. Certainly providing guidance is one of the purposes of an appellate opinion. So you can write an opinion very broadly, which will answer all the questions for the next 50 years, or you could write it very narrowly and just answer this particular case and let the next one come up when it does. It's a hard call as to how far you go in one direction or another. I really don't know whether the Supreme Court has been as informative as it could be or should be. I think it's, I have to say, not having been there, I'm sure they did what they thought was the best.
Judge Scalia, there are approximately 1,300 inmates under death sentences across this country. Many have been on death row now for several years as a result of the endless appeals process. Would you favor some limitation on the extensive number of post-trial appeals that allow inmates under death sentences to avoid execution for years after commission of their crimes?
Well, Senator, nobody likes frivolous appeals, I suppose, in any matter, criminal or civil. But to the extent that your question is asking about legislation, I shouldn't have a view about it. And to the extent it's asking about whether the Supreme Court ought to change its view of what the law requires to provide fewer appeals, I ultimately will have to have an opinion about it, but shouldn't set it forth here.
Judge Scalia, in the last several decades, we have seen a steady increase in the number of regulatory agencies which decide a variety of administrative cases. I realize that the scope of judicial review of these administrative cases vary from statute to statute. However, as a general rule, do you believe that there is adequate opportunity today for the appeal of administrative decisions to the federal courts, and do you believe that the standard of review for such appeals is appropriate? Again, I remind you, anything you feel that you should not answer, any matter you may feel will come before the court.
No, I don't think that will. I mean, appropriate, I assume you're saying appropriate. Congress can alter the standard of review considerably. I'm not aware of any great dissatisfaction in the administrative law community, and I think I'm fairly familiar with that community, having been a denizen of it for a number of years. I don't know that there's any great dissatisfaction with the general scope of review of administrative action that now exists, which is essentially an arbitrary or capricious standard. The fine call is for the agency, and the courts look it over to see that it hasn't been so unreasonable as to be arbitrary or capricious. As far as I know, it seems to have worked pretty well. As to whether all review, whether there is review in enough instances and there should be review in more cases or in fewer cases, that's really a call for the Congress on which I don't have any particular special views.
Judge Scalia, concern has been expressed with respect to the bureaucracy of the federal courts, the increase in clerks and support staff, and the supposed insulation of judges from personal decision-making. At the same time, the workload, the increase in complicated cases which raise technical scientific issues and other highly specialized disciplinary matters, suggests that judges and justices need more and more specialized assistance. Do you think that in addition to law clerks, the Supreme Court needs to appoint clerks or assistants with particular scientific or professional expertise, or is the solution to take certain issues involving science and other abstruse areas out of the courts altogether? Or is there some other solution?
No, I think you have them there, Senator. I personally, and I guess this is, you might get as, no, I don't think you'd get as many answers as you asked judges. Personally, I would not want a scientific expert on my staff. Institutions tend to do what you give them the capability to do. And if you give courts scientifically expert staff, they are going to become bodies that inquire into the scientific rights and wrongs of particular decisions. And simply the way our system is set up, those scientific judgments have been left to the Congress to make when it passes legislation, and to the executive to make, and to an even greater degree, by delegation from the Congress. As I said earlier, with reference to your question on the standard of review, all the courts are there for is to see whether the agency has followed the proper procedures, which is critically important, and whether in the final judgment that the agency reaches, the agency has been within the bounds of reason. I think I can tell without a scientific expert, just on the basis of the record in the case, whether it's within the bounds of reason. And I personally would not want the courts to go any further than that, or you're just duplicating the work of administrative agencies.
Judge Scalia, do you believe that the court has given sufficient consideration to relevant economic analysis in evaluating the effects of restraints of trade? And are you satisfied with the guidance that the court has provided on the proper role of economic analysis in antitrust law?
Senator, antitrust law has never been one of my fields. Indeed, in law school, I never understood it. I later found out in reading the writings of those who now do understand it that I shouldn't have understood it because it didn't make any sense then. As to whether the court has, so I really am in no position. All I can tell you is hearsay, Senator. From those who follow the field, I do understand that the rules have changed in recent years, and that the court is applying the principles and the data that economists have accumulated over the years regarding the sensible application of the antitrust laws. But I haven't had a single antitrust case since I've been on the D.C. Circuit, and I haven't complained about that either.
Judge Scalia, Chief Justice Berger, and others have complained about the poor quality of advocacy before the nation's courts, including advocacy before the Supreme Court. Do you feel that legal representation is poor? And if so, what, in your opinion, should be done to improve the quality of this representation?
Senator, I can only speak for my own court, and before my court, it's excellent. I can't speak highly enough about the bar that practices before me. I think an enormous proportion of highly competent lawyers who do fine work not only for their client but for the court in informing us of the issues of law that we have to decide. On the basis of what I see before my court, which is maybe not a typical court, the advocacy is good.
The distinguished senator from Massachusetts.
Thank you, Mr. Chairman. Our ranking member, Senator Biden, is currently on the floor with the introduction of legislation dealing with drug regulation, and he'll be over here very shortly, but I'll proceed if I might. Judge Scalia, if you are confirmed, do you expect to overrule the Roe versus Wade?
Excuse me?
Do you expect to overrule the Roe versus Wade Supreme Court decision if you're confirmed?
Senator, I don't think it would be proper for me to answer that question.
I agree with you. I don't think it's proper to ask any question that he's got to act on or may have to act on.
I mean, if I may say why, I'm going to, let's assume that I have people arguing before me to do it or not to do it. I think it's quite a thing to be arguing to somebody whom you know has made a representation in the course of his confirmation hearings, and that is by way of condition to his being confirmed that he will do this or will do that. I think I would be in a very bad position to adjudicate the case without being accused of having a less than impartial view of the matter.
There have been at least some reports that that was at least one of the considerations in your nomination. A lot of other clearly strengths which you bring to your own qualifications, but I'm interested in what precedents you put on the fact of that decision being on the law books. How I'm interested in your own concept in the stare decisis. Do you believe in it? What is it going to take to overrule existing Supreme Court decision?
As you know, Senator, they are sometimes overruled.
I'm interested in your view.
My view is that they are sometimes overruled, and I think that.
But what weight do you give them?
I will not say that I will never overrule prior Supreme Court precedent. I think that's.
What weight do you give the precedents, Supreme Court? I mean, are they given any weight? Are they given some weight? Are they given a lot of weight? Or does it depend upon your view? Which
doesn't depend on my view. It depends upon the nature of the precedent, the nature of the issue. Let's assume that somebody runs in from Princeton University, and on the basis of the latest historical researches, they have discovered a lost document that shows it was never intended that the Supreme Court should have the authority to declare a statute unconstitutional. I would not necessarily reverse Marbury versus Madison on the basis of something like that. To some extent, government, even at the Supreme Court level, is a practical enterprise. There are some things that are done, and when they're done and you move on. Now, which of those you think are so woven into the fabric of law that mistakes made are too late to correct, and which aren't, that's a difficult question to answer. It can only be answered in the context of a particular case, and I don't think that I should answer anything in the context of a particular case.
Well, do I understand that your answer with regard to Supreme Court decisions is that some of them are more powerful or more significant than others in terms of their how you would view in overruling them or overturning them?
Yes, I think so, Senator. May I supplement
And you're not prepared to say on this issue where that decision comes out, as I understand.
That's right, Senator. And maybe I can be a little more forthcoming in response to your first question. As you followed it up, you said that, some thought that that's why I was going on to the court or something like that. I assure you, I have no agenda. I am not going on to the court with a list of things that I want to do. My only agenda is to be a good judge. I decide the cases brought before me, and I try to decide them according to the law as I can best figure it out. But it's not a programmatic matter as far as I'm concerned.
Well, that's part of this whole process, giving you an opportunity to speak to those questions, but it also is a part of this process to find out what kind of relevancy you give to previous court decisions and how significant they are in terms of your own legal experience and when they might be overturned or when they might not be. And as I gather from your answer, that's kind of a variable, that some have a stronger standing than others, and that's your view. But in terms of that particular view, you're not prepared to indicate, at least in that case, in the Roe versus Wade case, where you come out as to whether You feel that that is a strong precedent or a weak precedent, but evidently you believe that some precedents are weaker and some are stronger, and the
That's
doctrine
right,
of
sir.
stare decisis.
And nobody arguing that case before me should think that he's arguing to somebody who has his mind made up either way.
Well, then what is the relevancy of the previous decision? Does that have any weight in your mind?
Of course.
Well,
I
you
mean,
can tell us how much? Or?
That's the question you asked earlier, Senator, and that's
Well, I
precisely
know
the
it.
question I do too.
Depends on the case, doesn't it?
Well, let me go to another kind of question about that you talked about overruling precedents, and that evidently some have a greater weight than others. I think all of us certainly here are familiar with the decision by the court of the Graham-Rudman case. We're also less familiar, but increasingly more familiar, of the decision in the district court. Some have suggested that you might have been the author of the opinion. Whatever that might be, there's a clear indication about questioning the roles of the independent agencies and the allocation of certain executive powers to those independent agencies. This was, I think, probably decided 1935 as to uphold their constitutionality, and I think maybe you want to comment whether this decision in the district court, how it really fits into that particular holding about the allocations and the authority of the independent agencies.
I don't think it affects it at all, Senator. The three-judge district court decision in Sinar decided the case on the assumption that that the decision in Humphrey's executor permitted the prohibition by Congress of presidential removal except for cause. It was done on that assumption.
Well, there'll I think be an opportunity, I think, at greater length to go into that particular decision and to try and draw out what the courts are really saying about the continued strength of the independent agencies in terms of their constitutional standing.
Senator,
okay.
Before that happens, let me tell you a problem I have of discussing it even generally, not in the context of a particular Supreme Court. We have pending, not in the Supreme Court, but before the court that I'm now sitting on, so that it'll be a problem for me whether I'm confirmed by this by the Senate or not. We have pending before us a suit challenging precisely the constitutionality of the restrictions on removal of the members of the Federal Trade Commission.
Right.
So I am very much constrained about
well,
speaking.
Let me we'll back up a little bit because I'm more interested in your approach to these issues. We have seen very strenuous action in the Congress over the period of 30 or 50 years in terms of creating a safe workplace for the American worker. The Congress addressed the whole abuses in the child labor laws. We've tried to address the issues in terms of sweatshops, other areas where there's been very significant exploitation of the American worker. One of the newer areas where the Congress has addressed is on the issue of occupational health and safety. This is an area which the Congress has spoken very clearly. Nonetheless, the complexity, very few of us in the Senate, I don't think any now, we did have some, are doctors. These are complex issues. And if it's the decision of the Congress and the Senate that these kinds of decisions are going to be relinquished to an independent agency to attempt to provide for what is a congressional responsibility in terms of the protection of the workplace, and that we are going to give that function to an agency that will draft various rules and regulations. I'm interested in how troubled you are about it, because I have reference to an article that you wrote on note on the benzene case, in which Judge Rehnquist had a dissenting comment, in which you also expressed a view which I would think if it became a majority position, certainly with regards to the occupational health and safety division, would probably mean that that particular agency would be effectively eliminated. I'm interested in your comments, whether I'm
You're
correctly-
asking now not about removal power, but about
Yes.
excessive delegation.
Exactly. And if I could just add to that, one of the points that you raise is the question of vagueness in terms of the drafting of various statutes. I would just interested as a legislator trying to find out where we're going, quite frankly, with you, Mr. Justice, would also, as someone who spent a good deal of time, know that certain language has to be vague in order to permit decisions by, say, medical personnel to be able to draft certain flexibility. Hopefully they're not vague, but they provide a degree of flexibility in order to get the job done. And I'm just wondering what message we ought to have in terms of the future if we're going to run into problems on this.
Well, again, I'm reluctant to talk about what Scalia will say in the future. I can talk about what he said in the past, and I think you have me on the wrong side on the matter of
help me out
of broad delegation. The fact is, in the Sinar case that we were discussing earlier, the principal attack on the legislation was that it was unconstitutional because of the excessiveness of the delegation, and the three-judge district court on which I sat rejected that argument. Did not sustain it. The article that you have there, which is an article from Regulation Magazine that I used to be editor of at one period, I think you read it incorrectly if you view it as an attack on the constitutionality of broad delegation. To the contrary, I think if I recollect the article you're referring to correctly, it displayed quite the opposite view, the view that it's very difficult for the courts to say how much delegation is too much. It's a very, very difficult question, and I think it expressed the view that in most cases the courts are just going to have to leave that constitutional issue to be resolved by the Congress. Congress has an obligation to follow the Constitution as well.
Well, would I be correct in saying that you would support, then, a broad congressional mandate in these areas?
I would support a broad congressional mandate that is not unconstitutionally overbroad. Yes.
Go around and around.
That's all I can say.
The point that
no, but seriously, I'm not trying to go round and round. I think I am accurate in saying that my writings do not show that I am likely to be more restrictive on that matter than others.
it may I may not assume correctly that in reviewing some of these cases and the articles that you require a degree of specificity in terms of the legislation. And an opinion that you're not going to breathe the life into the words or language of various acts. And there's a whole series of different references I could read. I don't want to take the time. That's what I'm concerned about. Obviously, and I'm interested in whatever response you can give. You know the point I'm driving at. We don't want unconstitutional delegation, but I'm talking about specificity and in areas which I think the Congress has acted in terms of the protection of the elderly, in terms of the protection of health and safety, in a whole wide range of areas of protections in health and safety. And I'm just interested in how not only the constitutional question of the allocation of powers, but also the specificity that you require in order to permit these to be upheld.
Senator, I think you have me wrong. I have criticized, and I think I've often said in my writings and in my speeches that Congress should be more specific, that the more specific Congress can be, the more democratic the judgment is, because if Congress isn't specific, the judgment is made by the courts, and the courts are not democratic institutions. So I have criticized what seemed to me as a policy matter, the overgenerality of the statutes. But the reason I've criticized them is precisely because, even though they are overgeneral, they will, by and large, be upheld and implemented by the courts, and the courts will determine what they mean. I don't think that that is ordinarily the better way to do it, to the extent that Congress has the time, and I know that's a problem. The import of my earlier writings was that Congress ought to try to be more specific, but that does not speak, Senator, to whether, if it chooses not to be more specific, the law will be unconstitutional.
Okay, that's helpful. In an earlier response to the chairman's questions on the free speech, on the Ullman versus Evans, in your dissent, your conservative colleague, Judge Bork, evidently criticized your dissent, noting that you were, I think he mentioned, abdicating your judicial function by your crab view of free speech. How do you respond to Judge Bork?
Oh, I guess I would respond that my dissent was joined by my liberal colleagues, Judge Wald and Judge Edwards. I'll leave it there.
That's enough for Judge Bork. You had an area that this committee is interested in, and that's a question of executive privilege, being able to obtain certain documents. I noticed in your exchange with Senator Muskie, you're talking about this time, they were talking about the Nixon case. And in Senator Muskie concluded in his question, and in your judgment, the right of the Congress to military and diplomatic secrets stand at a lower level than the right of the President to withhold those secrets was a question. You said, no, sir. And then you continued along. I don't mean to denigrate the congressional, I'll include it all in the record, Mr. Chairman, if I may. Got a statement. I don't mean to denigrate the congressional power. They both, the Congress and the executive, have the right to assert their prerogatives. When it comes to an impasse, the Congress has means at its disposal to have its will prevail. The means are indicated in my testimony. The most effective is the withholding of funds from the executive. The refusal to confirm presidential nominees was also used several times under President Nixon, if I recall, to elicit information which had been previously denied. The Senate simply would not confirm nominees until the information was turned over. I'm wondering if you still
Did I say
affirm that wonderful judicious statement and comment that is based upon all these excellent reviews that have been given to you. I imagine you still want to hold to that.
It's true, Senator. How can I withdraw from it?
I don't know whether I should ask you whether you want to expand on that or not, or whether
it's one of the means that the Congress has at its disposal.
In another area, Judge Scalia, this is on the questions of national security and individual rights. We have gone through a rather important period in past history in the early 70s, where we were trying to balance national security interests against the First Amendment. And we've seen recent histories taught us to scrutinize the claims of the executive branch when inhibiting the possibility of inhibiting free speech and association of press and right of dissent under the names of national security. And I just was interested in hearing your own attitude, how you as an individual view the role, whether you view the role as an umpire in our federal system, whether the competing First Amendment and between First Amendment and national security claims, or are you going to give the complete basic and overwhelming presumption to those who make the claim, or are you going to examine in some detail the background for such a claim, or how you'll approach the issue generally?
Well, I will certainly approach it with an awareness of the importance of both of the elements that are in contention there. The First Amendment is of enormous importance, the ability of the people to speak, to learn, and on the other hand, the national security is often national security interest is often of great importance. That's the worst problem about being a judge. It's never something on one side. I mean, you can be criticized for coming out against the First Amendment, and one never hears what's on the other side of that case. There is always some important interest on the other side, or it would not be a case. I can't be any more specific in response to your question, except to say that I'm seriously interested in both of the principles, both of the concerns that arise in those cases. I am aware of the importance of the First Amendment and will give it the full weight that the Constitution accords it.
The reason I bring that up is because when it was alleged and charged for national security reasons, we found the gross abuse of all these individual rights and free assembly during another period, the early period of the 1970s, where we had extensive unauthorized, unconstitutional wiretapping, mass surveillance, and questions of First Amendment rights. I hear my time is up. I thank you. In fact, thank you, Mr. Chairman.
Thank you. Thank you. Mr. Senator from Maryland.
Thank you, Mr. Chairman. Judge Scalia, as you well know, one of the special qualities that a judge must have is the ability to put aside very deeply felt personal beliefs in order to apply the law and the Constitution fairly and equitably to every litigant who stands before him. Your exchange with Senator Kennedy on the subject of Roe versus Wade suggests an area where you have written, and I'm not trying now to lead you down the pathways of the future, we'll look down the road of the past. But you've written on the subject of Roe versus Wade, and while I don't pretend to be an expert on every word you've written, I believe you have expressed doubts about that decision both on moral grounds as well as on jurisprudence. Is that correct?
I'm not sure. I'm not sure the latter's true, Senator. I think I may have criticized the decision, but I don't recall passing moral judgment on the issue. But I agree with your opening statement that one of the primary qualifications for a judge is to set aside personal views.
However it may be with your article on Roe versus Wade, the problem remains. What does a judge do about a very deeply held personal position, personal moral conviction, which may be pertinent to a matter before the court?
Well, Senator, one of the moral obligations that a judge has is the obligation to live in a democratic society and to be bound by the determinations of that democratic society. If he feels that he can't be, then he shouldn't be sitting as a judge. There are doubtless laws on the books, apart from abortion, that I might not agree with, that I might think are misguided, perhaps some that I might even think in the largest sense are immoral in the results that they produce. In no way would I let that influence my determination of how they apply. And if indeed I felt that I could not separate my repugnance for the law from my impartial judgment of what the Constitution permits the society to do, I would recuse myself from the case.
I had a similar conversation with Judge Noonan of the Ninth Circuit at the time he was before this committee for confirmation. And he has very strong feelings on the abortion question. But he came out about the position that you've just expressed, that it would be necessary, if not desirable, for him to recuse himself on cases that touched so closely on that issue in which he had been an advocate and a strong spokesman working in that field.
That's not quite what I've said, Senator. I didn't say that I would recuse myself in the
Well, that's where
program.
I'm wanted to
Yes.
press you to. How would you deal with the problem?
I don't know what Judge Noonan told you. Judge Noonan had indeed written considerably in the field and had been one of the leading advocates.
He was a strong activist,
Yes,
and was affiliated with a number of activist organizations.
I don't think I fall into that category.
Under what circumstances would you think a judge who had not had that kind of a background should recuse himself?
Only where he himself is personally convinced that he cannot decide the question impartially because he feels so strongly about the morality of the issue. And it's not at all unusual for justices to have to confront such cases. United States versus Reynolds, for example, which held that it was constitutional for a state to prohibit bigamy. Now, that was certainly a moral issue, the issue of monogamy for the justices sitting on that case. They obviously, at least many of them, must have had religious views about the matter, and they did not feel it necessary, those that had those views, to disqualify themselves. And I don't think that any judge has to, unless he or she is personally convinced that the issue has so beclouded his or her judgment that the Constitution would not be applied impartially. I don't intend to disqualify myself except where that's the case, as far as the type of question you ask about is concerned.
The way you put it in when you were with us in 1982 was this: I would disqualify myself in any case in which I believe my connection with one of the litigants or any other circumstances would cause my judgment to be distorted in favor of one of the parties. I would further disqualify myself if a situation arose in which, even though my judgment would not be distorted, a reasonable person would believe that my judgment would be distorted. That does not mean anyone in the world, but a reasonable person.
That's right.
Is that the position that you will carry with you from the Court of Appeals to the Supreme Court?
Yes, it is, Senator. And what I'm further saying is that I don't think that reasonable people think that the moral views that judges may hold on one piece of legislation or one decision or another so automatically beclouds their judgment that they must disqualify themselves. I don't think that the records of the Supreme Court could possibly be read to establish that as the basis of disqualification. On bigamy, on capital punishment, on an enormous number of things, the men and women on the court have had strong moral views, doubtless, and have sat nonetheless.
Now, you very carefully, and I think properly, limited this problem by saying that does not mean anybody in the world but a reasonable person. But if a reasonable litigant actually believed that your judgment would be distorted because of some strong personal bias or belief, would that dissuade you from sitting on a case?
USC Section 455, any justice, judge, or magistrate of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned.
Turning to the matter of precedents, as a member of the Court of Appeals, you are bound by the precedents established by the Supreme Court. But you will very soon be in a position to change the precedents, to overturn them. So your view of the value of precedents is important. Justice Rehnquist last week, or as a matter of fact, it was during his first confirmation hearing, he said that a precedent might be less authoritative if it is stood for a shorter period of time, or if it was the decision of a sharply divided court, and he reiterated that view last week. Would you agree with that general sentiment?
Well, I think the length of time is doubtless a considerably important factor. The Marbury versus Madison example that I gave in response to Senator Kennedy. I'm not sure I agree with Justice Rehnquist that the closeness of the prior decision makes that much difference. I mean, if Marbury versus Madison had been 5-4, I'm not sure I'd reverse it today. I think the statute reads that way, Senator. I have the statute somewhere. I'm quite sure that the way you put it is about the way the statute reads, requiring disqualification, if I may. 28 U.S.C. Section 455, any justice, judge, or magistrate of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned.
Turning to the matter of precedents, as a member of the Court of Appeals, you are bound by the precedents established by the Supreme Court. But you will very soon be in a position to change the precedents, to overturn them. So your view of the value of precedents is important. Justice Rehnquist last week, or as a matter of fact, it was during his first confirmation hearing, he said that a precedent might be less authoritative if it is stood for a shorter period of time or if it was the decision of a sharply divided court. And he reiterated that view last week. Would you agree with that general sentiment?
Well, I think the length of time is doubtless a considerably important factor. The Marbury versus Madison example that I gave in response to Senator Kennedy. I'm not sure I agree with Justice Rehnquist that the closeness of the prior decision makes that much difference. I mean, if Marbury versus Madison had been 5-4, I'm not sure I'd reverse it today. But I can understand how some judges might consider that that's an appropriate factor as well. I agree. I certainly agree with the former. The latter wouldn't have occurred to me, but maybe.
One area of law that has produced shifting majorities and some very sharp dissent is affirmative action. Some commentators have noted that after some years of ferment, the court is reaching a consensus. One of those observers is Justice O'Connor. She wrote in a concurring opinion in Wygant versus Jackson Board of Education that the court is in agreement that remedying past or present racial discrimination by a state actor is a sufficiently weighty state interest to warrant the remedial use of a carefully constructed affirmative action program. The court has forged a degree of unanimity. It is agreed that a plan need not be limited to the remedying of specific instances of identified discrimination for it to be deemed sufficiently narrowly tailored or substantially related to the correction of prior discrimination. Now, do you think it's a fair observation that the court's affirmative action decisions represent a fair measure of consensus or a degree of unanimity, so that an affirmative action program that benefits persons other than the identified victims of discrimination is permissible under the Constitution?
Senator, I really don't think I should give my view, and you're talking about an area in which it's a sure thing that they're going to be a lot more. The one thing you can say for sure about the Supreme Court decisions is that they haven't answered all the questions. There's doubtless going to be a lot more litigation in that field, and I don't think that I should commit myself here to a point of view. If that is Justice O'Connor's position and the position of a majority of the court, that does not prove that it will not be argued to the contrary. And I've spoken my piece about stare decisis, but stare decisis is quite different from committing myself to a view before the committee that is responsible for confirming me to the court.
Does the kind of consensus that Justice O'Connor mentions have any precedental value in your view?
Oh, I don't think it all has to be in a single majority opinion. I mean, if you have 3 separate opinions that add up to 5 justices for a particular principle of law, that principle of law has been found in that case.
The chairman raised the subject of the death penalty. I suspect that you have had a minimum number of the petitions on your current court from the prisoners on death row.
Very few, Senator, because we do not have a federal prison within our jurisdiction. It's over in the Fourth Circuit.
Of course, in the other circuits, these petitions are very frequent, and the Supreme Court is constantly confronted with these petitions. And it's been a controversial area of court activity, been criticized on procedural grounds. On the one hand, the death row petitioner usually arrives at the Supreme Court at the end of, as the chairman has suggested, the end of a very long and tortuous road of appeals and collateral attacks and every kind of procedural gambit that can be imagined. And there's a pressure of every sort to decide the petition very quickly and to bring finality to the case, even if it requires summary action. On the other hand, because the penalty is irrevocable, the argument is made that each one of the petitions should be very carefully examined and weighed and the execution date stayed until there has been full consideration. Have you had an opportunity to consider how these competing pressures ought to be balanced? How much process is due to the death row inmate whose petition arrives at the Supreme Court just on the very eve of the day of execution?
Senator, to tell you the truth, that is a subject I really have not given thought to, and it's scary, isn't it? I don't know. I think that must be a very hard call. Can't imagine a more important issue, and you've painted the considerations on the other side. All I can say is I'll do my best.
Well, I think it must be one of the most difficult issues to face any public official, whether it's a governor who has a death warrant presented for his signature, or whether it's a judge giving signing the final order. But it's one area of responsibility that I will not be envying.
No, I don't look forward to that as the most enjoyable part of the job, Senator.
In recent years, the court has very rarely spoken with a single voice in major cases. There have been a proliferation of individual opinions, concurring opinions, dissenting opinions, separate opinions by justices. And many of the cases that address very crucial issues are decided by a patchwork of opinions. The result has some unfortunate aspects. The value of the decisions of the Supreme Court as precedent is diminished, and litigants can be confused about what the law really is, or they may be encouraged to make a second try to get a clearer or more favorable sort of result. Secondly, there is a concern about the effect of these increasingly sharp public disagreements on the collegiality of the court. As a circuit judge, have you found that the proliferation of independent individual opinions on the part of the Supreme Court has impeded the ability of either lawyers or judges to glean the reasoning to support a particular decision?
Oh, unquestionably, Senator. I don't think there's any doubt about that, including in some very important and difficult areas. I guess the case that comes immediately to mind is the Bakke case on affirmative action, where what is said to be the holding of the court is really the holding of the opinion of only one of the justices, Justice Powell, because there were three opinions, one for four of the justices, Justice Powell, and one for the other four, and the four that Justice Powell joined became the majority, so his opinion is quoted as the opinion of the court. It makes for a very confusing situation. I don't know what the solution is, except self-restraint, I suppose. I have not been notable for writing separately on the court that I sit in. Notable for the quantity, I hope to mean. As you know, other systems get along without it entirely. The European system typically has an unsigned opinion for the entire court, and you either win over the majority to your view, or your view does not appear. One can run a system that way, but that's not in keeping with the rugged individualism of the common law judge, which is a quality I think we want to retain. So I do think you need to leave room for dissents and concurrences. All I can say is it takes some self-restraint, and I hope to bring it to bear.
Well, I don't know that this institution, that the members of the Senate are in any position to criticize verbosity on the part of others, but I see my time has expired.
Distinguished ranking member.
Thank you, Mr. Chairman. I apologize, Judge. I was on the floor with the introduction of another bill regarding the drug problem, and I'm sorry to not have heard your original statements. I want to pursue several areas. I will not be able to get them done in one round, but it won't be too many. Let's start, if you will, with I have read all the speeches that I could find that you've written, and I find a very interesting, and I mean that sincerely, analysis of the newly enunciated doctrine of original intent. And from your speech, the speeches that I've written, I can't tell, and I'm not being smart when I say this, whether your analysis of your view of original meaning was one you meant, or whether it was done with tongue-in-cheek, or because you start off the speech in which you enunciate your doctrine as saying, when I was in law teaching, I was fond of doing what is called teaching against the class. That is, taking positions that the students were almost certain to disagree with in order to generate some discussion, if not productive thought. I have tended to take a similar contrary approach in public talks. It is neither any fun nor any use preaching to the choir. And then you go on and
I'm trying to fight against that here, Senator Mike. I'm trying to fight against that inclination here.
Well, let yourself go. Because it's pretty boring so far. And it may be more interesting, and we may get a chance to see who you are a little bit more. I'm not suggesting that you are attempting to hide behind the argument that many use, which is that may come before the court, therefore I can never discuss it. Everything may come before the court. There is nothing in American public life that may not come before the court. Nothing. Therefore, if you applied that across the board, you wouldn't be able to speak to anything. But let's speak to what your speech is, not to your cases. I'm going to want to go to your cases and freedom of speech issues next, but let's start off with this, if we could. There's been a lot of debate recently involving several members of the court, as well as Attorney General Meese, about the so-called original intent doctrine. In fact, in a recent speech, the Attorney General's Conference on Economic Freedoms, you offered some view on the subject and suggest the doctrine would be better understood as that of, quote, original meaning, end of quote, rather than original intent. Would you tell us what you mean by original meaning as a means by which a judge should interpret the Constitution?
Yes, I'll be happy to, but you ought to begin by noting that in that speech I did not advocate the original intent doctrine. I just said that it should be known as the original meaning doctrine.
Well, that's what I'm trying to figure
yes,
out.
well,
Where
I'll
we
be
the
happy to
devil's
explain what the,
advocate?
yeah.
Let me back up. Why don't you tell us how you view interpretation of the Constitution? Are you do you view it as a living Constitution, to use that quote term of art? Do you view it as having to look to the original meaning, the original intent? Who are you, Judge Scalia?
That's a good question, Senator. I am embarrassed to say this. I'm 50 years old, grown up and everything. I cannot say that I have a fully framed omnibus view of the Constitution. Now, there are those who do, who have written pieces on constitutional interpretation, and here's the matrix, and here's how you do it. I think it's fair to say that you would not regard me as someone who would be likely to use the phrase living Constitution. On the other hand, I'm not sure you can say that he is pure and simply an original meaning, or I'll be happy to explain the difference between original meaning and original intent.
I just want to know what you think.
It's not worth it. It's not a big difference.
Well, what do you think?
What I think is that the Constitution is obviously not meant to be evolvable so easily that, in effect, a court of nine judges can treat it as though it's a bring along with me statute and fill it up with whatever content the current times seem to require. To a large degree, it is intended to be an insulation against the current times, against the passions of the moment that may cause individual liberties to be disregarded, and it has served that function valuably very often. So I would never use the word the phrase living Constitution. Now, there is within that phrase, however, the notion that a certain amount of development of constitutional doctrine occurs, and I think there is room for that. I frankly, the strict original intentist, I think, would say that even such a clause as the cruel and unusual punishment clause would have to mean precisely the same thing today that it meant in 1789.
You said it would have to mean that?
Yes, so that if lashing was fine then, lashing would be fine now. I'm not sure I agree with that. I think that there are...
Addressing this problem for me, Congress is presently considering legislation to create, on a trial basis, an inter-circuit panel to resolve the conflicts between the various circuit courts. How do you feel about that?
Well, let me give you the Court of Appeals judge's point of view again. The immediate effect of it, of course, is to render judges who are now sitting on the second highest court in the land judges sitting in the third highest court in the land. That's not likely to make.
How do you feel about it, Judge Scalia?
As a policy matter,
Yes,
for the country.
You think it has merits, or you think it's not necessary, or what?
I think it's terrible, and the only question is whether the alternative is more terrible. I don't think anybody is happy about having a four-level court structure. It's more cumbersome. It's more expensive for the litigants.
Unless the case was made that it was necessary, you don't think you ought to do it.
I think that's so, but I don't think that's telling you anything that's very useful. I think everybody.
There has been some debate here as to whether or not those judges should be taken from the various circuits, or they should be appointed by the Supreme Court, or even one suggestion was made in the markup that they be appointed by the President, confirmed by the Senate. Do you have an opinion of what you think would be best for that inter-circuit panel, if indeed it was established, where the judges come from?
Certainly, if it's to be made a permanent thing, it seems to me you should do it right and have the appointments made the way Article III judges are normally appointed to courts, appointment by the President to that court, a nomination by the President to that court, advice and consent of the
How
Senate.
about on a trial basis, which is the way the legislation did pass the Judiciary Committee? Do you have an opinion? I'm only looking for something to help.
Yeah, I don't know. I think it's a close call, whether on
You're
a
on the
trial,
bench.
on a trial basis, a quick and dirty trial, you want to do it on some different basis. I could see doing it that way temporarily.
Judge, I've been interested in formulating some way of constitutional provision for judicial discipline, short of impeachment. And the Congress did pass the Judicial Discipline and Tenure Act several years ago, and it was to, various circuit courts were to set up a procedure for this. And I knew once, but I've forgotten. Do you know if the D.C. Circuit Court has set up such a procedure?
Oh, yes. I think all the courts have a circuit council now that implements the act.
And do you know the experience of that at all? Has there been many complaints, or?
Yes, I think complaints are many. No, I wouldn't say many, but there are complaints, and the complaints are processed. I'm not sure that the fact that the procedure is not very visible to you or to anyone else means that the procedure is not working. It's working, and maybe the fact that it's working well simply stops many of these things from coming to public attention when they otherwise would.
Do you know that there has been complaints filed and some action taken on them?
Yes, I do.
Do you know if there's been any discipline? I'm not going to ask you who or what, but do you know if there ever been any discipline discussions relating to your circuit or any other circuit?
I don't know, Senator. Oh, I'm sure if you say my circuit or any other circuits, I'm sure there have been.
Well, I'm not aware of any, and I just wonder through the grapevine of the Judiciary Conference, what have you, if you knew of any, and I'm not going to ask you to be specific, or if you did know of any disciplinary actions that have been taken as a result of that.
Well, I think there was one in our circuit.
Thank
as
you.
a matter of fact, at least one.
Many critics of the so-called bureaucracy have been strangely silent, it seems to me, for the last few years. It's almost as if the criticism might have been motivated out of politics. That never happens in this town, we know that. I'm interested to read Regulation Magazine, AEI Magazine, your advice to the President concerning the bureaucracy, and you wrote, quote, "Replacing their bureaucracy with our bureaucracy does not solve the underlying difficulty. The point is that no bureaucracy should be making basic social judgments. It is perverse to delight in our ability to change the law without changing, to change the law without changing the law," end of your quote. What do you think can be done legislatively as an opinion, and what can be done judiciously to rein in the bureaucracy?
Well, let me begin by saying I have never been a bad-mouther of the bureaucracy. Most of the people I've known in the government, and I've worked in the executive branch in 3 different positions, most of them are good, hard-working, talented, dedicated people, and trying not to pervert the law, but to the contrary, to implement it. The problem I was addressing there was simply the fact, the same point I was discussing with Senator Kennedy earlier, as a matter of fact, is the problem of excessive delegation. Too many of the basic judgments are simply not made in the statute. They are left to be made by the agency that implements it. To the extent that can be avoided, that's the way to go. Otherwise, when you change an administration without any vote to change the law, suddenly the same law is being administered in a different direction, and that swing can be more or less extreme depending upon how specific the statute
Does
itself.
the judiciary play any role in that?
Yes, I think the judiciary stops the swing from going beyond the bounds of the reasonable. But when it's drawn with sufficient vagueness, even the reasonable swing is a pretty broad one. I'm sure Congress is aware of the problem. It's a hard one to get a hold on, that's all.
Thank you. Thank you, Judge. Thank you, Mr. Chairman.
After Senator Grassley, we'll take a 10-minute recess. Distinguished Senator from Iowa.
Thank you, Mr. Chairman. It's my understanding that much of the work of the D.C. Circuit involves regulatory agency cases and administrative law, and you've obviously thought and written a great deal about those issues, and I think it's fair to suggest that if confirmed that you're going to play a special role in future Supreme Court cases in those areas. I'm interested in the area of administrative law from my chairmanship of a subcommittee here of this committee. Now, I understand you to be an outspoken opponent of the legislative veto. You've criticized Congress for, and these are your words, passing laws with strings attached. Now, I personally disagree with your view because I'm opposed to the tremendous amount of legislating done by faceless bureaucrats who aren't elected by anyone. So I'd like to explore the subject of the legislative veto. What if Congress enacts legislative veto legislation that satisfies, one, bicameral passage, and two, the presentment requirements set out in the Constitution? Isn't that about all that's constitutionally required?
Those are the only two problems that were raised against the type of veto that was struck down in Chadha. And I suppose if those two requirements, if those two problems were overcome, the problem would be eliminated, but I'm not sure you'd still call it a legislative veto.
Well, that would then be following upon writings that you've done in the Administrative Law Review Article 1976, the Regulation Magazine, February 81, Regulation Magazine, December 79, in which you cite only those two constitutional imperfections. So your view today then is similar to what you had previously written.
Well, what matters today is not my view of what I previously wrote, but what the Supreme Court subsequently decided. That is, subsequent to what I previously wrote, the Chadha case.
Well, assume again that...
I think you're presenting to me a situation in which the two defects discussed or identified in Chadha were eliminated. On the basis of Chadha...
assume again that a legislative veto statute then would meet the Chadha test. Don't you agree that a legislative veto serves a virtue in today's age when it's so difficult for Congress to legislate policy statute by statute against a backdrop that we find ourselves in here of constantly changing issues?
Senator, as I told Senator Kennedy, one of the things I've always been concerned about, and my writings show it, is the problem of excessive delegation by Congress to the agencies. It's an awfully hard problem to deal with. To the extent that there is a device that will enable Congress to review more closely the activities of the agency, that is desirable. If there is some way to get proper legislative attention to what the agencies have done by way of implementing earlier statutes.
Yeah. Well, you accept the environment and decide within that environment. I hope that Congress reacts, that we can't anticipate crises, and that I hope you accept that it's unreasonable to expect Congress to do otherwise, and then accept the fact that that's why Congress delegates authority to agency expertise.
No, I understand. I think that's right.
Okay. I think we'd all agree with the Constitution lasting 200 years now, and hopefully for another 200 years, that we have found our founding fathers to be very practical people. I have a hunch that given the range of agencies that we now have today, whether it be FERC or the FCC or the Consumer Product Safety Commission, and you can go on and on, which of course they, writing 200 years ago, could have never dreamed of, that they might find the veto a fair and practical way to deal with the bureaucracy today. Do you disagree with that?
It's conceivable that that had they envisioned the kind of a system that would develop, they would have made provision in the Constitution for a legislative veto. Although, as the Supreme Court has said, they didn't. That's what the Supreme Court has said to date.
Well, what the Supreme Court said to date is what Congress passed for a legislative veto up until Chadha, that those forms of legislative veto were unconstitutional. You're said to be a free market advocate who favors economic deregulation, and I made reference to the fact that you'd written for Regulation magazine, and you said you had edited it, and that's kind of a gospel of deregulation. I'm not going to ask you to comment on any specific regulation, but can you give me some indication of what factors you consider when faced with a constitutional challenge to economic regulation?
10 minutes.
I don't recall that I've been confronted with a constitutional challenge to economic regulation during the entire time I've sat on the court I'm now sitting on. Frankly, constitutional challenges to economic regulation are pretty rare nowadays. Most of the challenges are on the basis of whether the statute permitted the economic regulation in question. I really wouldn't even know where to begin to grapple with the question you asked. It's I think I'm not sure that I am sure that the experience of my circuit is not different from the experience of most circuits. It's very rare that economic regulation nowadays is challenged on constitutional grounds.
Well, along that, I'll accept
Equal
that.
protection challenges have just not fared very well in the last half century anyway, and that would be the normal source of attack. And
Well, must the regulation be more than simply wrong-headed for it to be overturned? And
oh, absolutely. Yes. It'd have to be more than, and the agency's action would have to be more than wrong-headed to be overturned on statutory grounds as well. It can be reasonably wrong-headed, and we'll approve it.
in a case decided last year, Hershey versus FERC, and that was involving the Equal Access to Justice Act, you took the occasion to comment on what role legislative history and committee reports should play in judicial interpretation. And I hope it's fair for me to conclude that you showed a great deal of hostility towards committee reports in that writing. You wrote in a concurring opinion, and I quote, "I think it's time for courts to become concerned about the fact that routine deference to the detail of committee reports and the predictable expansion in detail which routine deference has produced are converting a system of judicial construction into a system of committee staff prescription." Now, that's pretty doggone strong language. Let me first ask, how important is legislative history to you?
I think it's a significant factor in interpreting a statute. I've used it in my opinions.
Well, let me ask you, how come you don't repeat the usual answer that we get, that, you know, if you do refer to it, if the statute, the language of the statute itself isn't clear to the judges interpreting?
Well, I guess I didn't repeat that because
obvious?
It's so obvious, and
But you accept the obvious.
number one, it's so obvious, and number two, because we normally don't have a lawsuit in front of us if the language of the statute is clear. Almost invariably, the language of the statute is argued to mean one thing by one side, another thing by another side, and where that's the case, legislative history.
Are you going to be then turning to the legislative history then that frequently, as you say, that the statute is hardly ever clear?
I will use what seems to me reliable legislative history when it's available to be used. The trouble in legislative history, Senator, is figuring out what's reliable and what isn't reliable. That's the trouble with it.
Well, I want to tell you, as one who served in Congress for 12 years, legislative history is very important to those of us here who want further detailed expression of that legislative intent. You're not suggesting that for committee reports to have any meaning, that they must be actually written rather than merely approved by members of Congress? Are you suggesting that?
Well, I don't want to pin myself down to a commitment to use any particular type of legislative history or not to use any particular type of legislative history. I'm just saying I will not exclude it as a basis for my decisions, as I have not in the past. And that it depends on what the snippet of legislative history is and how genuine a representation of the congressional intent it seems to be.
Well, let me be a little more specific. When you decide a case and look to the legislative history to help you, is it meaningless for a committee report to suggest that a court has misinterpreted an earlier statute and have that statement be meaningful to you?
In the Hershey case that you're talking about, it seems so to me because the statute hadn't been changed. The statute was reenacted unchanged, although it would have been easy to clarify the provision that was ambiguous and that had been the subject of the earlier court decision. What happened, it seemed to me, as best I could read the legislative history, was that the body as a whole had no intent concerning that earlier decision, probably didn't even know of that earlier decision. But the committee at most, and perhaps only the committee staff for all one knows, did have views about that opinion and put it into the committee report. But it is, of course, the view of the whole Congress that counts. Now, if the act had been amended in some respect, and if this statement in the committee report were an explanation of why that amendment, which came out of the committee, was suggested, then it would have had more weight. But here, the statute was enacted entirely unamended, and the statement in the committee report seemed to me almost a dictum. It had nothing to do with the bill that was on the floor.
Well, I think the facts are that there were a number of changes made in successive reauthorizations to that legislation.
No, but I said unamended in the respect that had been the source of ambiguity, which was the subject of the prior court decision. Yes, the act was amended in other respects, but there was no amendment to which this particular language in the committee report had any relevance.
Would it be improper to ratify, so as to speak, a correct court decision by Congress stating that in the committee report?
Can Congress ratify a court decision?
Well, what I'm saying...
Congress can only act... Senator, Congress does not act in committee reports. I will say that flat out. Congress acts by passing a law. The only value of a committee report is...
I'm speaking to the point of Congress accepting a view of a court decision and expressing that in the committee report, and then that being legislative history towards what Congress intended to some extent. And I'm talking about a correct interpretation.
I think that the statement in the committee report would have to be an explanation of something that Congress did in the statute. If it were an explanation of something that Congress did in the statute, and it shows that what Congress did in the statute was based upon thus and such an interpretation of a prior, or an acceptance of a prior opinion, then it would be of value.
Well, suppose Congress sees two different court interpretations of the same statute, and Congress says, this is the one that we intended.
In the law? No problem.
In the committee report, as a statement of congressional intent.
I wouldn't think that was of any relevance unless Congress had done something in the law of which that statement in the committee report was an explanation.
Suppose it's Congress's judgment that what we said 5-10 years ago is exactly what we intended, and we still intend to say it. It doesn't need a change in the statute, and we're saying with two court decisions with opposing views of that this is the one we like. What's wrong with that as a judgment by Congress of telling the courts how we want the statute interpreted in the future time?
If I could know that that's what the whole Congress meant, there'd be no problem about that at all. But I don't
Well,
know
we're
it when
talking
all
about
I see is
committee
is a
report.
single committee report. I can't tell that that's what the whole Congress meant, just from looking at a single committee report, where Congress has taken no action on the face of its statute to which that report is somehow tied, which that report explains, where it's just passing a law that, and the committee that happens to have jurisdiction over that area makes a comment.
Well, obviously, we're talking about a committee report that would follow legislative reauthorization or some other form of congressional enactment for that specific Congress by which the report came.
Yeah, but my only point, Senator, is I don't think that gives the committee the right to opine on all matters pertaining to that law, not to those matters which the committee is bringing before the full Congress. And mind you, all I'm seeking to do, and it's a problem for any judge using legislative history, is to try to figure out what the intent of the Congress is, and to what extent this expression, whether it be on the floor by a single senator, that's a problem sometimes too, or whether it be in a committee report, whether that genuinely represents what the whole body intended, so that we're sure we're not disenfranchising the Congress and getting you as a member of the Senate committed to a position which in fact you knew nothing about and would disagree with.
Okay. Well, the reason why I ask these questions is that I think I detect something in your writings, whether it's on the Graham-Rudman, the legislative veto, or this example I just gave. I sense a very critical view of how Congress tries to get things done. Can you address this concern, whether or not you think I'm being too sensitive about it?
Now, honestly, Senator, I have no criticism whatever about the way Congress tries to get things done. You can get things done any way you like, and that's your affair. And I understand the problems that you confront in trying to get it done. The problems that you tried to grapple with a legislative veto, and the kind of problems you're referring to that can be handled by committee reports.
Your background's primarily academic. You've also had a stint in the executive branch, but you never served in the legislative branch, and of course I'm not suggesting that you should.
I'm sorry I didn't, Senator. I frankly have gotten a good look at the territory of the law. The one slice of life I didn't get a peek at was Hill work, although I dealt with the Hill to some extent when I was in the executive branch.
Okay, I'd like to ask if you think that fact that you haven't served in the legislative branch might explain a lack of deference to the methods of the legislative branch in how we choose to do our job within the political constraints that we have to account for here.
No, I don't think so, Senator, because some of the criticisms I've made about committee reports, for example, have been made by members of the Senate. And you certainly couldn't explain it that way as far as their criticism is concerned.
But there isn't one of those senators that might criticize a specific committee report that takes the same that shows that same lack of respect for committee reports, because they would be involved with committee reports in almost every piece of legislation that comes before them and that they have to vote on. Mr. Chairman, I have no more questions.
I asked you one more question.
No.
Oh, you're through. We intend to take a recess right now. I understand we're going to have a vote in the Senate in a little bit. We have to take a recess then. So if you don't object, we'll go on for a few more minutes, if that's all right with you.
Mr. Chairman, can I just ask one question before you do? If we don't have a vote, the vote is put off, what will we do then?
We'll stop for a recess. And we'll try to find out when the vote's coming. Are you next?
I was next. I just didn't want to delay the committee when we go back in.
You can go ahead now then.
No, I won't. Scheduled momentarily. Well, then why don't we wait? Why not? Because Judge Scalia has also had a long time here.
Well,
I'm amenable.
10 minutes, so we won't save all the time we can. And he says he's willing to go in a few more minutes. You want to go now?
What's best for you?
Yeah, I'll call on you now.
Thank you, Mr. Chairman. I think one of the problems we've had is that the chairman's absolutely right in saying that votes been scheduled, but they keep putting it off and off and off. That's part of the legislative part of that legislative procedure that you and I have discussed in the past, too. Judge Scalia, yesterday's Wall Street Journal quotes Judge Richard Posner of the U.S. Court of Appeals for the Seventh Circuit as saying the words fairness and justice are terms which have no content. I'm interested in your view. Is the word justice one that has content to you?
Oh, yes, I think, of course, I think it has a content. I'd be surprised if what Judge Posner meant was not simply that, at least at the margins, and it's usually at the margins that we're talking when we have litigation in front of us. People disagree as to what justice requires, but I believe it has content, and fairness has content.
I ask that only because it jumped out at me when I read that, knowing that the first line of the Constitution says, "We, the people of the United States, in order to form a more perfect union, establish justice," and so on.
He shouldn't have put it that way. Should have known better.
I suspect he probably feels that way today, too. Maybe the Wall Street Journal, as Judge Heflin said.
I'm sure he doesn't mean anything different either, Senator.
Judge Scalia, you've been an outspoken critic of the Freedom of Information Act, and you've written and spoken out against the 74 amendments to FOIA. At the time these amendments were passed, were you the Assistant Attorney General in the Office of the Legal Counsel?
Yes, I was.
Did you have an opportunity to review those amendments and recommend to President Ford whether he sign or veto those amendments?
Yes, I did.
And what was your advice to President Ford?
Is this public knowledge, Senator? I don't know. If it's not, I think I probably shouldn't disclose it unless the President wants me to. The President vetoed the amendments, and I think he set forth in his veto message what his principal concerns were. The major one was the requirement of the amendments that courts review de novo justifications for withholding on the basis of national security.
Is it saying, do you agree with that veto?
It's come to the same question. Do I now?
Do you now agree with that veto?
I don't have any views on such matters now, Senator.
Did you agree with the veto at the time?
Senator, I have no compunction in answering it all, except the attorney-client relationship that I had with the.
Let me just ask, on your own personal legal opinion, did that veto comport with your own personal legal views of the Freedom of Information Act?
I think it comes to answering the same thing, and I really. I think I shouldn't, in deference to the attorney-client relationship I had with it.
And I'm really not trying to find just
I've criticized those amendments, Senator. I think you have in front of you. I mean, I'm in print as having criticized those amendments. I might also add, however, that when I was chairman of the Administrative Conference of the United States, I testified before Congress in favor of proposed amendments to the Freedom of Information Act and in favor of proposed application of the Freedom of Information Act by the agencies that were in the direction of liberalizing some disclosures. So
But going to the 74 amendments, which you did write about and that you spoke out against.
Yes.
The President then vetoed these amendments that you wrote about and spoke out against.
Yes.
The Congress overwhelmingly overrode that veto.
I think they
because of that, would you have any difficulties in upholding the law as it's currently written?
No, none whatever, Senator. I've upheld it as it's currently written. And I'm not sure whether Congress simply overrode the veto or did they make one minor change before they overrode? No?
You vote up or down on the veto, Judge.
Okay.
We don't even get a chance for the the staff to go in and write a report.
But they could. That's right. I suppose that's right. They did override and not pass an amended bill.
When we discussed this, am I correct in in summarizing our conversation that you said the law, sensible or not, was clearly written, and that Freedom of Information Act cases which you have heard were never particularly difficult to resolve.
Oh, no, no, you must have misheard the latter. Some of the most, I can name a couple, some of the most complex cases I've had were FOIA cases. I think
Was that because of the facts or because of the law?
Both, but probably more often the law. Church of Scientology is one of the cases. I commend it to your attention as an incredibly complex opinion, both the panel opinion for 3 judges which I wrote and the in-bank court opinion which I wrote. And it's one of the most complex pieces of statutory interpretation that I had to set my hand to.
Do you find the Freedom of Information Act a clear act, irrespective of how you may have felt about it, and felt about the 74 amendments? Do you find it a clearly written act?
No, I would not. I would. If you asked me for an example of a vague statute, the Freedom of Information Act is not what I would immediately pick out. There are some areas where, after I guess a couple of decades of experience now, the statute could be made more precise. But if you asked me for a vague statute, that is not what I would mention as a prototype.
FOIA was enacted before I was here, so I have no pride of authorship one way or the other, because I'm not involved in it, but I do want to. It is an act that keeps coming back to us, and it's one that I've been very involved with since. And then do I understand that the act is, at least as acts go, a clear act? It is not a vague act.
I don't know what you mean by almost any piece of legislation. You can say that there are some areas that could be more specific. There are certainly some portions of FOIA that are like that. How specific Congress wants to be, is always a question in every statute. The problem with FOIA, Senator, is that unlike most statutes that Congress passes, it isn't addressed to a single agency, so, addressed to OSHA or to the Food and Drug Administration, so that even if it has a certain amount of vagueness, you're going to get a standardized interpretation by one single agency. The problem with FOIA is that it goes out there to every agency in the executive branch. So to the extent there's any vagueness at all in FOIA, that vagueness is going to have to be resolved at the district court level, because each agency might resolve the vagueness somewhat differently. Now, the Justice Department tries to, at least it used to in the days when I was there, try to get the agencies to come up with a uniform interpretation, but I think you can say that there's special need for precision when you have a statute that is a cross-cutting statute.
But there are a lot of acts that go that way, or a lot of your employment acts and employment practices and so on are the same way.
I think that's so, although most of those are in much more detail than FOIA. I have no particular, I don't know what you're driving at. I guess what I'm saying. I suspect that there's some legislative proposals to amend it.
I just said
I really have no
I'm concerned about the FOIA. You will be having FOIA cases, I'm sure, before the Supreme Court. Aware of your opposition in '74, and I want to know if that, in your mind, does that opposition create a problem for you in hearing FOIA cases now?
No, Senator, I was asked that question earlier, I think, when you were out of the room, and one of the things I said then, and I stand by it now, is that to the extent that I've made significant law in the FOIA field, I've had a lot of FOIA cases, I don't know what the score is, but to the extent I've made significant law, I think it is in the direction of broadening access rather than restricting access, which...
I'll go back to the transcript of your earlier answer. One of the problems that happens to us in all these things, we have 4 or 5 matters going on at once around the corner of the Appropriations Committee meeting, on which I also serve.
I understand that.
Handling matters there. Judge Scalia, do you recall, well, I recall it was just last year, the Western Union Telegraph Company versus FCC. That was a case involving AT&T and MCI.
Yes, I do, Senator.
And were you asked to recuse yourself in that case by any of the parties or litigants?
No, I was not, Senator.
In '82, you were not on the bench. You'd received a consulting fee from AT&T in an antitrust case between them and MCI. Did you feel that that was close enough in time or significant enough in involvement to call upon yourself to recuse yourself?
No, I didn't, Senator. I had not been counsel for AT&T. I mean, I had not had a long-standing attorney-client relationship with them or anything like that. I had simply done a one-shot job of consulting with them, I guess 2 years or so before I went on the bench, and the compensation may have been just the very year that I went on the bench. And once before, I had taught a seminar for some of their executives about communications law one afternoon. That was the only association I had with them. It seemed to me that 2 or 3 years disqualification from AT&T matters would be more than enough to eliminate any appearance of impropriety. In all of these cases, of course, it's not just a matter of an interest on just one side and no interest on the other side. It's a cost to the court when I have to disqualify myself, of course, and it's unfair to the litigants. If there's no proper reason for disqualification, they're entitled to get a shot at the full bench of judges and not just at the full bench minus 1 or 2. So I decided that I would recuse myself for a period of 3 years. I informed the clerk of the court that I would not participate in any AT&T matters. That means that I'm, as a practical matter, disqualified from all common carrier litigation, which is a good chunk of D.C. Circuit business. After 3 years, I instructed the clerk to put me back in the pool for AT&T cases.
You do not agree with Mr. Friedman, the former dean of Hofstra Law School, who disagreed with your refusal?
No, not at all, Senator. And I don't know anybody else that agrees with him either. I've had nobody that has told me they thought that 3 years' worth of disqualification for that kind of prior financial connection with AT&T wouldn't be more than enough.
In another case, you wrote the decision in Block versus Meese, which dealt with the labeling of foreign films as propaganda. One of the 3 films involved in one was an Academy Award-winning film on nuclear war. 2 dealt with acid rain. In the decisions, I said labeled them as propaganda. Now, next term, as I understand, the Supreme Court will hear a California case, not a D.C. case, but a California case dealing with the same issue and, in fact, the same films. Is that one that you would feel that you should recuse yourself on?
I've been thinking about that, Senator. What do you think? I think it's a close one. It's not the same case. It's just the same issue of law, but the case is really.
I've not given the sense of the question of recusal much of a mind. I don't think that I'm on President Reagan's short list for judicial nomination.
No,
even though he'd have a chance to get both an Irishman and an Italian at the same time. But
all I can say, Senator, is I'm thinking very hard about disqualifying myself from it. They are the same films, not the same parties in the litigation, but it are the same films, not just the same issue, but the very same films involved. I think I will probably disqualify myself, recuse myself.
I might say only because
I wouldn't want to argue to me in that case.
I understand. Only because you had asked me the question on it. I would reach the conclusion that one should recuse himself.
In for a nickel, in for a dime. I may as well. Yes, I will recuse myself, Senator. I feel uncertain enough about it that I don't think I ought to go near it.
So I look at it this way, it'll probably get you out of having to watch the films again.
I never watched the films. That was not part of litigation.
Back in an area, and I would like to go into, you served under Attorney General Levy, who conducted a pretty extensive review of the domestic security program at the FBI and the Justice Department. He ultimately issued guidelines as to the appropriate scope and conduct of domestic security investigations. They were revised by Attorney General Smith, but they're basically the same guidelines. The Levy guidelines are basically what we use today.
I don't think so, Senator.
No?
No.
How do they differ today?
Well, I don't know the extent of the difference. All I know is that the intelligence community, so-called, did not like the Levy guidelines at all, and that the Smith guidelines were thought to be more acceptable to them. I know there are differences. I don't know what they are.
Wearing another hat, I deal with those same intelligence agencies, and I don't see an awful lot of difference. That's why I was curious what you might.
I've been out of that field for a long time, except that I know that some of my former associates in the intelligence community dearly did not love the Levy guidelines, and I think I thought that some of the impetus for the changes was from those people.
What was, did you work on the development of those guidelines?
I believe that Mary Lawton, who was my deputy at the Office of Legal Counsel, was the prime worker with the Bureau and the other intelligence agencies in developing the guidelines.
Who's still involved in that field?
I'm sure Mary has now gone on from the Office of Legal Counsel to, I think, a whole new post just dealing with intelligence matters.
Did you have any occasion during that time to consider whether Congress had the constitutional authority to legislate restrictions on the scope and conduct of such investigations?
Did I have any? I don't think I had any occasion to consider it, Senator, because I don't think there's any question that Congress does.
I'm sorry, I didn't hear that last.
I'm not aware that it was ever in question that Congress had authority to act in the field.
Was the FBI's COINTELPRO program underway when you joined the Justice Department? I'm having a little trouble recalling myself when it ended.
Oh, I'm sure it was all over by then, Senator.
Did you have any occasion on the Office of Legal Counsel to render opinion as to the scope or the authority or the legality of domestic security investigations generally that you recall?
Not that I recall, Senator. Not that I recall.
In the standard questionnaire, an area that I always find of interest, judges are asked is, quote, what actions in your professional and personal life evidence your concern for equal justice under the law? And you answered the question in part by referring to your work in support of legislation to overturn the doctrine of sovereign immunity. Can you describe the kind of work you did as assistant? Oh, I'm sorry, Mr. Chairman, I didn't realize the time was up.
Distinguished Senator from Alabama.
Judge Scalia, Senator Grassley asked you about legislative history and bearing downright hard on the issue of the committee reports. I've had the privilege of reading some of your writings, including a speech that you delivered between the fall of 1985 and spring 1986 at various law schools.
That was the speech,
Senator,
Senator,
on the use of the legislative history, not your dissent. And just to refresh your recollection, because I sort of agree with you on your priority that you give to the committee report. You quote from a Senate debate, floor debate on the tax bill in 1982, where Senator Armstrong and Senator Dole are involved in it, and Senator Armstrong points out the fallacies of what the committee report does, and involved in it just for everybody's edification, he said, he asked him, did any senator write the committee report? And Dole answered, I'd have to check. Does the senator know of any senator who wrote the committee report? He said he might be able to identify, but he'd have to search. And he said works, but it goes on to say staff. And he said, has the senator from Kansas, the chairman of the Finance Committee, read the committee report in its entirety? Senator Dole answers, I'm working on it. It's not a bestseller, but I'm working on it. And then he said, did the members of the Finance Committee vote on the committee report? Senator Dole says no. And Senator Armstrong says, Mr. President, the reason I raise the issue is not perhaps apparent on the surface. Let me just state this. The report itself was not considered by the Committee on Finance. It was not subject to amendment by the Committee on Finance. It's not subject to amendment now by the United States Senate. And you mentioned, and Senator Armstrong goes on and he says, for any jurist, administrative bureaucrat, tax practitioners, others who might chance upon the written record of this proceeding, let me just make the point that this is not the law. It was not voted on. It is not subject to amendment, and we should discipline ourselves to the task of expressing congressional intent in the statute. That's from the Congressional Record, July 19, 1982. You state ironically, but understandably enough, this is in your speech, the more the courts have relied upon committee reports in recent years, the less reliable they have become. And then at the end of your speech, you state this, for the purpose I suppose I would rank most highly legislative history consisted of amendments defeated on the floor, where it appears clear that the reasons for the defeat was a rejection of a particular course, now said to be contained in the unamended text. I suppose next to that would be extended floor debate, at least in circumstances which occasionally occur where the final text is actually being crafted on the floor. And then you state at the bottom of my list I would place what heretofore seems to have been placed at the top, the committee report. So I think you've expressed pretty well in your speech there the reason why the committee reports are not given a great deal of credence relative to legislative history.
I'm glad Senator Grassley's not here, though, Senator.
Well, maybe his staff will tell him, and I'll talk to him a little bit about it, but I thought that might be interesting to clarify and why. I think, frankly, that there has been too much reliance by congressional bodies on the committee report, and I've been one that's been arguing that is a wrong practice. Let me ask you this, in the Washington University Law Quarterly, you stated in an article entitled The Disease as Cure. This is a commentary on in order to get beyond racism, we must first take account of race. You state that I am in short opposed to racial affirmative action for reasons of both principle and practicality. And you went on to say that I strongly favor what might be called, but for the coloration that the term has acquired in the context of its past use, affirmative action programs of many types of help for the poor and the disadvantaged. Judge, would you define what you meant by principle and practicality in the first quote, and what type of affirmative action programs you do favor?
Well, as to the latter, I think what I was saying is that there's, let me set it in context once again, Senator. This was not when I was a judge, it was a speech I gave. In fact, it was on a panel at which now Judge Edwards, who was then also an academic at the University of Michigan, was another one of the panelists, and it was a panel about affirmative action as a policy, not its constitutionality, not its legality, and I was speaking as a, in those days, a law professor who could have views on such policy matters. When I said I would favor certain types of affirmative action programs. I was referring to affirmative action programs in favor of the poor and disadvantaged, even when it turned out that every one of the poor people or every one of the disadvantaged people favored by a particular program turned out to be of a particular race. I said that would, of course, make no difference. But the basis for the affirmative action, the basis for the favoritism, was the poverty or the disadvantage. What I expressed myself in opposition to on policy grounds was favoring a group solely on racial or ethnic grounds and not on basis of poverty or disadvantage. As to the practical and principal problems I found with the latter type of affirmative action, one of the things I mentioned, I guess the two things are, number one, when you favor one person because of his race, you are automatically disfavoring another one because of his race. And I think the second consideration I pointed out was that to an extent it deprives the members of the race who are given the special advantage of the fruits of their labors, because they are sometimes regarded as having achieved those fruits only because of affirmative action, whereas they could have they could have made it without it, and there's no way that they can demonstrate that. Those are, as I say, policy views of mine at the time. I think they're views held by other reasonable people. They're views disagreed with by the Congress, and that's why one has a Congress. Those views have nothing to do with the way I will apply whatever affirmative action laws are enacted by the Congress.
In your questionnaire, you list your various positions and jobs, and you mention quoting from your page 13 of your questionnaire, it says, "In my final executive post as Assistant Attorney General for the Office of Legal Counsel, September 1974 to January 1977, I was legal advisor to the Attorney General, and through him or directly to the executive branch. The Office of Legal Counsel drafts the Attorney General's opinion and much more frequently issues its own opinions under the Attorney General's delegated authority to the White House and all executive agencies. The questions I dealt with were multifarious, covering all aspects of federal constitutional and statutory law. Then you say the job also involves a substantial amount of congressional testimony on such issues as executive privilege and a legislative veto. I just wonder if you recall any of the congressional testimony pertaining to executive privilege, to whom it was given in Congress, what the House or Senate and the committee, any time pertaining to that.
Senator, unless I'm mistaken, it was both before the Senate and the House. I think it was before judiciary in both houses, but I'm sure I can get that for you. I'm sure it's all a matter of public...
You remember what the issue was about or how the circumstances arose?
I think mostly it was executive privilege in general. The whole doctrine of executive privilege was then at issue with regard to a number of different matters that the Congress had on the stove with the executive, and I don't recall right now any specific issue of executive privilege where it involved the withholding of any particular document or set of documents and where I was testifying. But I can get it for you. I'm sure there's a record of it. All that testimony is...
Well, I'm sure there's a record. I thought maybe you might give us enough to identify where we might look to see what you might have said pertaining to that at that particular time. You don't remember what the
I
issue
don't
was
remember.
that brought you to Congress?
No, at the time, Senator, I remember I think I was on a panel, and I think it was a panel before a committee concerning whether there was any such thing. I mean, this was before the Supreme Court's decision in the United States versus Nixon. So there had been no court decision which, in so many words, had affirmed the existence of such an animal as executive privilege, and it was a matter of great interest to the Congress at that time. I was on a panel, as I recall, with Raoul Berger from Harvard, who was an opponent of the existence of any executive privilege.
Express the viewpoint that that cooperation with Congress should be followed, and that Congress should be allowed to see all documents except, and then list the exceptions that at the time had the president that you were serving under, who I assume was Ford, and were you also under Nixon as
No, I didn't serve under President Nixon. He was out of office before I was confirmed.
Well, did President Ford at that time issue any executive order which, in effect, described and limited the use of executive privilege?
Yes, Senator, but not in the manner you described. The way it was limited was not describing the subject matters, but rather describing the procedure for its assertion. And the procedure was a rigorous one. It could not ultimately be asserted by an executive officer without, as I recall, the approval of, I think it required the President's personal approval before it could be asserted. So it's a big deal. The executive branch does not take it lightly. Now, very often when an agency is asked for documents, it'll say, we're reluctant to turn them over, and there's a preliminary process of negotiation. But if it really comes down to hardcore, adamant positions on both sides that can't be resolved, before the agency can say, we will not comply with the subpoena for the documents, we will not turn them over, the procedures required that there be, as I recall it, approval by the President with the advice of the Attorney General on the matter. And as far as I know, I'm quite confident that that's still in effect, or something like it. We didn't take it lightly, Senator. I mean, it's always a
of legal counsel whether or not he had issued an executive order which, in an effect, express the viewpoint that that cooperation with Congress should be followed, and that Congress should be allowed to see all documents except, and then list the exceptions that at the time had the president that you were serving under, who I assume was Ford, and were you also under Nixon as
No, I didn't serve under President Nixon. He was out of office before I was confirmed.
Well, did President Ford at that time issue any executive order which, in effect, described and limited the use of executive privilege?
Yes, Senator, but not in the manner you described. The way it was limited was not describing the subject matters, but rather describing the procedure for its assertion. And the procedure was a rigorous one. It could not ultimately be asserted by an executive officer without, as I recall, the approval of, I think it required the President's personal approval before it could be asserted. So it's a big deal. The executive branch does not take it lightly. Now, very often when an agency is asked for documents, it'll say, we're reluctant to turn them over, and there's a preliminary process of negotiation. But if it really comes down to hardcore, adamant positions on both sides that can't be resolved, before the agency can say, we will not comply with the subpoena for the documents, we will not turn them over, the procedure is required that there be, as I recall it, approval by the President with the advice of the Attorney General on the matter. And as far as I know, I'm quite confident that that's still in effect, or something like it. We didn't take it lightly, Senator. I mean, it's always a regrettable confrontation between the two branches.
Mr. Short, we got to vote on, is it?
Yes, sir. The chair would like to recess it here.
All right.
What we will do is, once you finish your questions, is to recess. We're also going to have a meeting of the Judiciary Committee at
Right after.
Well, I have several other questions I want to ask. If I still got time, I'd rather come back and do it.
How much time does Senator Heflin have?
Well, we still have time for the 5-minute vote. So
I got 15 minutes left. I didn't take it 5.
You have 5 minutes left.
You have 5 minutes left.
That's wrong.
If just one inquiry, when we start off tomorrow, are we in recess and come back in later this evening, or come
Only
back
until
tomorrow?
5:15, Senator. We'll recess until 5:15.
5:15, okay.
Start again at 5:15.
In other words, we're going to recess now to 5:15?
Yes, sir.
Unless you want to finish your 5 minutes.
No, I'll come back. We'll recess.
Well, then we will recess, and then this might be an indication, Judge Scalia, that notwithstanding the dire prophecies that you are going to be faced with a mass of vultures up here, it shows you how relaxed everybody's been. It's got all the way down to having me as acting chairman at this point. We'll stand recess at 5:15.
About certain documents that the Democrats wanted to see that are contained at the Justice Department concerning Justice Rehnquist. I appointed the able and distinguished senator from Nevada, Senator Paul Laxalt, to work with the Democrats, see if it could be worked out. They have reached an agreement, and I'm going to request Senator Laxalt now to announce their agreement.
I thank the chairman. We've been working for several days, and by we, I mean most of the members of this committee, in an effort to try to work out a compromise in connection with requested documents. And what we've had is a classic conflict between the executive and the legislative branch. Very frankly, the problem was not so much a lack of cooperation on the part of the executive. They wanted to cooperate, but they didn't want in the process to create harmful precedents or get in the way of the whole executive privilege doctrine. So as a matter of scope, what documents would be produced under what circumstances? And after endless negotiations, actually, I look back on it, I think the Marcos mission was a cakewalk compared to this one. As someone pointed out, I did have several more Marcoses to deal with in this situation. But we have finally arrived at an agreement defining the documents that would be made available for justice or by justice to the membership of this committee and certain staff. That examination will be conducted immediately, starting tonight, and sometime tomorrow the senators will be meeting to discuss staff recommendations and questions. The long and short of it is that the conflict has been resolved. In my objective opinion, the needs and desires of this committee and the legislative branch to conduct a full and complete inquiry has been properly balanced by the need of the executive to protect confidential and sensitive documents within the exercise of executive privilege. So what we have essentially here is a rolling back, a limited release of the imposition of executive privilege. And I think, Mr. Chairman, that we have a good compromise. And I'd like to compliment and thank and commend the various colleagues who worked with me for these last several days.
Mr. Chairman.
Go ahead.
Mr. Chairman, I'd like to publicly compliment Senator Laxalt. I quite frankly think with Senator Laxalt's diligence to this subject that allowed a result to be produced because everyone trusts him. The administration trusts him, I trust him, all my colleagues trust him. Number one. Number two, should not be misled by the comment of Senator saying limited. We are getting an access to all we asked for. Everything that we asked for, everything we asked for is being made available under the circumstances provided. When I say everything, in the last request, there were 7 categories we set out.
I was speaking of the first request,
Yes, I
which
know. I
was
just
much
didn't want the
broader.
press to come up and say,
Yeah.
well, what didn't you get that you wanted? From our standpoint, from my standpoint, the administration is not holding back anything with what is relevant to our inquiry here. As you pointed out, there have been several staff designees, 3 in the majority, 3 in the minority, who'll get a chance to look at this. And every senator has a right to look at them, and I know that we intend on looking at them, and we will late tomorrow afternoon, early evening, do a final review of those documents. And the last point I'd like to make, in fact, it wasn't merely Democrats who were requesting these documents. There were 10 people on this committee, including 2 Republicans, who felt it was important these documents be produced. I compliment again my colleague, Senator Laxall, and the chairman for his good judgment in appointing Senator Laxall, and the Justice Department in cooperating. And as far as we're concerned, unless any of my colleagues wish to speak, the matter has been amicably resolved.
Just for a moment, Mr. Chairman, and I don't want to delay the further consideration of Judge Scalia, but I, as one of the 3 members this side that initially requested these documents, and as one that made the statement that the administration's position of executive privilege, that they were basically stonewalling the committee and the American people and permitting the Senate of the United States to perform its function in advising and consenting under the Constitution on the particular nominee. I welcome the reversal of the administration to those requests. I believe that these requests were not being made in behalf of individuals. They are being made in behalf of the Senate Judiciary Committee, in behalf of the Senate, in behalf of the American people, so that we could fulfill our function. We'll have an opportunity to examine the various documents, the memoranda, the various notes, all of the information relating to matters which Mr. Rehnquist had recused himself as a Supreme Court justice, the May Day demonstrations, wiretapping, the whole Laird versus Tatum case, and other measures involving civil rights and civil liberties. I believe that this is a very substantial victory for the Constitution and for the constitutional process, and for the American people and for the Senate. So I want to just regret it's taken us the several days to get to this far, but I welcome the fact that we are here, and I too want to join in commending those that spent the time and the effort to assure that we are going to gain that measure. I want to make it very clear at the outset, in reviewing the various holdings on the issue of executive privilege, didn't feel that the argument that were being put forward by the Office of Legal Counsel held water. I don't think it holds water on the requests that have been made by Senator Nunn in terms of trying to gain various information with regards to our negotiating position on ABM. The Soviets have it. The negotiating debates and discussions and notes, the Senate of the United States has denied it. And I welcome the fact that we have made progress in this area, and I'm very hopeful that the soundness and the responsible attitude which has been assumed now by the Department will apply to other areas so that we can truly fulfill the mandate of President Reagan when he said that when information is requested by the various committees in order to fulfill their responsibilities, they will be able to receive it. Thank the Chair.
Mr. Chairman. Senator Messenbaum.
Chairman, I just want to say publicly that I think the one individual and American people owe a great debt of gratitude, Senator from Nevada, Paul Laxalt. Because I don't think there's any secret about it that this issue of the confrontation on the matter of executive privilege was rapidly escalating to the point where it was about to becloud the entire question of the confirmation of Justice Rehnquist. And I feel certain that if Paul Laxalt had not inserted himself into the issue at the request of some of us. I think that it would have gotten out of hand. I think there would have been proceeded to a matter of subpoenas and the entire unraveling of that kind of issue. I think Paul Laxalt has served the nation well in not permitting that to develop. I think the President owes him a great debt of gratitude, and as his reward, I think he ought to send to South Africa to get some matters resolved over there. But I think that's just a fine way for you to conclude your career in the Senate, Paul, but you've done a great job on this, I'll say.
Thank you, Howard. You're all hard.
Any other comments?
Well, I'd like to
Spoke a
second
few
it.
minutes.
I tell you, if y'all keep talking like it, you go give him the big hit. He might decide to run for president.
When I spoke a few minutes ago about the Democrats asking for documents, I should have said a majority of the Democrats. There were 2 Republicans on our side, Senator Specter and Senator Mathias, and I want to make that correction. Any other comments? If not, now we will continue with the hearing. And Senator Laxalt, we thank you again for your good work.
Thank you, Mr. Chairman.
Senator Heflin, I believe you have 5 minutes remaining.
Judge Scalia, a lot has been written in the paper about your belief in federalism, and the early decisions of the United States Supreme Court certainly recognize the essential role of the states in our federal system of government. Justice White in the Justice Chase in the case of Texas versus White declared that the Constitution is, all of its provisions looks to an indestructible union composed of indestructible states. Of course, the 10th Amendment, we know about that. I'd like for you to give us your general philosophy of the role of the judiciary and relative to federalism.
Well, I can give you my view of what it's been up to now, anyway, or at least in this century. The fact is, it seems to me, that the primary defender of the constitutional balance, the federal government versus the states, maybe versus isn't the way to put it, but the primary institution to strike the right balance is the Congress. It is a principle of the Constitution that there are certain responsibilities that belong to the state and some that belong to the federal government, but it's essentially the function of the Congress the Congress, which takes the same oath to uphold and defend the Constitution that I do as a judge, to have that constitutional prescription in mind when it enacts the laws. I think the history of this century, at least, shows that by and large, those congressional determinations will be respected by the courts.
Well, there are certain people of diverse ideologies that seem to embrace the concept of one federal legislative act as the cure for any major problem. These widely diverse groups, they are the extreme liberals and the extreme right-wingers, seem to at least agree on the fact of trying to find a single cure for problems that they consider to be monumental problems. And for example, the extreme right now seems to want a federal cure in the area of abortion, gun control, tort reform, labor violence. Does your belief in constitutional government include a belief that there should be a deference to the states in seeking solutions in areas that traditionally and historically have been considered to be in the jurisdiction of state government?
Certainly, as a member of the legislature, Senator, that would be my view. I think my writings show that I take seriously one of the checks and balances, which are the ultimate protection of individual liberties in the Constitution. One of them is is the fact that you have not just a unified centralized government, but also 50 independent states, and that the work of government is divided between those two entities. As to whether that question is of much relevance to me in the vast majority, if not all of the cases that I have to decide, that's quite a different issue. I think what I'm saying is that on the basis of the Court's past decisions at any rate, the main protection for that is in the policy-making area, is in the Congress. The Court's struggles to prescribe what is the proper role of the federal government vis-a-vis the state has essentially been abandoned for quite a while.
You don't care to comment on what you think from a position of being a member of the judiciary would be as opposed to the legislative, as you have stated.
I think that's right, Senator. I think what the Supreme Court decisions on the subject show is that it's very hard to find a distinct justiciable line between those matters that are appropriate for the states and those that are appropriate for the federal government. That finding that line is much easier for a legislator than for a court, and by and large the courts have not interfered. I expect there will be more arguments urging that they do so in the future, and I'll, of course, keep an open mind.
Let me ask you about the issue. You spent some time as head of the administrative conference, have written a good deal on administrative law and have taught administrative law.
Yeah.
We now have a situation where we have administrative law judges, and the administrative law judges outnumber the U.S. District Court judges and the Circuit Court of Appeal judges, I believe, more than 2 to 1, something like maybe in the neighborhood. These are ballpark approximate figures of about 1,400 administrative law judges as opposed to about 700 of the other type of judges.
Senator Heflin, if I might interrupt you, the time has expired. If you finish this question and proceed to the answer.
Well, there's been proposals to try to establish an independent corps of administrative law judges. Do you have any opinions relative to proposals to establish an independent corps of administrative law judges?
I wrote an article some years ago, Senator, in which I essentially supported the concept of a corps of administrative law judges, but the quid pro quo for establishing the corps, right now, of course, each agency has its own judges. The corps proposal is that there be a central depository of administrative law judges, an ALJ court, in effect, which would decide cases from all agencies with maybe specialized panels of that court. I wrote a piece that thought that concept was worth exploring, provided that what went along with it would be the understanding that all administrative law judges would not all be the same grade level as they now essentially are in each agency. And in most agencies it's a very high level. It seemed to me in that article at least that what we should be moving for is a career administrative judiciary, which is what most other legal systems have, so that you could, many of the administrative matters that need to be decided do not take as experienced, as seasoned, as knowledgeable, as expert a judge as a major rate-making case, and it would make sense to have judges of varying degrees of experience and hence varying grade levels who can work their way up through the corps and ultimately be assigned to the most difficult cases.
Judge Scalia, as I had suggested in the very brief opening statement, the questions that I have for you are really limited to certain of what I consider to be the rock bed propositions on the authority of the court to decide questions with finality on the interpretation of the Constitution, coming from Marbury versus Madison, which you've already commented about a bit, and the issue of the court's authority or jurisdiction to make those decisions in the context of any effort by the Congress to circumvent the court's power, should the Congress seek to do so by trying to cut off jurisdiction. And then the issue of the incorporation doctrine. And that really amounts to the areas of concern which I have. Starting first with Marbury versus Madison, I believe you testified earlier that a decision as old as Marbury versus Madison 1803, which does establish the basic power of the Supreme Court to decide the final interpretation of the Constitution, is a settled issue as far as you're concerned?
I said, Senator, it's a pillar of our system. I don't want to say that anything is a settled issue as far as I'm concerned. If somebody wants to come in and challenge Marbury versus Madison, I'll listen to them. But it is obviously a pillar of our current system. Whether I would be likely to kick away Marbury versus Madison, given not only what I've just said, but also what I've said concerning my respect for the principle of stare decisis, I think you'll have to judge on the basis of my record as a judge in the Court of Appeals, and your judgment as to whether I am, I suppose, on that issue sufficiently intemperate or extreme. But I really don't want to say, with respect to any decision, that I would not listen to a litigant who wants to challenge it. I invite you and urge you to make your judgment. I think the question you're asking is quite a relevant question. I wouldn't want to confirm anybody that I believed would destroy certain decisions. But I think the way you have to come to that judgment is on the basis of my past record as a thoughtful, moderate lawyer and judge, and on the basis of my writings and my records in the past. I don't want to be in the position of saying as to any case that I would not overrule it.
Well, you just used a magic word, Judge Scalia, moderate. You consider yourself a moderate judge?
I suppose everybody considers himself a moderate, Senator. I do.
Well, I don't know about that.
Well, maybe everybody doesn't. I do, anyway.
Well, I think you've come pretty close to saying that you consider Marbury versus Madison an indispensable part of constitutional law in establishing the authority of the Supreme Court of the United States to interpret the Constitution, but you haven't quite said it. You said it's a pillar.
It's certainly an essential part of the system that we now have.
Well, I'll infer a yes from your answer, although you haven't directly said it. I think maybe I'd even say you've implied it, but let me move on to the issue of jurisdiction of the court, and I'm appreciative of the fact that that is an issue which could come before the court. I hope it doesn't. We have Ex parte McCardle and we have U.S. versus Klein, and I'm sure you're familiar with the line of questioning that I undertook with Justice Rehnquist on that subject. But it seems to me that where you have the issue of jurisdiction, if the Congress can legislate and say that the Supreme Court of the United States no longer has jurisdiction, for example, on First Amendment rights of speech, press, and religion, that the pillar of our system is gone and the court no longer has the authority to decide constitutional questions. So let me ask you the question that Justice Rehnquist did answer without making any binding promises, because we're not looking to that today. But would you think that the court would have to have the authority, even in the face of a congressional enactment trying to take away jurisdiction, to retain the power to decide the fundamental questions of First Amendment, speech, press, and religion?
Senator, I'm afraid I'm at the same place on that I was on Marbury versus Madison. In fact, I think Ex parte McCardle was probably described too generously as being a decision of the Supreme Court that seemed to indicate, on the one hand, that the jurisdiction could be taken away entirely, and then United States versus Klein suggesting to the contrary. Ex parte McArdle actually didn't quite go even so far as to allow the jurisdiction to be taken away. It allowed the jurisdiction, habeas corpus jurisdiction, to be taken away under one statute, and the court went to some pains in the opinion to point out that this is not to say that there is no habeas corpus relief at all. There is just no habeas corpus relief under the particular statute as to which Congress had withdrawn it. So I don't think that there's an opinion on the books that is even as possibly antagonistic to your view as ex parte McArdle has been described. I share your concern with the ability of Congress to simply remove jurisdiction entirely from the Supreme Court. It is obviously a jolt to the system, to put it mildly. I just don't want to be, and don't think I properly can be in the position of saying that I would rule unconstitutional any piece of legislation that does that. I think I must ask you to judge what I am likely to do on the basis of your estimation of my my legal views, my loyalty to the meaning of the Constitution as you understand it.
Well, would you say that the jurisdiction of the court on speech, press, and religion is a pillar of our system?
I think the jurisdiction of the court on any matter is obviously a pillar of the system that we have.
All right. Well, you're talking about pillars. You're putting it on the same level as Marbury versus Madison, so that is an advance. Judge Scalia, the problem that I find with the limitation as to what you're willing to testify about is that it doesn't give a commitment to certain very, very basic principles. And I haven't asked you to go very far, and I really wouldn't. And I don't think there's any doubt about your confirmation as we're sitting here at the moment. But there is a real problem institutionally as I see the attitude and the responses which you take, and I respect them. I respect them totally. But I'm not asking you for what you're going to do with some of the really hot, controversial issues where people are hanging on bated breath as to where you stand, that you know are going to be coming up, and that if you answer one way, you're going to make one group of senators mad, and if you answer another way, you're going to make another group of senators mad. I'm going on Marbury versus Madison and jurisdiction of the court to real pillars that the building falls down. And the question I have for you is, how does a senator make a judgment on what a nominee for the Supreme Court is going to do if we don't get really categorical answers to fundamental questions like that?
I think it's very hard, Senator, when you're dealing with someone that doesn't have a track record, where you can't read that individual's opinions in the past, dealing with the important features of the Constitution and of statutes, seeing how that person deals with the materials, seeing that person's veneration for the important principles that you're concerned about. In my case, you have 4 years of that. You have extensive writings on administrative law and constitutional law from the years when I was a professor. You have testimony and statements that I made when I was in the executive branch. I am as sympathetic to your problem as you've said you are to mine. I think at least in the present circumstances, as I see my responsibilities anyway, my problem with answering the easy question, Senator, is that what's an easy question for you may be a hard question for somebody else. And as I commented earlier, it's not a slippery slope, it's a precipice. Marbury versus Madison, we all agree about jurisdiction of the court. It goes from one to the next, and I'm very unable to say this is the line where it suddenly has become a doubtful question. That indeed is prejudicing future litigants who should be able to come up and argue that we have seen, Plessy versus Ferguson might have been considered a settled question at one time, but a litigant should have been able to come in and say it's wrong, and get a judge who had not committed himself to a committee as a condition of his confirmation to adhering to it. That's what I'm struggling with, and I hope you have enough material to judge my reasonableness and my fidelity to the Constitution to assure you that on matters that you consider rock bed and that are rock bed, I would not pull the structure down.
Well, suppose someone wanted to litigate, and let me give you an absurd proposition. Suppose someone wanted to litigate your responsibility under your oath to uphold the Constitution. Would you hear litigants on that question?
I will hear a litigant on, well, I will hear a litigant in my present court on any question, Senator, and I've heard some fairly far-out arguments. In the Supreme Court, I won't have to do that because we have some option as to whether we decide to take a case or not. But in theory, I think I have to make myself available to any argument.
Well, let me ask the absurd question one more step closer. If you're confirmed, will you take an oath to uphold the Constitution?
I certainly will.
Well, of course you will. Will you let somebody litigate after you're on the Supreme Court whether you have an obligation under your oath to uphold the Constitution?
I think you've finally gone over the edge of absurdity so much that I have to say, of course not.
Well, wonderful. Then we've gotten the finale.
I'm on the precipice, you're telling me now.
No, you, that's a finite answer, and that's a conclusive answer, and that's a commitment. As I review the answers by Supreme Court justice nominees, there has been carved out a large range of exception where nominees simply do not answer questions. And I think that's justified in the highly controversial settings where it's imminent that question is going to come up and there's a sharp difference of opinion on it, and maybe on more practical grounds where getting into those areas is going to place the nomination in jeopardy in terms of the confirmation process. But I believe very firmly that if you're talking about the issues we've discussed so far, Marbury versus Madison, the authority of the court, or the jurisdictional issue, that we really ought to be able to have those answered positively and in terms of commitment. But your failure to answer it is not going to cause me to vote against you.
Well, I hope not, but I don't want you to think less of me for failure to answer. I've thought about this issue a long time because the one thing you know is going to come up in every judicial confirmation hearing, in particular Supreme Court confirmation hearing, is this issue of what questions can you answer, and it is a constant problem, and I realize that some nominees have tried to answer some questions and not answered the other. I thought long and hard about that problem, and I came to this conclusion, that if indeed it is obvious, then you don't need an answer, because your judgment of my record and my reasonableness and my moderation will lead you to conclude, heck, it's so obvious anybody that we think is not a nutty would have to come out that way. If, on the other hand, it's not obvious, then I am really prejudicing future litigants. So taking all that balance into account, I just concluded that the only safe position that I can take in conscience is to simply not say that there's any particular case that I would absolutely vote against a litigant who urges a position that is contrary to it.
Well, the problem with that, Judge Scalia, is that if we take what is obvious, then we look at your record, we look at your writings, we don't need a hearing.
Well, no, I think you have to look at my writings and ask me about my writings and test those writings to see what I meant about some elements of them. I've been questioned about cases that I've written, and I'm happy to respond to answers about what they meant and why what I said in them or what I did in them is not bad. I've been very open on those and will continue to be. It's just predictions as to how I will vote in the future that I'm drawing the line at.
Well, let me ask you the questions about the incorporation doctrine, because I want to put those on the record. Would you say that the issue of the due process clause of the 14th Amendment having incorporated the Fifth Amendment privilege against double jeopardy is settled as the case was decided in 1969 under Benton versus Maryland?
Yes, I will say that that's an accepted part of current law.
And would you say that the self-incrimination and just compensation clauses decided in Malloy versus Hogan and Chicago B&O Railroad versus City of Chicago are a settled matter of constitutional law?
They certainly have been clearly settled by the Supreme Court.
And would you say the same thing as to the incorporation clauses of assembly and petition, press, speech, and religion, that the 14th Amendment due process clause incorporates them?
Indeed, it would be quite a jolt to the existing system to suddenly discover that those series of protections against state actions do not exist.
And Sixth Amendment, speedy trial, public trial, and jury trial, all incorporated with the due process clause?
Indeed.
And impartial trial, notices of charges, confrontation, compulsory process, right to counsel, still in the Sixth Amendment, are all incorporated by the due process clause of the 14th Amendment?
That's what the cases have held, and it would be a massive change to go back on them.
And similarly, with the cruel and unusual punishment clause of the Eighth Amendment incorporated by the due process clause of the 14th Amendment?
Same answer, sir.
Would you say that those would come into the categories of pillars of constitutional law?
Marbury versus Madison is a pillar. If that's a pillar, I don't know what. I would just say it's a very accepted and settled part of our current system, and it would be an enormous change to go back.
Thank you, Judge Scalia. Senator Metzenbaum.
Mr. Chairman.
Senator Simon.
Well, maybe Senator Metzenbaum.
Senator Metzenbaum has not had a round yet.
Pardon?
Senator Metzenbaum has not had his first round.
I apologize. I thought he had his question. Sorry.
Judge Scalia, in an article, I'd say parenthetically, you've been very patient. It must be a long day, and you must be a bit weary, and your family must be wearier. But I'm glad the younger portions went home. In an article entitled "The Judges Are Coming," you made this statement: "It would seem to be a contradiction in terms to suggest that a state practice engaged in and widely regarded as legitimate from the early days of the Republic down to the present time is unconstitutional. I do not care how analytically consistent with analogous precedents such a holding might be, nor how socially desirable in the judge's view. If it contradicts a long and continuing understanding of the society, as many of the Supreme Court's recent constitutional decisions referred to earlier in fact do, it is quite simply wrong." The problem I have with that statement is that the Supreme Court throughout our history has had the responsibility to declare that certain widely accepted practices violate the Constitution. For example, deciding that segregated schools were unconstitutional and that legislative districts had to be apportioned fairly. Are you saying that as a Supreme Court justice, you would oppose decisions which prohibited widely accepted practices? Or stated another way, does that mean that if a Gallup poll says 80% of the people have a particular point of view, then court decisions to the contrary, in your opinion, those decisions are quite simply wrong?
Can I talk about what I meant when I wrote that article instead of putting it in the context of what I would do?
No, I'm asking that.
Yes,
I'm not asking what you would do.
Right. The point I was trying to make, Senator, was simply this. There is an ongoing debate it's always been ongoing, but it's just more publicly known now about strict constructionism versus a more evolutionary theory of the Constitution. And I am speaking particularly about decisions of the court that give content to provisions of the Constitution that are not sufficiently explicit to strike down particular practices. If a practice that constitutes plainly racial discrimination existed in all the states, it would make no difference whether it existed from the beginning of the 14th Amendment down to the present. If it's facially contrary to the language, obviously there's no problem. And that's not the situation I was referring to. I was referring to the situation where a court is giving content to, in particular, the due process clause of the 14th Amendment, what particular substantive protections that might incorporate. And what I felt, and it was the point of that article, was that the judges have authority to give such content, no doubt, but I do not know how a judge intuits that a particular practice is contrary to our most fundamental beliefs, to the most fundamental beliefs of our society, when it is one that was in existence when the constitutional provision in question was adopted and is still in existence. Now, when I say a practice is in existence, I'm not referring to a Gallup poll. I'm referring to the understandings of the people reflected in the legislation that their representatives have adopted. I would find it very difficult, I was saying in that article, to strike down a provision on the basis of substantive due process in particular, where it's a provision that state legislatures generally adopted at the time the 14th Amendment was passed and continue to generally adopt. When one leaves that point of departure, you're left to the individual preferences of the judges, and I am not comfortable with imposing my moral views on the society. I need something to look to, and what I look to is the understanding of the people. The strict constructionist would say, use only the understanding at the time of the 14th Amendment. The evolutionist would say, no, the understanding today as well. Whichever of those two you use, and as I said in some earlier questioning, I'm a little wishy-washy on that point, but whichever of the two you use, it seems to me that either one or the other has to reflect the new right that you found. If it was neither there when the 14th Amendment was adopted, nor is there today, then it seems to me, I was saying in that article, I'm making it up.
Well, it seems that you're equivalent of saying the Constitution means what the majority says it means. I have difficulty with this whole majority approach. And in your language is very clear. If it contradicts a long and continuing understanding of the society, as many of the Supreme Court's recent constitutional decisions referred to earlier in fact do, it is quite simply wrong.
Well,
that's a very bold statement. Maybe bold is even a mild word.
Well, maybe I shouldn't take it on frontally, but let me do it. I would even. It is true in a way, it seems to me, that a Constitution has to have ultimately majoritarian underpinnings. To be sure, a Constitution is a document that protects against future democratic excesses, but when it's adopted, it is adopted by democratic process. That is what legitimates it. And the point I was making in that article is if the majority that adopted it did not believe this unspecified right, which is not reflected clearly in the language, if their laws at the time do not reflect that right existed, nor do the laws at the present date reflect that the society believes that right exists, I worry about my deciding that it exists. I worry that I am not reflecting the most fundamental, deeply felt beliefs of our society, which is what a constitution means, but rather I'm reflecting the most deeply felt beliefs of Scalia, which is not what I want to impose
Judge,
on the society.
The real problem I have with your article and your own statements today relates to the fact, and I'm sure you remember it, that when the Kefauver Committee was active, I wasn't here in this body, but I remember there was a great hue and cry to repeal the Fifth Amendment. Anybody taking the Fifth was per se practically a bad person. We ought to repeal the amendment, that'll solve it so they can't take the Fifth. And then I have a recollection of somebody's poll, and I don't know whose, whether it was Gallup or somebody else, checking with people as to their views on each of the separate constitutional amendments to the Bill of Rights. And overwhelmingly, American people indicated they don't support that concept. Now, I sit here concerned, is this new justice of the Supreme Court going to start to find ways to change that Bill of Rights because it is a fact. It is tougher. It is one of the toughest things that some of us have, and that is to stand up for an unpopular point of view on the basis that that's a person's constitutional right. It's sometimes, I guess I remember one case, the case up there in Illinois where the Nazis were picketing or they were marching, and the Jewish community came out en masse to try to stop them from doing it. And I remember the American Civil Liberties Union got into great trouble because
Skokie, as I recall.
Pardon?
Skokie.
Skokie, that's right. And in that case, the American Civil Liberties Union lost a lot of its members, but they stood up for what they thought were their constitutional rights, even though they'd be unpopular. I'm worried about you're going on the court and reacting. What's that? Let me just. 15-minute roll call. I guess they reform Republican senators as well as Democrats. I think I may have cut you off. Had you finished?
No, you just made a statement that I don't disagree with your concern. All I can say to it is that the views I expressed certainly do not reflect the notion that I will be swayed by Gallup polls or by current public opinion. To the contrary, if there is an established constitutional right that has been set forth in the Constitution, and that or even if not set forth very explicitly, is clearly established by the practices of the society, I would assuredly not allow the mere fact that the current society, inflamed by one passion, prejudice, or another, wants to stomp it out. I would not allow that to affect my judgment. Quite to the contrary.
Let me ask you a little bit.
I don't mind taking unpopular positions, Senator.
Let me ask you a personal matter about your membership in the Cosmos Club. I think you were a member.
Yes, sir.
You were a member from 1971 to December 85. I think the Cosmos Club excludes women from its membership. And I think the ABA's position is that the membership of a judge in an organization which practices discrimination may give rise to perceptions by minorities, women, and others that a judge is not impartial towards minority groups. And then the ABA Standing Committee on Ethics and Professional Responsibilities has been considering the impact on the judiciary of judges who belong to discriminatory clubs. And the Judicial Conference in 1981 adopted a resolution that it is inappropriate for a judge to hold membership in any organization that practices invidious discrimination. And then in '83, the ABA Ethics Committee submitted to the House of Delegates proposed amendments on the membership of judges in private discriminatory clubs. More than half the population is female. And the women of the country have some concern, rightful concern, about a jurist who undoubtedly knew about some of these provisions of the ABA and the Judicial Conference. Do you want to comment on that?
Well, I certainly agree, Senator, that a judge shouldn't be a member of a club that practices invidious discrimination. I think the issue is whether that was invidious discrimination or not. I certainly would not belong to a club that practiced racial discrimination, because I don't think there's any basis for socialization on the basis of race, that there's any difference in company on the basis of the color of a person's skin or ethnic background.
Did you know Cosmos Club discriminated against women? What, didn't have any women members?
I knew that it was a men's club, and what I was going to go on to say is that I don't consider that an invidious discrimination. I think there are a lot of other people who likewise do not consider it invidious discrimination. I realize there are those that disagree, that do not like organizations like the Knights of Columbus, or for that matter the Boy Scouts, and think that that should not be an all-male organization. I happened not to have felt that way, and thus was a member of the Cosmos Club. When I first joined it, Senator, was when I first came up to Washington to work in the executive branch. I lived in the club for about 6 months while my family was still in Charlottesville. One of the facilities of living there was that it was a men's club. Now, I understand there are people who feel differently about it. I am sensitive to their views. Towards the end of the period that I was membership of the club, that I was a member in the club, I was especially uncomfortable, because I know that some of the judges on my court took the opposite view of whether there should be clubs of that sort. I happen to disagree. I'm no longer a member. That's all I can say.
I note you used a rather interesting story to illustrate one of your objections of affirmative action, and that's the story of Tonto and the Lone Ranger, and in it I think you have tell the story with the Indian dialect of English. I won't read the whole story, but it's a cute story, but the English dialect of the Indian I'm not quite so sure about. Everyone who knows you says that you are quite adept with the English language. The fact that you have exceptional verbal talent. How do you think the Indians of this country might feel about your reciting that story with some of the quotes?
Would you read the quote where I used
Yes. When John Minor Wisdom speaks of restorative justice, I'm reminded of the story about the Lone Ranger and his faithful Indian companion Tonto. If you recall the famous radio series, you know that Tonto never said much, but what he did say was, disguised beneath a Hollywood Indian dialect, wisdom of an absolutely Solomonic caliber. On one occasion, it seems that the Lone Ranger was galloping along with Tonto heading eastward when they saw coming towards them a large band of Mohawk Indians in full war dress. The Lone Ranger reins in his horse, turns to Tonto and asks, "Tonto, what should we do?" Tonto says, "Ugh, ride 'em west." So when they wheel around and gallop off to the west, suddenly they encounter a large band of Sioux heading straight toward them. The Lone Ranger asks Tonto, "What should we do?" Tonto says, "Ugh, ride 'em north." So they turn around and ride north, and sure enough, there's a whole tribe of Iroquois headed straight toward them. The ranger says, "Tonto, what should we do?" Tonto says, "Ugh, ride 'em south," which they do until they see a warpath of Apaches coming right for them. The Lone Ranger asks, "Tonto, what should we do?" Tonto says, "Ugh, what do you mean, we, white man?" And it's a rather cute story, but I think the use by you of a sort of a Indian dialect. I wonder if the Indians would feel offended by it.
I'm fully aware of that sensitivity, Senator, which is why, when I began the story, I made it clear that Tonto's wisdom was always Solomonic, but it was disguised between what I referred to there as a Hollywood Indian dialect. That is a disparaging term. I'm fully aware that Indians don't talk that way. It's how Hollywood portrayed them. I thought I made it very clear in what I wrote, that Indians don't talk that way, but that's the way Hollywood wrongfully portrays them. Now, if that is not enough of a disclaimer and the story has to be stricken from everyone's repertoire, I think that would be a great loss. And it doesn't work in non-Hollywood Indian, it really doesn't.
There's now a pending request for certain memoranda that we have worked out in connection with Justice Rehnquist. He waived any objection to our having that information. Do you have any objection to our obtaining information from the Justice Department concerning your efforts while you were there?
Personally, Senator, you know, I have no personal objection to it. There's nothing I did at the Justice Department that was other than honorable. I'd be less than honest if I didn't say that having worked in the Office of Legal Counsel and defended its prerogatives for 3.5 years or so, I'm concerned about the institution, about the effect that such probing, or more specifically the awareness of the fact that whatever the head of the Office of Legal Counsel writes will henceforth, should he ever be subjected to questioning in connection with a confirmation, which is very likely because most heads of the Office of Legal Counsel, or many of them at least, go on to later government positions. I think it would be harmful to the office if it is known that everything he puts down on paper by way of advice to the Attorney General or to the agencies will be made public. I fear that it may make his advice less frank, less forthright than it otherwise would be. That's purely an institutional objection. It's up to the President to defend that institution. Personally, I'm not ashamed of anything I did while I was there.
And you have no personal objection?
I have no personal objection, Senator.
I have no further questions. Thank you.
Take recess, and the first, after the recess, James Sutton from Illinois.
I thank you, Mr. Chairman.
We'll take a recess now and go and vote.
Stands for. Let me first throw you a softball question. You will be one of the leaders of the law in this nation. You have been a law professor at Stanford and University of Chicago, University of Virginia, I believe. We, in 1970, had 270,000 lawyers. We now have 640,000, graduating about 39,000 a year. There are those who believe the numbers are so high that it can present problems in our society. Do you have any reflections on this? And if so, if there is a problem, what we do about it?
I share the perception that there is a problem, Senator. I'm not entirely sure what to do about it. To some extent, the problem feeds on itself, of course. There's the story of the fellow sitting in a train and the gentleman next to him asking him what he does, and he says, "I'm a lawyer." And the fellow says, "Gee, what do you know that? We used to have a lawyer in my hometown. Poor devil, he could hardly make a living. Then another lawyer moved in. Now they're both doing fine." To some extent, the very increase in the number of lawyers creates yet greater litigiousness. I don't know whether it does seem to be a trend that is beginning to slow down a little bit. The answers that are being sought are alternative dispute resolution mechanisms other than the courts. And my understanding is that there is some success with those mechanisms. Unfortunately, the resort to those mechanisms is in itself something of an admission of failure. People want to resort to them because the courts are too crowded, it takes too long to get justice there, and it's too expensive. which is a sad commentary. I'm afraid I just don't have an answer. I
Right.
share your perception of the problem.
It was not a question you expected to be asked
Yeah.
during this hearing, I have an
No, I
idea.
didn't.
Let me, let me read from a staff memorandum along with your opinion. It draws this conclusion. It says, from these and the other cases included in this book, it's easy to see where Scalia's sympathies lie. He will interpret civil rights statutes narrowly. In cases of race discrimination, a plaintiff will have a very difficult time proving his case because of the high standards Scalia imposes on race cases. The same will be true with gender discrimination. To be sure, the court will have an ardent enemy of affirmative action in Scalia, and in future cases, he can be expected to leave his mark. In his article, quoting from an article of Washington University Law Quarterly, you say, Justice Powell's opinion on affirmative action, which we must work with as the law of the land, strikes me as an excellent compromise between two committees of the American Bar Association on some insignificant legislative proposal. But it is thoroughly unconvincing as an honest, hard-minded, reasoned analysis of an important provision of the Constitution. Do you have any comments on my staff's conclusion looking at that area of your decisions and any reflections on your Washington University article?
Well, we discussed that article a little earlier, and as I said there, it was addressing mainly the policy of affirmative action, not its constitutionality, whether it was desirable. That is, of course, a disagreement concerning the means to the end. I don't think, I hope there's no doubt about my commitment to, or there should be no doubt about my commitment to a society without discrimination. If the notion there is that I'm hostile to laws that seek to eliminate that, that's simply not true. I'm in a way having any animosity towards racial minorities in my case would be a form of self-hate. I'm a member of a racial minority myself. Suffered, I expect, some minor discrimination in my years, nothing compared to what other racial groups have suffered, but it doesn't take a whole lot to make you know that it's bad stuff. My wife's mother remembers the days, she's a Fitzgerald from Boston. I wish Senator Kennedy were here to know that. But she remembers the days when there were signs in Boston that said no Irish need apply. I find all of that terribly offensive. I'm a product of the melting pot in New York, grew up with people of all religious and ethnic backgrounds. When I lived in your state senator, I didn't live in a monochrome suburb, but I lived in Hyde Park, and my kids went to school, a school that was at least 40%, maybe more than that, black, not white. My kids socialized with and dated people of all races. I have absolutely no racial prejudices, and am, I think, probably at least as antagonistic as the average American, and probably much more so towards racial discrimination. Beyond that, I can just say that I disagreed with affirmative action in that article as the way to eliminate it, because of side effects that I saw that could be worse than what was than what the particular affirmative action program would eliminate. In any case, those policy views will not inform my decisions on the Supreme Court, as I do not think they have informed my opinions on the Court of Appeals. I think it would be a different matter if those opinions showed any racial hostility or hostility towards the laws, and I don't think they do.
Let me phrase the question a little differently. Let's use an imaginary scene at the White House that might have taken place. The President asked the Attorney General, get me the 6 best names you can get in the nation. And he comes up with 6 names. One is named Jones, one Smith. And he looks through, and one is named Scalia. And the President says, it'd be a good thing to have Italian American on the Supreme Court. 6 outstanding nominees. And it is not difficult in this great land to find 6 outstanding nominees. Is there anything fundamentally wrong with the President making a decision on that kind of a basis in part, assuming you have 6 quality people there?
Fundamentally wrong you mean on illegal or morally wrong?
Well, from the viewpoint of the theory of government.
No, I think that it's a good thing. Certainly in my own hiring practices, I've tried to have a mix of people among my law clerks and elsewhere. No, I can't say that that's
okay.
That's
and so if Congress, through the if we decide that affirmative action, if we see a plant where there are 2,000 whites and no blacks, we say, as you award contracts in the defense area, let's try and encourage employers to follow practices that give opportunities for people. We're not saying you should hire people who are not qualified, but let's have a society where there are opportunities for everyone. If Congress passes laws requiring that, and I don't want to get into, we're getting close to territory that you may feel uncomfortable responding on, but just in the abstract, do you find that offensive from a legal point of view?
I don't want to. In the days when I wrote that article, I actually gave that speech, which became an article in the Washington University Law Review. I had policy views. I've tried not to have them, not have any public ones anyway, since I've been a judge. So I'd like not to comment on it as a policy matter. I just want to note that there is a difference between the first hypothetical you gave me and that. That is, and the difference is this: it's the President saying, it seems to me it'd be good to hire Puerto Rican or whatever, as his own voluntary decision, and on the other hand, saying the President or anybody must hire an Italian or a Puerto Rican or a certain percentage of them. The difference is that when you adopt the latter situation, you are automatically excluding some people from consideration. Now that makes a difference just as a policy matter. So it's a slightly different question. I guess that what my Washington University piece would say is that in the days when I had policy views, I didn't think it was a good idea. That has nothing to do with whether I would enforce it vigorously if it's passed by Congress.
I guess my experience is through life, and maybe yours too, that if you have policy views, inevitably they creep up or creep out or appear when you are on the Supreme Court or in any other position. But I guess what you're telling me is that is a policy matter for us to decide here in Congress, and you do not, and again in the abstract, you don't see a constitutional prohibition to Congress moving ahead.
Well, I guess we can get into the question whether the latter is a pillar or not, but I would like not to express a view on constitutionality of the matter, but certainly the policy of the matter is entirely Congress's. I am certainly in sympathy with the objective of Congress. Whether I am in sympathy with the particular means Congress has pursued to that objective, I assure you, will have nothing to do with my decision in the case. I understand that it's hard, but it's a discipline that a good judge has, and I think it's one that I have.
Let me shift to another area. After looking at your decisions in the First Amendment area, this conclusion is drawn here. In all three of the important libel cases that have come before him, Judge Scalia has ruled against the press. I received a memo from my colleague, Senator Dodd of Connecticut, expressing some concerns in this area. Now, you have in part answered this question to one of my colleagues, but any kind of generalities you would like to make in response to this characterization of your stands?
I'd be happy to talk about the three cases, if you'd like. What three was it referring to?
They are referring to the one was the mobile Pablo Rios, if I'm pronouncing it correctly.
Well, that was not. That is the one case one of very few cases I can't talk about because it's still before our court on petition for rehearing. But I can at least note that it was not my opinion. It was the opinion of Judge McKinnon in which I joined. The holding of the case was on a factual matter. I think I'd better not try to defend the holding at all, except to note that the opinion was not mine. It was an opinion in which I joined.
But that characterization of your decisions, you believe, is not an accurate characterization.
I think sometimes you win, sometimes you lose. The fact that I've ruled or joined an opinion against the press doesn't prove anything. What are the other opinions, Senator? I think I can probably guess them.
The other one that's quoted here quite a bit is the Ullman versus...
Evans and Novak versus Ullman. Senator Hatch said a few words about that case earlier. It really is, as I think he pointed out, a sort of damned if you do, damned if you don't situation. I could have been criticized as being against Marxists had I come out the other way. It was a suit by a Marxist against a conservative columnist. The fact is that my dissent in that case, it's a dissent that they're referring to, was joined in by, if I recollect correctly, Chief Judge Robinson. The position that I took was joined in by Judge Robinson, Judge Wright, Judge Edwards, and Judge Wall. My opinion itself was joined in by Judge Edwards and Judge Wall. I don't think that that's any indication of a bias against the First Amendment, unless all of those judges are deemed to have the same bias, which I would doubt. The specific issue in the case was whether a particular, it was a very narrow issue. We were all in agreement on the basic principles of First Amendment law, that it was libelous if it was not an opinion, it was not libelous if it was an opinion. And the issue before the court was whether the statement that this Marxist professor, who was up for appointment as chairman of the Department of Political Science at Maryland, University of Maryland, the statement that he had no status in his profession was not taken seriously by his colleagues, something to that effect, whether that was libelous. I thought that that was not a statement of opinion, but a statement of fact, that he was not highly regarded by his colleagues. And in fact, in traditional libel law, the classic libel is to say that you are not regarded as a competent by your professional associates. I just don't believe that there's anything in there that's antagonistic to the First Amendment. I think the opinion that I wrote, which largely responded to Judge Bork's concurrence, had a statement which was quoted by a columnist to the effect that public figures getting a good amount of bumping from the press was fulsomely assured by New York Times versus Sullivan. It somehow came out in the press as though I was saying that the freedom of the press was fulsomely assured by New York Times versus Sullivan. I wasn't saying that at all. I was saying the fact that public figures will get a good amount of bumping was fulsomely assured, by which I mean assured not only sufficiently, but more than sufficiently. I don't think that there's anything in that statement that demonstrates an antagonism towards the First Amendment. And the last case, Senator, was what? I'd welcome the opportunity to...
But I think you adequately covered it here. Let me shift to another area. You testified in 1981 on the tuition tax credit case, and you said in testimony, Senator Moynihan was taking the testimony, the court's decisions in this field set forth neither a settled nor a consistent nor even a rational line of authority that you could rely on even if you wanted to. You were not aware you were going to be a nominee for the Supreme Court when you said that. Do you have any general, well, the whole church-state issue, any reflections on that?
I suppose doesn't give any indication how I'm going to vote on any particular case. To say that I don't think that statement is would be much altered today, and I doubt whether there are very many people who would disagree with it, with the possible exception of, well, even the rational. The decisions are very difficult to reconcile with one another. The decisions that are on the books, the court, the rationale that's adopted in one case does not fit entirely well with the cases that have been decided in the past. I think that's common ground among people who discuss the Establishment Clause cases, whether the cases are thought of as being right or wrong. I think there is general agreement that it's one of the messiest areas of constitutional jurisprudence.
Well, assuming that, but do you have, are basic traditions pretty sound in this area, in the whole church-state area?
Basic traditions?
Yes.
I'm not sure what you mean by basic tradition, Senator.
Well, the constitutional principles as they have emerged over the past 2 centuries.
Well, I think what's sound is that what's accepted. The problem in the area, Senator, is a problem that largely arises because of a natural conflict between the Establishment Clause and the Freedom of Religion Clause. Both of those interests are very important. People ought to be able to practice their religion freely, and yet the government cannot establish religion. So you get cases like the case of the Jehovah's Witness, who wants to, being a Sabbatarian, wants to have Saturday off instead of Sunday, and wants to draw unemployment compensation when she's been offered a job that requires work on Saturday and turned it down. And the way the court resolved the case was to say it violated the Freedom of Religion Clause for a state not to allow her to draw unemployment compensation simply because she refused to accept a job that would require her to work on Saturday. Well, yes, that does protect freedom of religion, but on the other hand, doesn't that somehow amount to an establishment of religion, to have the state make a special rule to accommodate the religious belief of this Sabbatarian? That's the problem that runs throughout these cases, and that's the reason they are very hard to figure. On some occasions, the court seems to be giving more weight to the freedom of religion section of the First Amendment. On other occasions, it seems to be giving more weight to the Establishment Clause section. If I had to pick an area that, in the whole area of constitutional law that is in an unsettled state, I think that's the one, and I think many commentators would agree.
I see my time is up, Mr. Chairman. Thank you.
Senator Illinois from Illinois is correct, and the second round will involve
according to previous announcement of Senator Thurman, 10 minutes each, and the senator from Delaware is next. I'm
Call
sorry.
home, Justice
You want me to-
Scalia, that's the call. I'm sorry, I thought we were going to yield to my colleague. I appreciate that. I'll yield to my colleague from Alabama, and then maybe I could ask my question.
The senior senator from Alabama.
Thank you.
You've been previously asked about the Inner Circuit Tribunal. However, question is phrased as to whether or not the appointing power ought to be the Chief Justice or the President. Under the proposed legislation, it's a temporary court of existing officers of the United States who have already been confirmed under the Constitution. The selection of those judges has been debated. There seems to be two alternatives, one being it'd be three alternatives, one being the Chief Justice appointing them, the others being the circuit themselves selecting their judge, and the third being the Supreme Court instead of the Chief Justice, all 9 members of the Supreme Court doing the selecting. Do you have any opinion on which you consider the better method of those three?
It sounds like the least of the evils offered, Senator, doesn't it? There are problems with all of them. It's very hard to envision.
Excuse me, Judge Scalia, if you could pull your microphone a little closer.
It's very hard to envision a court getting together for such a purpose to select one of its number to be the designee, or for the Supreme Court to select particular individual judges. It amounts to a kind of, I don't know, designation of ability and of primacy that I certainly wouldn't want to do it as a member of a court of appeals. I wouldn't particularly want to do it as a member of the Supreme Court either. Your judgment on that is as good as mine, Senator. I'd guess that having the Chief Justice do it is the least evil, but there are problems with that too. It doesn't give you the spectrum of opinion that having a body of people do it would.
All right, so...
Some questions don't have any good answers, Senator.
Well, sometimes can't get people to state a position. But let me ask you another matter. We've got an issue before Congress now on the impeachment of a federal judge. House's representatives has, in effect, brought articles of impeachment, which are in effect are an indictment. The Senate is supposed to sit as a trial judge. For the judiciary, this appears to be a rather cumbersome process. Some of the states have had other procedures for removal of judges, and I'm not trying to prejudge or do anything pertaining to the one before us, but I just wondered if you have any thoughts on any innovations or improvements that might occur pertaining to problems that could arise with judges in the federal branch.
Giving this answer now that I'm a judge does make it sound as though it's self-pleading, but I had the same view before I became a judge. It is a cumbersome process. I think it should be a cumbersome process. I think it's the major protection for the independence of the judiciary. the bases for impeachment are somewhat vague, and the bases that past Congresses have sought to use in most prominent cases are pretty vague. It seems to me that it is an important protection to the independence of a judge to be able to decide cases as he sees them, that removing them is a lot of trouble.
Well, some of the states have had various methods. Some have had the equivalent of a House action taken through a judiciary inquiry commission, and then have a court of the judiciary, which is largely composed of judges and maybe also some lawyers. Others have had commissions which deal with the disciplinary and removal matter. You don't have any feelings about those, or you think the impeachment is more of a protection of independence than those methods?
I think much more so, Senator, and it's not as though the framers didn't know that they were establishing something that was very cumbersome and very difficult. They were out of step with many of the colonies at the time in what they provided for the judiciary. And one of the major debates at the convention was the provision on the judiciary, giving them life tenure, for example. Our federal judiciary is out of step with the states in many other respects. Many states have mandatory retirement age, as you know. Many states still, I believe, have election of judges. And all of those things were considered and rejected in favor of an extraordinarily strong, extraordinarily, more so than most of the colonies then and more so than most of the states now, an extraordinarily strong and independent federal judiciary. I think it was a conscious decision by the framers, and I happen to think it was a good one. I understand that it's, especially at a time when the Congress has plenty else to do, to have to sit in a trial of a judge is cumbersome.
I believe that's all the questions I have at this time, Mr. Chairman.
Senator from Delaware.
Thank you. You've had a long day, Mr. Justice, but from the time I've been here, it seems like you've had a pretty good day. And let me at least close out my questioning by asking for a couple clarifications and also to go into a little bit the privacy questions, Ninth Amendment. I understand in response to a question from Senator Metzenbaum, you indicated that you would not belong to a club that discriminated based on race, but you would not feel bound not to belong to a club that discriminated based on sex. Is that correct?
No, that isn't quite what I said, Senator. I said that I regarded the two as quite different, and that I would think that a club that discriminates on the basis of race or on the basis of religion would be invidious discrimination. I think the jury's out on whether it's invidious discrimination to have a men's club. That's what I said. I didn't say that.
Sorry to hear the last part. The jury is out.
I think that there's room for disagreement on whether a social club that's a men's club or a woman's club is invidious to the other sex.
Could it be invidious if, in fact, the effect of keeping women out was to have a detrimental impact upon their ability to do business, or if they were businesswomen, or participate in sport if they're sportswomen? Or
I can see that, Senator. Yes.
Would you? Where do you put the classification? I mean, in what context would you place those clubs which would discriminate based upon nationality?
Well, there's sort of a affirmative and negative discrimination, I suppose. There's certainly. I've been a member of Italian American clubs that members share a common heritage. The exclusion of others is not an invidious exclusion at all. And
if in fact,
likewise, religious clubs. I mean, they're Knights of Columbus and whatnot. They exclude people of other religions, not invidiously, but just because they get together to celebrate what they have in common. I think that's the key to it, whether the exclusion is an invidious one or not.
If in fact there were a club or an organization that included not one group of people who shared anything in common other than the fact they didn't like the Irish or the Italians.
Yeah, I think that'd be invidious.
You've been questioned on this already, but in your, get to make sure I have the right title of the article, referred to as the Panhandle magazine article.
Yes, sir.
I understand that one of my colleagues quoted you, the provision that said, "I do not care how analytically consistent with analogous precedent such a holding might be, nor how socially desirable the judge's view, nor how socially desirable in the judge's view, if it contradicts a long and continued understanding of the society, as many of the Supreme Court recent constitutional decisions referred to earlier in fact do, it is quite simply wrong. There will be no relief from the most far-reaching intrusions of the modern judiciary until the Supreme Court returns to this essentially common law approach to constitutional interpretation." Now, as I understand it, if in fact it were a long-established societal view, it would. Why don't you explain it to me?
Let me try, Senator. I am deeply mistrustful of my ability, without any guidance other than my own intuition, to say what are the deepest and most profound beliefs of our society. And that's what it means to say that something is constitutionally required. It is in accordance with the deepest and most profound beliefs of our society. I find it difficult to come to the conclusion that something qualifies for that description when neither at the time the constitutional provision in question was enacted was it in fact the practice of the society as demonstrated by the laws that the society enacted, nor at the present time is it that way. Now, I can understand, and you get into the debate between the evolutionists and the original meaning types when you say, well, what if everybody now thinks it's awful and there are no laws on the books of this sort today, but there were in 1789, so it must be constitutional. It seems to me that's a good debate. But I find it very difficult to say that it's contrary to our most fundamental beliefs when both in 1789 and today, all of the states have, permit the practice in question, whatever it may be. Once you don't give me that to hang on to, Senator, I worry that I'm left with nothing to tell me what are our most profound beliefs except my own little voice inside, and I do not want to govern the society on the basis of that.
Well, let's talk about the Ninth Amendment in that context. The decisions, and I don't expect you to comment on how you would rule, but the decisions that have arisen that have been somewhat controversial, where the right of privacy is asserted as being a right that is protected or recognized under the Ninth Amendment. I guess maybe that's the place to start, the Ninth Amendment. You believe that the Ninth Amendment, in fact, implicit in the Ninth Amendment is a recognition of a right called the right of privacy, not to what extent it applies, but that there is such a thing as the right to privacy.
I think that's in effect asking me to rule on cases. I can say the Supreme Court has held that there is such a thing as as a right of privacy. They
Well,
haven't
I
tied
don't
it.
know
They
about-
haven't tied it to the Ninth Amendment. As far as I know, there's no Supreme Court holding that rests any right exclusively on the Ninth Amendment. They mentioned the Ninth in a litany of amendments from which various penumbras emanate, and
Do you believe
the
that
Ninth
there
was among
is
them.
such a thing as a constitutional right to privacy? Not delineating whether, for example, the right to terminate a pregnancy relates to the right to privacy, or the right to engage in homosexual activities in your home is the right to privacy, or the right to use contraceptives in your home is right, but is in a philosophic sense, is there such a thing as a constitutional protected right to privacy?
I don't think I can answer that, Senator, without violating the line I've tried to hold.
Judge, I don't know how you...
I can tell you that that's what certainly a number of Supreme Court opinions now say.
Well...
But there's somebody may come in and say, just as somebody might come in and say Marbury versus Madison was wrong, that it doesn't exist.
Sure, they may come in and say it, but you
that it
would
shouldn't
not-
exist. I do not want to be put in the position of having I'm sorry, I believe in a right of privacy because I told the committee in connection with
the
its
fact-
considering my nomination that I believe in it.
Well, the
It's a heck
fact
of
you
a-
believe in a right to privacy doesn't mean that that a case before you, in fact, rises to the level of being guaranteed that right. I mean, I think you're being a little bit disingenuous with me here. If, in fact, you conclude that there's an existing right to privacy, that in no way predisposes you to have to rule one way or another about whether or not a right is claimed as being qualified under such a right.
No, Senator, I beg to differ. There has been scholarly criticism of the whole notion of right to privacy.
Well, I agree.
And it's not at all inconceivable that criticism will be reflected in a brief before the Supreme Court. And
Well, that very well may be, but it doesn't, in other words, if the right to privacy exists, if you believe the right to privacy exists, and I believe you have stated in, what was that in the CNN case? Okay, so was that in an article? Excuse me one moment. Pardon me? I believe, and I can't pin down where you said it. It was in an article?
I don't think you'll find
In
it.
the Panhandle article, did you say that that the right to privacy is one of the deepest and most profoundly held beliefs in our society?
I don't recall having said that, Senator.
Oh, I see. I'm sorry, I misspoke. What was being referred to was your answer to me earlier, saying that in order to meet your test, it has to be one of the deepest and most profoundly held views in society. And you always, do you have any doubt the right to privacy is one of those deeply and profoundly held view of American society? Forget the Constitution. Let's just talk politics, you and me.
It's very hard to answer. You began this line of questioning by answering me, never mind what the right of privacy consists of. I can't answer that question without knowing what you mean by the right of privacy.
Sure, you can acknowledge whether or not you believe there is, in fact, let's start over again. Clean the slate. Do you believe that Americans as a whole believe that there is a right to privacy that they have, inherent, that they think they have a right to privacy? Do you think that's a deeply and profoundly held belief by American society? Whether it's found in the Constitution or found in natural law or found in their Bible or found in the Talmud, as a society. I mean, do you have any doubt that Americans believe?
I'll give you that, Senator. I think
Good
that's
man,
right.
I tell you, we're getting there. All right. Now, having said that, do you believe that is there any doubt in your mind that the Ninth Amendment, in conjunction with other amendments as it relates to particular assertions of particular rights of privacy, if I can find the Ninth Amendment here so I don't misquote it. Do you have the Ninth Amendment sitting there? Dig it out for me, will you? Roman numerals confuse me, Judge.
Let's see if
yours
yours
is
is the same as mine. I have one here, too.
All right. I almost read the 11th. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Is there any doubt in your mind that the people, at the time and now, believe they have retained the right to privacy, whatever that means?
No, I think there's no doubt in my mind of that.
Okay. Secondly, if in fact that, well, I don't have to go any further, actually. Because in fact, it seems to me if there, in some form or another, there is a constitutional protected right of privacy. What that means remains to be seen, whether it means the right to engage in homosexual activity in one's bedroom, or anything else remains. I'm not going to ask you to comment on that, but let me, and I guess my time, I know my time is up, but let me pursue this one step further if I may. When I look at your musings on the, and I don't mean that in a derogatory way, because I love to read what you've written. I love the way you go about it. I mean, I wish I had had you in class. I'm probably too old to have had you in class, but you're the kind of guy that I would have liked to have been in class. I could have gotten by with you because we could talk about philosophy. As long as you didn't ask me what the case stood for, I'd be all right. But when I tie your musings on original meaning and original intent, and where I must admit I put you more in the school of the original intent fellas than I do in the living Constitution area. I begin to be concerned about, and then when I take your second stated principle in the Panhandle article, which is basically that if it is a long-held societal view that has been, in effect, recognized through constitutional interpretation, case law, Supreme Court cases, then you would be very reluctant to overturn it. If I read that correctly, or am I putting words in your mouth?
No, yes, I think that's a fair statement.
Okay. Now, the irony of all ironies is that the people who are concerned about you, some who are concerned about you, women's groups who are concerned, not all, pro-choice women's groups who are concerned about you, they are worried you'll use that rationale to overturn Roe v. Wade. That is that, we won't go through it all. Ironically, it seems to me you could read your view as saying, if that hangs in the law another 10 or 15 years, it'd be awful hard. You would, by your own test, have trouble overruling Roe v. Wade. So I guess what I'm asking, without asking about Roe v. Wade, is there a time frame? If it's on the law, on the books, if you will, if it's settled constitutional law for an extended period of time, and the argument to overturn that settled constitutional principle does not, in fact, meet the test of, on its face, being consistent with what the correct constitutional principle is, do you have to stick with what the settled law is? I know that sounds good, but you're making it understandably hard for me because we can't talk about specific cases.
I agree with the statement that long-standing cases are more difficult to overrule than recent cases.
What do you have to find as a matter of constitutional principle to overrule long-standing cases? And I'm not talking about any one case now. Constitutional principles enshrined, it's been there, reaffirmed by cases for 20, 25 years. What do you have to find as a logic to overturn it?
Well, in every case, Senator, you have to find that it's simply wrong, that it's not a correct interpretation of the Constitution.
Okay, that's what we're getting at.
You begin with that.
But how do you...
But as I've said, some cases that are so old, even if you waved in my face a document proving that they were wrong when decided in 1803, I think you'd have to say, sorry, too late.
Oh, 1969.
Well, that's not 1803. All
I really
can
am
say
trying
is
to
that
get a sense of the
time is
time
certainly
frame.
one of those.
What, you know, I mean, when is the wine
It's
aged?
not just I don't want to mislead you into thinking it's just a function of time.
No, I
mean,
don't read it as justifying. As I understand it, if in fact enough time has passed, and notwithstanding the fact you could argue that it was wrongly decided at the time, because it was a overgenerous interpretation of a right recognized but expanded, that if it becomes settled practice, and the argument to overturn it is not that it was an incorrect decision 25 years ago, but that, because it was too expansive, but is the argument required to overturn it that clearly, on its face, they disregarded what was the clear intention of the Constitution? Case in point, Plessy versus Ferguson. That was on the book long...
Can I interrupt the senator from Delaware? He asked the question, when is the wine aged?
Well, I understand.
I would say the wine's time has come.
I understand that, but I appreciate his biting humor. But I thought this was a serious line of questioning. I'll cease and let my...
Well, it's not a question of cutting
That's
you
all right.
off. It's a
No,
question
fine.
that the senator from Illinois has been waiting and...
Senator from Illinois just asked questions. He can ask them again. I have no further questions. Thank you very much.
I thank you, Mr. Chairman, if I'm being recognized. You may, after this most recent dialogue, you may wish to decline to answer this next question on your constitutional right of privacy here, Judge. But following the question that Senator Biden and Senator Metzenbaum, may I ask why you resigned from the Cosmos Club?
The basic reason I resigned, Senator, I think I described earlier how I had first become a member. I used the club a lot. I lived there for 6 months. I used it a lot when I was in Chicago, because when I came up to Washington to testify or to do any other business, which I often did since ad law was my field, I would stay there. I came to use it very, very infrequently when I was a member of the court that I now sit on, which is at the other side of town. So I found I was having lunch there maybe twice a year, and I quickly calculated that it was costing me something like $250 a lunch, which didn't seem to me to be worth the trouble.
It's a pretty expensive lunch.
It is an expensive lunch.
But did you, in part, leave the club because you felt uncomfortable with the regulations of the club?
I would hesitate to say that, Senator. I don't know whether that alone would have done it. I told you that I was uncomfortable at doing something which, although I thought it was perfectly okay, was offensive to friends whose feelings I'm concerned about. But I can't say that alone was the reason.
One other question, and I will be very brief. You made a speech on legislative intent, which you say, among other things, if I were writing on a blank slate, I suppose I would call into question the fundamental premise upon which all use of legislative history is based. And then a little later on in the same speech, you say, as an intermediate federal judge, I can hardly ignore legislative history when I know it will be used by the Supreme Court. Now you will become part of the Supreme Court. Do you still believe if you were writing on a blank slate, you would call into question legislative history completely?
Sneaked in.
Yes, if I could create the world anew, I suppose I still would, but I will no more be able to create the world anew when I'm sitting on the Supreme Court than I could when I was sitting on the Court of Appeals, if I ever get to sit up there. And if the burden of your question is whether I would utterly ignore legislative history on the Supreme Court, the answer is no, I wouldn't.
I have no further questions, Chairman.
Senator Heflin, do you have a?
I only have one or two questions. Judge Scalia, I noticed you smoke a pipe. It may well be that someday you may have to rule on the right of privacy as to whether or not an individual can smoke a pipe in his study or in his bedroom. So I just, I hope that you take care of we smokers one of these days. No, I have no further questions.
I have just one or two questions, Judge. You have already testified concerning your approach to legislative history. What, in your judgment, as just as a general matter, what weight ought to be given to a committee report in identifying the intent of Congress in enacting a legislation in which the report accompanies? I think Senator Grassley asked you about a rather unusual situation, and
Right.
might leave that aside, but just look at it as a general matter.
Senator, as a general matter, I am not as enamored of committee reports as authoritative expositors as some judges are. I may say, by the way, that my view on that matter is not idiosyncratic. There are, my impression is that a number of judges have come to feel that the process has gotten out of whack, that to some extent, because the courts have used committee reports to such a degree, the committee reports are no longer as accurate a device as they used to be. It's sort of the phenomenon of when the cameras go. It's sort of the phenomenon of you're never being able to look at yourself in the mirror and see what you really look like, because you know you're looking at yourself. And it's the same thing with committee reports. Once it was clear that the courts were going to use them all the time, they suddenly became a device not to inform the rest of the body as to what the intent of the bill was, but rather they became avowedly a device to make some legislative history and tell the courts how to hold this way or that way. Once that happens, they become less reliable as a real indication of what the whole body thought it was voting on. That's why I'm sorry if it doesn't please some of the senators, but I just have to say that I'm more suspicious of them than some judges may be.
I raise the matter not merely because of how it reflects on your views as a judge, but it also, I think, could be helpful to us in our committee practices. It's a matter of more than ordinary interest. A case decided by the Supreme Court this term, the Jingles case, Thornburg versus Jingles, turned in part on whether the report of this committee or some remarks on the floor better express the intent of Congress in the Voting Rights Amendments of 1982. And several members of the committee filed a brief, an amicus brief in the issue. Ultimately, the court agreed with us, stating that we have repeatedly recognized that the authoritative source for legislative intent lies in the committee reports of the bill. Now, I gather that you would feel there might be some circumstances in which that much recognition shouldn't be controlling.
I doubt very much, Senator, whether I would not use committee reports at all when I'm on the Supreme Court. But I do think that the view I'm expressing of greater skepticism than has been brought to bear upon them in the past is, unless I mistake my guess, the wave of the future. I think the courts sometimes are beginning to feel that they are being
well, I hope the committee will listen to what you're saying, because I take that as a constructive criticism, and that we could do better on committee reports and be more helpful with them.
It isn't the quality of the report or the work that's gone into them, both of which are fine. The essential ingredient, however, is for the court to know that when the Senate voted on the bill, that's what the full Senate meant. And if there's some way that, that the actual attention of the whole body to that particular item, which very often is such a subsidiary item that one really has to wonder whether the notion that the full Senate had in mind this one statement in a multi-page report, whether that isn't utterly fictional. And if it is fictional, then it doesn't really represent the intent of the Senate when they voted.
I
That's
have
the
to
problem.
agree with you. It's a fairly rare event where the committee itself has any argument over the language of the report. And occasionally it happens where a line is written in or a line is stricken out, but that's, I think, the exception rather than the rule. Now, the subject of judicial activism is one that's important to the chairman. You published an article last year in which you noted the tendency to regard the courts as an alternate legislature whose charge differs from that of the ordinary legislature in the respect that while the latter may enact into law good ideas, the former may enact into law only unquestionably good ideas, which, since they are so unquestionably good, must be part of the Constitution. And you went on to say that every era raises its own particular threat to constitutional democracy, and the attitude of mind thus caricatured represents the distinctive threat of our time. I don't think anybody would disagree that unbridled judicial activism is a bad thing. Certainly Thomas Jefferson believed that. Did you mean to say that it is the distinctive threat of our times? Was a necessary resort under the Constitution to deal with a problem of major proportions, the malapportionment of congressional districts. Well, I'm glad you have put...
You're right, that may have been too broad a statement. In the context in which I was speaking, it's the distinctive threat with relationship to the judicial process of our times. I think if there is one failing, and perhaps in our entire governmental process bearing upon the relationship among the three branches.
And I would agree with the thrust of your remarks earlier today, in which you said that if legislatures were more precise, there wouldn't need to be so much judicial activism. In fact, we invited the one-man, one-vote cases, for example, came about as a result not of legislative imprecision, but rather legislative stalemate on the subject. And it represented a clear example of legislative failure which invited judicial activism, really demanded judicial activism. And in a case in which it apparently was a necessary resort under the Constitution to deal with a problem of major proportions, the malapportionment of congressional districts. Well, I'm glad you have put that characterization into context.
I'm sorry that article's gotten most attention. It's doubtless the, of all my articles, it's the one I'm least proud of. I'm not ashamed of it, but it was a couple of page thing in a rather popular as opposed to scholarly publication. Probably not even very popular, but at least not scholarly.
Well, I have just one more question, and that is on the question of original intent. Very popular subject for articles, lectures, speeches. What is your approach to this rather arcane subject?
Well, it's where I start from, Senator. I think the first step is to, and I use the term original meaning rather than original intent, which is maybe something of a quibble, but
Any more votes?
I think that one is bound by the meaning of the Constitution to the society to which it was promulgated, and if somebody should discover that the secret intent of the framers was quite different from what the words seemed to connote, it wouldn't make any difference. In any case, I start from the original meaning, and I think there's room for dispute as to what extent some of those elements of meaning are evolvable, such as the cruel and unusual punishment clause. The starting point, in any case, is the text of the document and what it meant to the society that adopted it. I think it's part of my whole philosophy, which is essentially a democratic philosophy, that even the Constitution is, at bottom, a democratic document. It was adopted by the people's acceptance of it, by their voting for it, and its legitimacy depends upon democratic adoption, either at the time it was enacted. Now, some of its provisions may have envisioned varying application with varying circumstances. That's a subject of some dispute and a point on which I'm quite wishy-washy. But I'm clear on the fact that the original meaning is the starting point and the beginning of wisdom.
Well, my time's up, but the chairman indulged me just to finish that question. What happens if the starting point is zero? For instance, the whole range of public school issues are beyond any scope of the founders' original intent because there wasn't a public school system. And so many of the public school questions that have come before the court couldn't have been precisely forecast by the founders, because you're talking about a whole institution that has been invented since their deaths.
On those types of issues, Senator, that where the law has to be applied to circumstances that just didn't exist at the time, you obviously have to decide as a judge what resolution would most comport with the application of that clause to the circumstances that did exist at the time. You try to make it fit.
Thank you very much, Judge Scalia. Thank you, Mr. Chairman.
Distinguished Senator from Illinois.
I have no further questions. I would appreciate if we keep the record open, and if the judge would not mind if any of my colleagues have any questions they want to submit in writing, that we include that in the record.
Thank you, Senator. Without objection, we'll do that. See, today is how long do you want to keep it open, Senator? Thursday?
If we could keep it open, but today is Tuesday. Yeah, how about keeping it open till Friday?
Friday?
Friday.
All right, your request, we'll do that. We'll keep the record open for any questions that any member of the committee wishes to propound to Judge Scalia until Friday. And Friday, say at 4 o'clock, would that be satisfactory?
Fair enough.
And any member who desires to submit questions by 4 o'clock Friday, it'll be agreeable. Judge Scalia, I want to commend you for the way you've handled yourself in this hearing. I think you're one of the best qualified men that's come before us to be a judge on Sacred Court or Supreme Court. Your successful law practice, professor of law in 4 different law schools, at least in 3, and then I believe you're a visiting professor at Stanford. And I've been impressed that you possess the qualities we need in a judge. An excellent judicial temperament and the other things I mentioned this morning. I think you will be able to assist the other judges on the court, too, in arriving at a consensus. I have a feeling that you're not only a good musician, but you're a persuasive talker. And with your great legal knowledge, I think you'll be able to help with a consensus. You have a reputation for being a hard worker, a man of great analytical skills, sound judgment, congenial personality, and all of these qualities I think will be of great benefit to you on the highest court in our land. The American Bar Association has found you well qualified. That's the highest rating they can give you. They'll be testifying tomorrow as the first witness tomorrow. But I just want to say to you that we are fortunate, I think, to have a man like you to be appointed to the Supreme Court, and I commend President Reagan for appointing you. And I wish you well on the bench, and I'm sure you'll have a successful tenure. And I don't think it'll be necessary now for you to come back anymore. If so, we will let you know. You're welcome to come back tomorrow. Some other witnesses, some for you and some against you if you want to be here, but it won't be necessary.
Thank you, Mr. Chairman. May I thank the committee for its courtesy, and I have genuinely enjoyed being here.
I have nothing further.
Staying Senator from Illinois, do you have any comments?
I have nothing
you want to
further,
make this
no.
time? Staying Senator from Maryland, do you have any comments?
Mr. Chairman, I join with you in congratulating Judge Scalia on a very fine performance before this committee. We've seen a good many judicial nominees who have come here, and I don't think any of them have surpassed Judge Scalia in the manner in which he has addressed the questions and the kind of thoughtful responses that he's given to the committee. And as I suggested a minute ago, some of his comments may be helpful to us in the conduct of our own business. So we appreciate your being here.
Senator.
We will begin at 10 o'clock tomorrow. And after we get through with the American Bar Association, we're going to allow 3 minutes to the other witnesses, and we want to finish this hearing tomorrow. We now stand in recess until 10 o'clock tomorrow.
Had to go to open up the Senate and has asked me to chair in his absence, and we'll proceed at this time. The current witnesses are representatives of the American Bar Association, Mr. Fisk, Mr. Lafitte, and Mr. Lane. And we will proceed at this time. And Mr. Fisk, if you will start.
Good morning, Senator Specter. My name is Robert B. Fisk, Jr. I practice law in New York City, and I'm chairman of the American Bar Association Standing Committee on the Federal Judiciary. With me today are 2 other members of our committee, John D. Lane of Washington, D.C., and Jean W. Lafitte of New Orleans, Louisiana. I should say that during the time that the investigation of Judge Scalia went forward, I was engaged in a major trial in New York, and I'm very grateful to Mr. Lafitte, who undertook to coordinate and chair the investigation that was conducted of both Justice Rehnquist and Judge Scalia. And of course, Mr. Lafitte did present the position of the committee to the Senate Judiciary Committee last week on Justice Rehnquist. Mr. Lane is the circuit member from the District of Columbia who conducted the principal part of the investigation on both Justice Rehnquist and Judge Scalia. We appear today to present the views of the American Bar Association on the nomination of the Honorable Antonin Scalia of Washington, D.C. to be an Associate Justice of the Supreme Court of the United States. At the request of the Attorney General, our committee investigated the professional competence, judicial temperament, and integrity of Judge Scalia. Our work included discussions with more than 340 persons, including the justices of the Supreme Court of the United States and many other federal and state judges across the country, a national cross-section of practicing lawyers, and a number of law school deans and faculty members, some of whom are specialists in constitutional law and scholars of the Supreme Court. In addition, we have had Judge Scalia's opinions reviewed by a team consisting of the dean and law professors from the University of Michigan Law School, by a separate team of practicing lawyers, and also by 3 students who were working in the office of one of our committee members during the summer. Finally, 2 members of our committee, Mr. Lafitte and Mr. Lane, interviewed Judge Scalia. Based on our investigation, the committee is unanimously of the opinion that Judge Scalia is entitled to the committee's highest evaluation of a nominee to the Supreme Court, well qualified. That evaluation is reserved for those who meet the highest standards of professional competence, judicial temperament, and integrity. Persons in this category must be among the best available for appointment to the Supreme Court. I filed with this committee yesterday a letter describing the results of our investigation and will not repeat those results in detail here, but I do request that the letter be included in the record of these hearings.
The letter will be made a part of the record without objection.
Thank you, Senator. To summarize our findings, Judge Scalia has an outstanding academic record and has demonstrated strong abilities in his service as a practicing lawyer, a teacher of law, and as an appellate judge. Our investigation has shown him to be extremely intelligent, analytical, thorough, hardworking, and devoted to the legal profession. His writing and analytical skills are widely acclaimed. The diversity of his experience as a practicing lawyer, as a law teacher in 4 of the outstanding law schools of this country, and as a federal appellate judge, provide a valuable background for a justice of the Supreme Court. Notwithstanding isolated expressions of concern, our investigation revealed that Judge Scalia has an outstanding judicial temperament and that he is well suited for service on the Supreme Court from that standpoint. He enjoys the respect of his colleagues both on and off the bench for the soundness of his judgment and his congeniality. His integrity is above reproach. In conclusion, the committee, by unanimous vote, has found Judge Scalia to be well qualified to serve as an Associate Justice of the Supreme Court of the United States. Thank you very much.
Thank you, Mr. Fisk. I note from your report at page 3, you state that you interviewed a cross-section of the legal community, including women and minority lawyers. How many of the 340 persons interviewed came from the category which you label as, quote, women and minority lawyers?
I'm not sure I'm in a position to give you a precise number, Senator, and perhaps if you would like that, I will go back through the detailed interviews that we have. But the way this investigation,
I think the committee would be interested in the specifics, but can you give us an approximation at this time?
If I could say, Senator, just so you understand the way this process worked, and then I think I will be glad to answer the question. What we did right from the beginning was, as you know, we have a member in every judicial circuit and 2 in the Ninth Circuit. And what we asked each member to do was to go out in his or her circuit and conduct interviews with the federal circuit judges in that circuit, the Supreme Court, the judges of the highest court in the state courts, Also, leading lawyers, the presidents of the bar associations in the circuit, and also, of course, deans and members of the faculty of the leading law schools in the circuit. So we had a fairly standardized approach within each circuit, which each circuit member then implemented. And then what we have done in the letter is try to pull together the results of some 13 or separate investigations of that nature, and that's where we get the number that appears in this letter.
Well, I understand that, Mr. Fisk, but since there's been a question raised as to the issue of women, minority interest, that's why I'm directing the question specifically to get some idea for the committee as to how many or what proportion comprise the women and minority lawyers.
Well, again, I cannot give you a precise number because I haven't gone
Well, I
back.
understand you can't give a precise number. Can you give an approximation?
Yes, but I would say more than 10%. But that is a rough judgment.
The report that you have submitted speaks very, very glowingly of Judge Scalia, and as does your summary here this morning. There is one comment at the bottom of page 3, quote, "There were isolated expressions of concern or objections about a lack of open-mindedness or the reasoning in his opinions." In order to give as full a picture as possible with any qualification being limited, as I read your report, to that single sentence, would you please expand upon that
Yes.
and focus particularly upon, first, how isolated were the expressions of concern?
Well, first of all, Senator, as you probably noted, that sentence appears in the section of our letter that is headed Interviews with Lawyers. And this does refer to isolated expressions of concern that came from people within the group of about 80 lawyers that we interviewed. I would say, again, I would say it's a handful, probably not more than 5 at the most. And it came primarily from people who had argued cases before Judge Scalia who felt, I remember 1 or 2 comments to this effect, that during the argument they felt that he had a position that he was expressing through questions that he was asking, and these were people who had lost the case and who felt that perhaps he'd made up his mind and didn't really come with a full open-mindedness to the issue. I really should emphasize, though, that we used the word isolated very carefully. We searched for a word that we thought was appropriate to try to quantify that type of objection, and it really, I think isolated is the best word we could come up with, because overwhelmingly the sentiment of lawyers was to the contrary.
As to those isolated expressions, was their conclusion that Judge Scalia was qualified to be a Supreme Court justice nonetheless, or were their objections sufficiently strong, at least in their own minds, so that they opposed his confirmation?
I don't remember any lawyer that said he felt so strongly about it that he didn't think Justice Scalia should be on the Supreme Court.
Senator, if I may supplement Mr.
Yes, please do.
Remarks. I think there were a couple of lawyers who did indicate objection to the appointment based on, in one case I recall, judicial philosophy, another case because of prior opinions, without any explanation as to what in the prior opinions was the problem. But I do recall those in response to the Senator's question. I certainly share Mr. Fisk's comments concerning the isolated nature of these objections or concerns, though.
Going on to the top of the next page, where you have the category of interviews with deans and professors of law, you say, quote, "Again, there were isolated expressions of concern about his strong conservatism or lack of open-mindedness." Can you quantify there the number of those who expressed those concerns?
Again, I would say it's less than 5, Senator. It's out of 60. Out of the more than 60 that we interviewed, it's less than 5. Probably 2 or 3.
I think it would be helpful to the committee, Mr. Fisk, if you would be a little more specific on that. If you could give us precise numbers, I think there's some who would be interested in it. And as a matter of future report writing, at least speaking for myself, where you have some expression of concern, the more specific you can be, the more helpful it is.
Well, I'll try to get you the exact number, but I'm quite confident it's in the vicinity of 2 or 3.
As to those isolated expressions of concern, did any rise to the height of objecting to the confirmation of Judge Scalia?
Again, I don't recall anyone that would have opposed his confirmation on that basis.
So what you're saying is that on the total of these 340 persons interviewed, that although there were some isolated expressions of concern, that no one opposed his nomination to the Supreme Court?
Well, no, I would qualify that only to the extent that Mr. Lafitte did a moment ago, that there were perhaps two or three out of the 340 who felt that because of positions he had taken in some of his prior opinions or because of his judicial philosophy, he should not be appointed to the Supreme Court. But as you well know, our analysis does not really get into the question of judicial philosophy. But on the issues that we look at, integrity, professional competence, and temperament, I would say that there are, as I would say again, less than a handful of the 340 that would have opposed the confirmation.
Your analysis does not get into the issue of philosophy, but that is brought up by others on their own.
Yes, it's quite often gratuitously volunteered.
All right, thank you very much, Mr. Fisk, Mr. Lafitte, Mr. Lane. Senator Heflin had arrived first, and I think the chairman had announced the policy of moving through the sequence and order of arrival by the senators, so we'll turn to Senator Heflin at this time.
I suppose Mr. Lafitte and Mr. Lane,
Who arrived second?
I'd like to know about your interview with Judge Scalia. How long did your interview last with him?
I think about an hour and a half, Senator.
What was the scope of your interview? What did you cover in your interview?
Well, we discussed some of his ways of proceeding on the court, that is, how he functions in the appellate court that he now serves, how he uses law clerks, how he writes opinions, that kind of thing. We discussed, actually the discussion, as is usually the case, was rather wide-ranging. We discussed something briefly about his personal life. We talked about, of course, the concerns that had been, that we had heard, and received his responses to those matters. I think we talked some about his early life. Those are the things that come to my mind, Senator Heflin. And as I say, this is usually the kind of discussion we have with the candidate for the federal judiciary.
Did you go off into issues, we'll say, like federalism or civil rights or women's rights, or did you discuss any of the, in effect, contemporary issues of the day, judicial issues?
Well, I certainly encourage Mr. Lane to amplify my remarks, but we did raise generally those issues because they had been suggested to us as matters that might affect his judicial temperament, because there had been expressions of concern about his open-mindedness with respect to such matters. So we talked in general terms about them.
Did you talk, like, say, covering the issue of freedom of press, some of his decisions in those type of issues?
I don't think we discussed them specifically.
No.
I think we raised the First Amendment cases as a matter of some concern that had been voiced, but just in general terms.
I was merely to add the fact that we did mention First Amendment concerns that have been raised with us. See, one of the purposes of this type of interview is to give the candidate an opportunity to explain to us his or her side of any issue that may come up in the course of the investigation.
Well, was he open, candid with you? Did he discuss these issues, go into it in some detail, explain his position?
To be, as best I can recall, none of this discussion was very lengthy. He was open. He was very relaxed and very friendly, and I think readily responded to any of the questions that we put to him.
Was he elusive or evasive on any
Not
of it?
at all,
Senator.
Not at all.
Did he attempt to, in an effect, in your discussions with him, decline to answer any questions on the basis of the fact that it might interfere with his future as a potential member of the Supreme Court, and that it might, his discussion of the issues with you might in effect be considered as some sort of a prejudging or prejudicing his mind or something to discuss it?
No, I think, I'm trying to recall, I don't recall, Senator, questions that were so specific as to give rise to that kind of a problem in his mind, but he was very open with us and responsive to us as we talked about these concerns. And I think it's fair to say that his reaction was that, you know, one can always understand how there are people that will differ with one's decisions on issues of this kind, but that, in effect, he just does his best as a judge to come out where he thinks the law takes him.
Well, I think Judge Scalia, of course, from everything I know about him, is a very fine individual, fine jurist, a brilliant mind, everything else. But yesterday in our discussions and the various questions that were asked of him, I ended the day with some sort of a sense and feeling that he had been elusive, evasive, and had in an effect perhaps overly hidden behind some concepts of separation of powers, or on the fact that he might have prejudiced himself in answering questions. Now, I don't want to be unfair to him in any way, but I did come away with somewhat of a feeling that he didn't answer things that perhaps I thought that he should have answered, and that I didn't think that the potential position of being on the court necessitated his protective attitude over future writings or future decision making that he might have. Was there any of that relative to your discussions with him, or was he completely open?
Senator, I'll let Mr. Lane answer for himself, but I found him completely responsive. I do not recall any question that we asked him that he indicated he would rather not answer, or that he thought he should not answer. I don't, and my sense certainly was that he was completely open with us and forthright, and very articulate in responding to our questions.
I think so the record will be clear here, we did not try to press him on important issues of the day, and we did not try to find out how this man would vote on these important and difficult issues. I think we were sensitive to the problem, and I think we are also understand and sympathize with the problem you have in making your judgment in the process of confirmation. I think it's a difficult problem for the committee, and it's a difficult problem for the candidate. It's one that we really didn't try to press him in these areas, as the committee did yesterday.
Well, it is very difficult, and it's a task doing it that I couldn't help but, on the basis of Associate Justice Rehnquist and his answers, I thought he was much more open and gave more answers and relative to the matters than Justice Scalia, than Judge Scalia did. So, it is a task. It's, of course, you got a line to draw, and maybe we are more protective of our role in the advice and consent, and maybe he's more protective of his role. But I did have that feeling. I just didn't know whether or not it might have been, or whether or not from the Rehnquist hearings to the Scalia hearings, there might have been some coaching. That's all.
Simon. Thank you, Mr. Chairman. I would just note that after listing many virtues, and obviously there are significant virtues, the interviews with the lawyers, with the deans and professors, and the students all list this one concern they have of lack of open-mindedness. We can all learn from our critics, and if Judge Scalia is viewing this or reads a transcript, I hope perhaps he can note that. I would just lobby Mr. Fisk, whom I've lobbied before on this, but I'd like to do it publicly. I would encourage your Committee on the Federal Judiciary, and this has nothing to do with the Supreme Court nominees now, but goes back to our earlier conversations, that the Bar Association lift its standards for approval for federal judges. It is something I think we can do in this nation. We have 640,000 lawyers. I think we can find some of the very finest for the federal judiciary, and I think the American Bar Association Committee can play a very important part in that.
Well, Senator, I would respond publicly, as I have to you privately in our earlier discussions. We believe this committee has high standards. They're set forth in the public document that we call our backgrounder. The individual members of the committee don't always agree on every candidate with respect to how that candidate measures against those standards. We get divided votes among our committee with respect to the qualifications of the candidates. But we certainly, one of the reasons we have separate ratings, exceptionally well qualified and well qualified, in addition to a basic rating of qualified, is that we hope that the administration will propose as many people as possible who fall into those higher categories of ratings, which by our own definition means that we, the committee, find them to be among the best available for appointment. And we rejoice, as you would rejoice, every time we are able to find a candidate well qualified. We'd like to see all the candidates well qualified or exceptionally well qualified.
Well, let me just, in response, as you and I have carried on conversations before, I think you have to be not too sophisticated in dealing with members of the United States Senate in terms of that we should get a message when someone doesn't come in extremely well qualified or well qualified, if they come in with a mixed qualified, not qualified rating. I think somehow you have to devise a system of a stronger signal to the members of this committee and to the Senate that people aren't in the top categories. We've carried on this conversation before, but I would simply urge you once again to review how you handle this to see if we can't do a little better job.
We will, Senator.
Thank you, Mr. Chairman.
How about Spector's here? Staying Senator from Massachusetts.
Thank you, Mr. Fisk. I want to underline what Senator Simon has just outlined here. I think all of us find useful the kinds of evaluation that the Bar Association does in terms of professional competency and the judicial temperament, the basic integrity of various nominees. But quite frankly, you were up here with regards to Justice Rehnquist, talking about those qualities, and you didn't really comment about the whole question of the Laird versus Tatum and the judicial ethics about ruling on that type of case, whether you people felt that was important, whether you thought we ought to explore that issue. You didn't come to our committee and indicate that it would be important for us in making our judgment that we gain certain information in terms of his work in the Office of Legal Counsel, or helpful. I didn't hear anything from you people with regards to the whole question of executive privilege, whether you felt in terms of our function and the availability to provide good information to the United States Senate and the American people in meeting our responsibilities, whether we should have that information or not have that information. I was here when the Bar Association came up here and recommended Carswell. And that would have been a travesty to the Supreme Court of the United States. And yet you recommended him as qualified. He met the particular standards. You know, he could write a good legal brief. Nobody was complaining too much about him in the back room. And I think in terms of the relevancy of the ABA, and the American people have to put a good deal of confidence in the organization. I quite frankly felt that we all knew that Justice Rehnquist could write a good legal brief and was #1 in his class at Stanford Law School. And you reiterated that. But we went through 2 hard, difficult days in trying to make some help this institution, help the American people to understand better what this whole process was about. And in looking back on the testimony that you people gave with regards to Rehnquist, I don't think that you really helped one bit on that issue, if I could be perfectly blunt about it. And now we have it with regards to Judge Scalia, and I'm quite prepared to, get on with other kinds of witnesses. I don't think anybody has doubted or questioned that he is an enormously able and gifted and talented person on it, but the kinds of issues that Senator Heflin was talking about, the kind of criteria, what we ought to be able to expect in terms of responsiveness of a witness, I think you ought to be helping us, helping the American people, trying to help establish what should be able to be asked. And the American people then understand whether we are probing into his mind in terms of potential future cases, or whether we have a legitimate right to understand these questions. You people have professors, access to people who can have the luxury of spending some time and can help us on these kinds of issues. And I think you probably gather, at least from some members of it, the fact that, I for one am glad to have you come by here and make these statements, but I think, as others have expressed, if going to be relevant at all with regards to various appointments, I think that you've got to be able to be a good deal more comprehensive in terms of what you're going to observe and what you're going to comment on.
Well, Senator, I would like to make an initial response, and then Mr. Lafitte, who was here last week presenting the committee's position with respect to Justice Rehnquist, will, I'm sure, have something further to say. I think it's important, I'm sure you do understand, the basic function of the American Bar Association when it comes to passing on the qualifications of judges. We view our principal responsibility to bring first to the Justice Department for their consideration, and then secondly to the Senate for its consideration, the result of our analysis, which is basically going out and getting the views of the person's peers at the bar and on the bench. People who have practiced with the particular candidate, judges before whom the candidate has appeared, lawyers that have litigated with or against the candidate. In the case of someone going to the Supreme Court who is a sitting judge, what law professors in a leading law school think as professors of the quality of the candidates or the judges' writing skills. We basically look, Senator, as you I believe you know, at professional qualifications as reflected through the views of the people that we think know the candidate best, who
Can
are the
I
people.
ask then the question, do you still say that Carswell was qualified?
Senator, none of us were on the committee at that time. I think.
Well, I mean, he wrote well, you know, he evidently gone through the various process. I haven't read anything from anybody that's saying that we missed one on that particular case. And I've seen nothing on the ABA that says we missed it. We ought to review our process. We ought to review our system so that we can be more helpful to the Senate Judiciary Committee, where we have 1,000 different issues on copyright, on judicial nominees, on civil rights, civil liberty issues and questions, and saying, look, we missed one on that. What has been wrong? Why can't we have a different criteria? How can we review our whole recommendation?
Senator, I would disagree with you to this extent. My understanding in reviewing the history of the committee is that the committee did go through a major restructuring of its procedures for investigating Supreme Court nominees following the Hainsworth and Carswell incidents back in the late 60s or in early 70s. And the type of process that we have gone through that is reflected in the letter that we submitted here, where we talked to more than 340 people around the country, was specifically designed to try to uncover, or have a procedure that would be designed to uncover some of the things that apparently were not uncovered in the case of Justice Carswell. But I'm talking secondhand on this. I'm just talking what I've been able to learn from my review of the committee's history.
One of the things that you missed was the membership, for example, at Carswell and various clubs that were not open and that were restricted. And now we've had those same kinds of things right back here with Justice Rehnquist. You missed it last time, and you missed it this time.
Senator,
the only thing, I just mentioned, is that you give a very broad recommendation that has to impact the American people. It does the members of the Senate. We've all heard the last time. A broad recommendation, and it seems to me that the areas in which you examine are limited in terms of the total kind of requirement that we have meeting our responsibility. It's always of some use.
Well, I think, Senator, some of the things that you put to us a minute ago may be beyond the proper scope of our committee's functions.
Well, don't you think that would be useful to mention when you say we find well qualified that we're talking about just very, very limited areas on this? Rather, you don't find a distinction between saying that the American Bar Association, which has a very profound and significant reputation, and in many instances well-deserved among lawyers and among the American people. When you come in with a broad kind of mandate and you're only looking at a rather limited area, I think it is something that, in terms of a responsible organization, you ought to distinguish.
Well, Senator, I think we make it very clear in the second paragraph of our letter that the committee's evaluation of Judge Scalia is based on its investigation of his professional competence, judicial temperament, and integrity. We go on to say, consistent with its long-standing tradition, the committee's investigation did not cover Judge Scalia's general political ideology or his views on issues, except to the extent that such matters might bear on judicial temperament or integrity. And I would say that the question you raised that relates back to what Senator Heflin was asking about whether the extent to which Judge Scalia should or should not have taken positions yesterday here before this committee on matters that may come before the Supreme Court are covered by ABA canons, and there are ABA canons that say that a judge should not publicly take positions. And we have made that clear to this committee in the past that that's our view.
The question, I suppose, is when you come down hard on the issues of integrity, I suppose there were some questions here. Certainly Mr. Brosnahan with regards to Rehnquist, Mr. Smith, another person in that old voter harassment situation would raise serious questions about that nominee on that very issue.
I've been trying to I think those are legitimate questions, but I do think you need to understand the circumstances. You mentioned two incidents. One was the Tatum v. Laird case, and the other was the Phoenix voting situation and the executive privilege issue. Now, our investigation was completed many days, and our report was made to the Department of Justice many days before the issue of the Phoenix voting matter ever was raised in the media. Now, I understand it was raised in the first hearings, of course, but But the coming forward of additional witnesses occurred after our report was completed. Now, our feeling was that those people, we understood, were going to be here to testify. If there was something else, of course, this committee wanted us to do in terms of integrity or temperament, naturally we'd be happy to help any way we could in that respect.
Point is...
May I just finish,
Sure.
Senator? The other thing is the Tatum v. Laird issue, which, so far as I know, came to light on the Monday morning of the week that I came up here. It certainly was not anything that came to light in the investigation we did, and that was the case also of the Phoenix voting matter. There again, our Justice Rehnquist's position was, as stated in his opinion, denying the motion to disqualify. There again, we are pleased to provide any service we can if this committee wants us to do additional work. But the point is that those matters arose after our investigation was completed and we had reported.
I think that comment really indicts your own kind of investigation. The whole question about the harassment of voters was a part of the record the last time that Justice Rehnquist appeared before this committee, and it only came up after that. So this isn't any surprise. This is a question that reaches the issue of integrity, and no mention was made about that. You were really of no help to this committee on that issue, as I understand it. It wasn't even referenced in your statement. I may be wrong, but you didn't even raise that. Now, on the Laird versus Tatum, someone in that Bar Association ought to read the McKinsey's book on that, and the chapter on that very case that was printed in the 1970s. We all had the chapter on that. Why didn't the Bar Association have it? That isn't revolutionary, for Pete's sakes. McKinsey is a distinguished writer in the New York Times who writes about the Supreme Court. And I got one staffer that was able to find that. It seems to me, with all of the team that you've got, you ought to be able to raise that, at least bring that as a matter. It's a subject of a good deal of inquiry here. And for you to say, well, you didn't know about that till you came on here before this committee is difficult to... Well, I've made the point.
In our investigation. It was not raised to us as an issue. And therefore not something we really reviewed before we came here.
Well, I would take the time, but you're not the nominee on the whole question about whether it should have been or shouldn't be an issue in terms of recusing, but that isn't what we're about here. Thank you, Mr. Chairman.
Senator, if I may add, may I further respond to Senator Kennedy?
You may respond. Go ahead.
Just briefly. Senator, I think that once we saw the voter rights thing coming up again in these proceedings, it was at least my judgment that this committee had subpoena power and had the ability to get these witnesses and has access to FBI reports. And we really don't have the capability of getting as deeply into an issue like that as you can. And we're not perfect. You know, we can't do all of the work of this committee. And although I've only been on this committee for 3 years, I want to tell you that I've been impressed with the dedication and the hard work of the members of the committee, and I've enjoyed serving with them. I think they do make an effort to help. We do not get these candidates. We have no role in the selection of who's to be nominated. They just give us a name, and we go forward, and we do the best we can.
You've been a great help to our committee.
Well, thank you, Senator. I appreciate that.
In addition to your investigation, the FBI investigates each person appointed. The Judiciary Committee, and we have majority and minority investigators investigate the man. For the record, I just thought that ought to be shown. Staying with Senator from Utah.
Thank you, Mr. Chairman. I think it should be shown that both the majority and minority has every right to investigate here. That's our job. We're paid for that. How much are you fellows paid for doing your job?
You could put it in negative terms.
You're paid in negative terms. This costs you time.
You asking them their salaries, or?
No, I'm asking them how much they're paid for performing this public function, this public service. That's what I'd like to know.
I think,
well, why don't I ask the question? I didn't interrupt you, Senator. I have a feeling all of you have given pro bono services, as most attorneys do, for the poor and those who are afflicted. Now, I'm asking you just for the benefit of the public at large, so everybody understands what's going on here.
I think you should know, Senator, that all of us volunteer our time.
I know that. I want the public to know that.
And
I want them to know how much time it takes to do something like this, and then to come here and get attacked for doing it. Because you're not into every case that's involved in this matter. They have a right to ask any questions they want. We can keep these hearings going, I guess, forever if we want to do the work to do it. But the fact of the matter is you have a particular responsibility. You do it voluntarily. You take time from your business and your office. It costs you money to do it. And frankly, you're doing it because of the love of the law and the love of the Bar Association and the love of integrity and justice in this country. Would that be a fair summarization?
I think you put it very well, Senator.
I thought so, too.
We couldn't do better, sir.
I'd even agree with that, or...
I knew I'd get Kennedy to agree with me on something before the session.
I think
now, if you'll just agree on Rehnquist and Scalia, it would show what a great man you really are. Yes, sir.
I think to quantify it, I think it perhaps would be of interest to this committee to know that in a typical investigation that is done by one of our circuit members of a candidate, that investigation can take as much as 2 weeks of the committee members' time to complete. As chairman of the committee, I can tell you that I've spent 300 to 400 hours a year on the work of this committee.
I won't ask you what your hourly billings are worth, but I know they're worth a lot of money. So that's a lot of loss of your own business to do it for these purposes, and I think you deserve commendation. I have to admit, I've been fairly critical of some of the evaluation process in the past, and this has been a wonderful experience for me to see you three gentlemen and to discuss it with you and hear you testify and see how exhaustively you go into these matters and how you do it for the right reasons. Now, I can't say I've always agreed, but on the other hand, I have a lot of respect for what you do. Let me just ask you some questions. Is it correct, Mr. Fisk, that well qualified is the ABA's highest rating for a Supreme Court nominee?
Yes, it is, Senator.
And that is the rating that you've given to Judge Scalia here?
Yes, sir.
There is no higher rating that he could get for this nomination. Is that right?
That is correct.
Now, could you tell us how many deans and law professors your group interviewed in your evaluation of Judge Scalia?
More than 60.
So you went to more than 60 deans of law schools and law professors. Is that correct?
Yes. The procedure, Senator, was that within each circuit, as you know, we have a member from each circuit.
Sure.
That circuit member went to the dean and prominent faculty members in each of the leading law schools in his or her circuit to obtain their views on Judge Scalia.
And am I correct, they were virtually unanimous in support for Judge Scalia?
Yes, sir.
Now, these are the academically learned in the law in this country, is that right?
Yes. We also had his opinions reviewed by the dean and a group of professors at the University of Michigan Law School.
I see. How many opinions did they review?
Well, he had 107 published opinions. They reviewed all of them, and I believe there were another maybe 60 or 70 unpublished, and I believe they reviewed a representative cross-section.
So they virtually reviewed all of his opinions? And I take it you then sub-reviewed those opinions as well, in your, or at least members of your committee did in your review?
We had two separate reviews. We had one by the University of Michigan dean and law professors, and we had a separate review conducted by practicing attorneys in a major law firm. And they both came to the same conclusion.
What conclusion was that?
Well, they both spoke very highly of Judge Scalia's writing ability, his intellectual capacity, his ability to analyze legal issues, his ability to clearly and lucidly state the issues in the case, and the reasoning process by which he arrived at a decision.
Sounds like he might make a terrific justice based upon those qualifications.
Well, that's the conclusion our committee came to, yes, sir.
I see. Now, how many federal and state judges did you interview?
Approximately 240.
240 federal and state judges?
I'm sorry, about 200. There were 340 persons interviewed together. Altogether, about 200 of those were federal and state judges. What we tried to do was, again, on this nationwide basis, circuit by circuit, we tried to go to the chief judge of the highest court in every state in the country and in addition to the Chief Judge of the Federal Circuit
In other words, you went to
Courts.
the Chief Justice of every state in the country, or tried to.
Yes, everyone that we were able to
So
reach.
the top justice at the top courts, state courts, in every state of this union.
Everyone that we were able to reach in the
Right.
state courts and in the federal courts. We went to the chief judge of each of the circuit
see.
courts of appeals and each of the federal district courts throughout the country, and also representative other circuit judges throughout the country.
And they were virtually unanimous in supporting your opinion.
Yes, sir.
How many how many practicing lawyers did you interview?
A little more than approximately 80.
80 practicing lawyers, a lot of whom are practitioners before the Supreme Court?
Yes, and a number who, another thing we did, we picked what we considered to be a group of 25 of Judge Scalia's more leading opinions, and we made a list of the lawyers that had appeared
So you
before.
went to both sides, those
Yes.
who won and those who lost.
We tried to find, we always, in all of our investigations, one of the important things we do with respect to any sitting judge is we always go to lawyers that have lost cases before that judge.
And what was the consensus of the lawyers?
Well, the consensus of the lawyers was, again, they had the highest praise for Judge Scalia's judicial competence, his temperament, and his integrity.
Well, as I see it, you've made an exhaustive study, and you've done it for the good of our country. It was a nationwide study. You interviewed 380 people from every state in the Union. And virtually everybody said he would make a terrific Supreme Court justice.
Yes, as our letter indicates, and as I said earlier, there were isolated expressions of concern, but the overwhelming consensus was extremely high a degree of enthusiasm for Judge Scalia.
Well, I don't know who could be nominated that there wouldn't be some modest expressions of concern, no matter who would be nominated, no matter how great the reputation, it seems to me. But I think that your report stands Judge Scalia in very good shape, and I just want to personally tell you that, yes, I've been critical of this process from time to time, but having sat through these last two hearings, Justice Rehnquist and now Judge Scalia's, and listening to you, I have changed my opinion. I think you deserve the highest praise, especially in these two instances, for what you have done, and I can't see any way that there was any politics or partisanship or preferences or any other kind of an approach that could be criticizable under the circumstances. You are not the United States Senate. It is not your job to go into every last detail concerning his life, nor do you have investigators to do this with. You do this voluntarily, and I just want to personally compliment you and tell you you've done this committee a great service, the United States Senate a great service, and I think the country a great service. So I just want to thank you for it publicly.
Thank you, Senator.
Distinguished Senator from Ohio.
I see the members of the Bar Association here again, and I don't want you to go away feeling too good about those praises that my distinguished friend on the far right was talking about. The far right was saying that the American Bar Association really wasn't anything to be particularly paid attention to when you gave the rating, the very lowest possible rating, to Judge Mannion when he was up for confirmation.
Well, that wasn't the lowest rating at all.
Oh, yes,
he got a
gave him-
qualified rating. He
Well,
could have
they
had
gave
an unqualified rating.
Gave him the lowest possible rating that could be affirmative, which was a majority qualified and a minority unqualified. But it's just a question, I suppose, of which day of the week it is, as to whether you love or hate the American Bar Association rating system. Are you going to let me go ahead? Are you going to let me go ahead?
Under President Carter, we approved 3 who had unqualified ratings.
Senator Nussbaum has the floor.
Well, he
Order.
One of the things that particularly concerns me about your report, thank you, Mr. Chairman, is this emphasis about a lack of open-mindedness. And hasn't been discussed here today, although I didn't get in at the opening of the session. But when you had interviews with lawyers, you said there were isolated expressions of concern or objections about a lack of open-mindedness or the reasoning in his opinions. when you had interviews with the deans and the professors of law, again, there were isolated expressions of concern about a strong conservatism or a lack of open-mindedness. And when you took a survey of Judge Scalia's opinions, I'm reading from you, 3 summer law students who also reviewed his opinions expressed concern about his open-mindedness. Now, that's about all you say about it. Did you inquire further? Did that concern you, that that same word seemed to come up in each instance, regardless of which group you were speaking to?
Senator Metzenbaum, Senator Specter asked earlier questions with respect to the very issue that you've just raised, and I would like to respond again. First of all, I think the word isolated was a word, as I told Senator Specter, that we arrived at with some care after trying to quantify the number of expressions of concern that we had. And in each category, that is from the deans and the law professors and also from the lawyers, the number of such expressions of concern in each case was, I would say, less than 5 out of the total. So the overwhelming number of people who commented on Judge Scalia, both from the academic side as deans and professors, and from the practicing side, the lawyers, the overwhelming number of those were strongly enthusiastic about Judge Scalia and did not have a concern about open-mindedness. But in order to present the complete picture, we wanted to make it clear that there were in each case a few lawyers and a few members of academia who had expressed that type of concern. With the lawyers, one or two comments were made to that effect by lawyers who had argued cases before Judge Scalia and who had formed the impression during the oral argument from the way Judge Scalia was asking questions that Judge Scalia had come into the argument with a preconceived position that to them reflected a lack of open-mindedness. And I think as Mr. Lafitte...
What concerns me is, I've asked this at previous inquiries and previous hearings, and I didn't get a satisfactory answer, and I'm concerned I'm not going to get a satisfactory answer now. There are other bar associations in this country. The Justice Department used to be willing to hear and did inquire of the other bar associations when the confirmation process was occurring. This Justice Department has closed its doors to those other opinions. But the American Bar Association, I believe, therefore, has a special responsibility to find out what the federal bar says, what the National Bar Association says, what the legal aid societies of the country say, what the Women's Bar Association says. Did you make inquiry of any of the other bar associations?
We did, Senator, we did make inquiries of a minority bar associations and women's groups. We told them that we were doing this investigation, and in each case we were told that that particular organization was in the process of coming to making its own investigation. They hadn't reached a conclusion at that point, and they both said that if they reached a conclusion, they would get back to us. And at the time we rendered our report, which we felt we were under some time constraints to do, we had not received an answer back from those groups.
Well, I have some real concerns. I think I remember the American Bar for many years myself, and I have some real concerns as to whether or not you're not letting the membership down, as well as your responsibility to this committee when you appear, in that you only make inquiries of law professors, lawyers, judges. And I am not at all impressed about the question of whether or not you have the resources, because there's no doubt in my mind that you do. You all come from major law firms, or your law firms have no problem about making available investigators or your own time or your junior members to go out and do the investigating. My real question is it right Is it the correct thing to do? You don't actually say in your comments here, you say the committee's evaluation is based on its investigation of his professional competence, judicial temperament, and integrity. You don't indicate, although through the report you say what groups say, but you don't say that our investigation is only limited to his peers at the bar and those on the bench. Now, it wouldn't have taken too much investigation on your part to find out some of the facts concerning Judge Scalia or Justice Rehnquist, but you didn't do that. I wonder if that's really appropriate, or do you think you only limit your activities to that having to do with lawyers?
Well, Senator, first of all, let me respond to one thing you said to make it clear the way this committee functions, because I think it's important that you understand that. We have, as I said before, one member in each circuit. Mr. Lafitte is a member from the Fifth Circuit. Mr. Lane
I
is...
understand that.
Yes. But
that's a given.
it's a very important part of our process that committee member personally does all of the interviews with the lawyers, judges, whoever is being contacted in that circuit is done by that committee member personally. He does not delegate it to junior members of his firm or her firm. And the reason for that is very important. The members of this committee across the country are selected for their diversity, but also for their standing at the bar in their particular communities. And across the country, these are men and women who are...
All that.
No, but it's important, Senator, that you understand that by the very reason of the fact that they do this personally, and they are people who are trusted in their communities, they get access to information on a confidential basis that we don't think we'd get if we delegated a bunch of junior investigators to go out and do it.
Mr. Fisk, I'm talking about investigating facts. Investigating factual information doesn't have to be done by a lawyer. When you're talking to somebody, to a judge, to another lawyer, I understand that. But let me pass on to something else that is very much within your area. You say you do all this work, you're the Bar Association. The Ethics Committee of the American Bar Association had a proposed commentary in their canons, which was adopted in August of 1984, that no member of the judiciary should belong to a club that practices invidious discrimination. And the Judicial Conference passed a resolution indicating that a judge should not belong to a club that practices discrimination. Now, when I inquired of Judge Scalia yesterday on this subject, I thought he sort of tried to make a distinction between invidious discrimination and discrimination. It is a fact, I'm just going to finish this question, that the Cosmos Club does not admit women. Now, if you want to say that's not invidious, then you probably ought to ask the women of this country. But the question that I'm asking you is, how come there's nothing in your report about this issue that has to do with judges, has to do with the ABA canons, has to do with the Judicial Conference, and I looked through it, unless I overlooked it, you don't even mention the fact. Why?
Well,
Senator...
That was very smart. You have the question to him.
The reason I took it, Senator, is that I did interview
You what?
I did interview Judge Scalia along with Mr. Lane, and I think the answer, I guess the best answer to the question is we did not ask him that question in that interview.
My question to you, Mr. Lafitte, is why didn't you? That's an ADA
Yes, I
canon,
understand.
that's a judicial conference ruling. Why didn't you? And therefore, can we expect that your whole report is that incomplete?
Well, I don't think that's a fair conclusion, Senator. Normally, when we conduct these investigations, we do have the benefit of responses to personal data questionnaire in which the judicial candidate does list the clubs and organization he belongs to. In this instance, Judge Scalia had updated his prior PDQ or personal data questionnaire response to us, but quite frankly, I simply don't recall whether that information was in there. We did not ask the question that you are now raising to us, and of course it's true that, you know, if we had, I think the question would have been, do you belong to an organization that does exclude women or minorities from membership? And I believe, as I understand the response, it is that the judge does not now belong to
Fisk, as chairman of the
such an
committee, I would
organization.
hope that in your future investigations, you will ask the question and you will report back to this committee when you make your recommendation as to the facts. Is that agreeable with you?
yes, it is, Senator. As Mr. Lafitte indicated, I think if the question had been asked, as I understood Judge Scalia's answer yesterday, he would have said he was not a member of any such club.
I'm not sure whether the judicial conference calls for invidious discrimination. Let me say
We
that...
will ask the question, though.
Pardon?
We will ask the question.
Ask the question of belonging to a club that discriminates.
In this particular case, if I might add, his questionnaire showed that he was formerly a member of that club. And from my own personal knowledge, I know that there's been a battle going on within the club on that very question. And there are some members that feel that they should stay in that club and continue the fight to open it up.
Did you check as to whether Judge Scalia was involved in the fight? And
No, I did not.
And isn't it the fact he didn't resign until December 1985?
I don't know the date
He
that
was
he
there
resigned.
about 5 or 6 years, as I recollect. Thank you, Mr. Chairman.
I want to ask you this. I have before me the American Bar Association Standing Committee on Federal Judiciary, what it is and how it works. And on appointments to the Supreme Court, I want to quote here, evaluation criteria and ratings. The committee's investigation of prospective nominees to the Supreme Court is limited to their professional qualifications, their professional competence, judicial temperament, and integrity. Now, so I had never heard of the American Bar making a detailed investigation of everything about a nominee, and I was always under the impression it's just what you got in this book here, is that your investigation is limited to the professional competence.
That's correct, Senator. And
What
that's
ability they have as a lawyer, their professional competence, their judicial temperament, whether or not they preserve the personality and temperament to be a fair and a reasonable and a just judge, and their integrity as to their honesty, their lack of corruptness, their character. Is that the basis of your investigation, what I just stated?
Yes, it is, Senator, and as I indicated before, that's, I believe, what we tried to make clear in the second paragraph of our letter to you regarding both
these
justice...
questions about all these little details, as I understand, you don't investigate all those. That's the FBI's job and the Judiciary Committee's job, isn't it?
There are certainly...
Is that the way you construe it?
Well, there certainly are matters, Senator, that we feel the FBI is more able to investigate than we are, and there are other matters where you have the subpoena power and can place people under oath, where
Of course,
we think you...
Of course, if you picked up anything detrimental, you would report it. But as I mentioned, those are the qualifications that a professional organization, as I understand, would be interested in presenting to the committee. Other details will be gone into by the administration, the FBI, the Judiciary Committee, and the Senate. Is that your understanding?
Yes, we recognize, Senator, that our function is, principal function is professional competence, integrity, and temperament, and we certainly recognize there are matters that the FBI and this committee are better equipped to investigate than we are.
Three things: professional competence, judicial temperament, and integrity.
Yes, sir.
Distinguished Senator from Iowa.
Mr. Chairman, I have no questions of this panel.
Distinguished Senator from Maryland.
Thank you, Mr. Chairman. I'd just like to thank the members of the American Bar Association for their continuing interest and help to this committee.
Distinguished Senator from Vermont.
I have no questions of this panel, Mr. Chairman. I've read their report. The questions that I would ask them are in their report. Other questions would go outside their report, and they would not be the ones to ask the questions of.
I just submit a question.
Well, let me see. Are you through, you say?
Yes, sir.
I just submit just for a written. Is that all right, Chairman? I just submit a question.
Distinguished Senator from Massachusetts.
I'll just submit a question for writing. Right. Well, I'll just submit a written question if I could for, I'd like to clear up a factual issue and question that I'd like to get straightened out for the record. I'll submit it so that we can move on, Mr. Chairman.
As I understand, now everybody's asked questions. Are you through? As I understand, the committee investigation included interviews with justices of the Supreme Court, United States, and other federal and state judges, practicing attorneys, deans and faculty members of law schools, a review of his opinions, and then 2 members of your committee interviewed Judge Scalia personally, I believe. And as to the judges, you say many judges who do not personally know Judge Scalia have a favorable impression of him based on his reputation and their reading of opinions that he has written. The judicial community was strong in its praise of Judge Scalia's qualifications. The judicial community. Is that correct?
Yes, it is, Senator.
That's an excerpt here that I had. Now, you interviewed lawyers. Lawyers have commented that he is always well prepared. He asks the right questions and writes exceedingly well. That arguing before Judge Scalia is an exhilarating experience. That he has strong intellectual capabilities. That he is very fair. And that he has a warm and friendly personality. That's the next excerpt. Is that correct?
That is correct, Senator.
The deans and professors of law, including specialists in constitutional law and scholars of the Supreme Court. He is uniformly praised by those who know him for his ability, writing skills, and keen intellect. Is that correct?
Yes, Senator.
Now, a survey of his opinions, high praise for his intellectual capacity, his clarity of expression, his ability to analyze complex legal issues, and his organization and articulation of ideas. He is regarded as a splendid legal writer. Is that correct?
Yes, it is.
Where is that press release? In the statement I believe you made and gave out from your letter to the press is a short summary. To summarize our findings, Judge Scalia has an outstanding academic record and has demonstrated strong abilities in his service as a practicing lawyer, a teacher of law, as an appellate judge, Our investigation has shown him to be extremely intelligent, analytical, thorough, hardworking, and devoted to the legal profession. His writing and analytical skills are widely acclaimed. The diversity of his experience as a practicing lawyer, as a law teacher in 4 of the outstanding law schools of this country, and as a federal appellate judge, provides a valuable background for a justice of the Supreme Court. Notwithstanding isolated expressions of concern, our investigation revealed that Judge Scalia has an outstanding judicial temperament and that he is well suited for service on the Supreme Court from that standpoint. He enjoys the respect of his colleagues, both on and off the bench, for the soundness of his judgment and his congeniality. His integrity is above reproach. In conclusion, the committee, by unanimous vote, has found Judge Scalia to be well qualified to serve as an Associate Justice of the Supreme Court of the United States. Is that correct?
That is correct.
And that's your recommendation?
Yes, it is, Senator.
That's your finding?
Yes, sir.
You stand by it now, all of you?
Yes, we do.
Yes. Yes. No more questions. You're now excused. Thank you for your appearance.
Thank you.
Our first panel this morning, and if they'll please come to the table, Ms. Carla Hills of the firm of Latham, Watkins and Hills of Washington, Dean Gerhard Casper, Dean of the University of Chicago School of Law, Chicago, Illinois, Dean Paul Verkule, President of the College of William and Mary, if you'll come in that order and sit in that same order, Professor of Law, Honorable, let's see, Mr. Lloyd Cutler, Wilma Cutler in Pickering, Washington, D.C. Honorable Irvin Griswold, is he here? If you sit in that seat right here, Mr. Griswold. Now, we're going to give you 3 minutes apiece to express yourselves. You can do it in less time, that'll be fine, but you can take 3 minutes. Now, if you've got written statements you wish to put in the record, we'll put the entire statement in the record. But first, I will swear you if you'll stand and hold up your right hand. Will the testimony given in this hearing be the truth, the whole truth, and nothing but the truth to help you God? Well, have seats. Ms. Hill, you may proceed.
Thank you, Mr. Chairman. Mr. Chairman and distinguished members of this committee, I have worked with, known, admired, and been enriched by the wisdom of Judge Scalia since 1972. He was then chair of the Administrative Conference of the United States, and I was just named to that body. One cannot imagine a wider group of federal issues than those addressed by the conference, or a wider divergence of views than those held by its members. With intellectual precision, unfailing humor, and relentless fairness, Judge Scalia accommodated all opinion and faithfully caused our deliberations to be well recorded. He was at all times constructive in helping that body build a consensus, even when it did not reflect his own judgment. When I went to lead the Civil Division of the Justice Department in March of 1974, I was pleased to learn that my colleagues there held him in the same high regard as did I, a regard that increased when he came to head the Office of Legal Counsel later that year. Those were difficult days that we shared through the first months of President Ford's administration. Seldom, if ever, have so many complex and emotional legal issues been so prominent and so controversial. Yet during that period and the years following, when I sought his counsel from the Department of Housing and Urban Development, he was ever the patient, careful, and reasonable advisor. In writing and by voice, formally and informally, he expressed his views on a wide range of issues often of profound constitutional importance. Never did I perceive or hear an allusion to his having a bias or a leaning. He was respected for his objectivity, clarity, judgment, and integrity. In my view, the Senate has now a rare opportunity to celebrate our Supreme Court by its confirmation of Judge Scalia's appointment to that institution. The essence of our legal system is its ability to provide a government that rules by law rather than by individual. The fairness of that system depends upon the intellectual soundness and thus predictability of opinions that emanate from the Supreme Court. However wise the justices might be judged on the basis of any number of standards, the acceptance of their ruling by our body politic depends on how the public perceives the court's work over the course of years. Inarticulate or fragmented decisions serve no purpose. Well-reasoned opinions that bind the court and set forth lucid rationale will serve all of us quite well indeed. Judge Scalia brings distinction and respect to this court. His ability to reason, to write, and to persuade are his hallmark. That he will do this, all of this, with energy and good humor makes it a happy privilege for me to appear here in support of his confirmation.
Thank you very much. The rest of your statement will go on the record. Dean Casper, we're glad to hear from you.
Mr. Chairman and members of the committee, my name is Gerhard Casper and I'm the Dean of the University of Chicago Law School. I am of course not appearing before you in my capacity as Dean. I am referring to that role only because it made me for 4 years what FBI investigators like to call the nominee's supervisor, though God knows that there are few jobs in this country more challenging than the task of supervising the University of Chicago Law School faculty. I am well familiar with Judge Scalia's academic work and reasonably familiar with his judicial work. Judge Scalia possesses what I would call a tenacious intellect. He is intellectually refined and takes great pleasure in measuring a problem. To put it differently, he is exceptionally probing in his investigation of legal matters. He is thoughtful and straightforward. Of course, Judge Scalia is not a mere technician. He understands fully the intellectual, moral, and practical difficulties inherent in most controversial legal issues. The best example from Judge Scalia's writings to illustrate my point is his article on judicial review of administrative action in the 1978 Supreme Court Review, of which, incidentally, I am an editor. His article on the Supreme Court's decision in Vermont Yankee Nuclear Power Corporation versus Natural Resources Defense Council is a masterful and sweeping critique of the D.C. Circuit, the Supreme Court, and Congress's failure to update the Administrative Procedure Act. In recent weeks, I have often been asked what Judge Scalia's ideology is. I have noticed that the distinguished members of this committee also use the term ideology with great frequency. I'm frankly not sure what everybody means when they say ideology. For instance, President Reagan a few weeks ago seemed to employ the term mainly to criticize the opponents of the Mannion nomination. If you ask me what Judge Scalia's view of the Constitution and the rule of law is, I'm inclined to answer that he believes that the Constitution and the laws mean what they say, and that it is not beyond human endeavor to determine the meaning of what they say. If you call that ideology, so be it. I do not mean to suggest that, in my opinion, Judge Scalia is invariably right. I have had many disagreements with him, for instance, on the constitutionality of the legislative veto. But there is no question in my mind that Judge Scalia, at all times, attempts to be faithful to what we may call the American concept of the rule of law. Permit me to say a word about how to evaluate judges. There was a time, not too long ago, when it was considered respectable and valuable for lawyers to sit down and do a painstaking, detailed analysis of a judge's single decision, keeping in mind a dictum of one of the great state judges of all time, former Justice Schaefer of the Illinois Supreme Court, who died earlier this year. The principal stimulus, Justice Schaefer said, comes from the facts of the case. The interaction between fact and law is close and continuous. Without having studied the subject empirically, I have a sense that this genre of analysis is increasingly disfavored. Its place seems to be taken by more speculative endeavors which seem less interested in understanding the judge than in the approval or disapproval of outcomes. In this worldview, the courts are filled with heroes and villains rather than with professionals to whose professional performance we apply professional standards.
Time is up. I've got a red
May
light.
I-
That
may
red
I
light
just
comes on, you're supposed to
give
stop.
you my punchline, Mr. Chairman? If one applies professional standards to Judge Scalia's case, one must confirm this splendid nomination. Thank you.
Very much. We appreciate your appearance. Dean Paul Verkle, how do you pronounce that?
Mr. Chairman, it's Verkyle.
Verkyle.
Thank you for inquiring.
Mayor, you also a professor of law, are you?
I am president and professor of law at the College of William & Mary.
Double duty.
Well, I guess you might say that.
Get extra pay for that?
I'll inquire about that, Senator. I haven't
You may proceed.
separated them. And I'm here, of course, in my individual capacity. I would first like to say I'm not here to testify in a partisan role or as one who necessarily shares the same views as Judge Scalia on legal issues. I am here to testify about why I believe he will make an outstanding justice. I shall emphasize two aspects of his background that bear upon his qualifications for the high post he seeks: his judicial temperament and his legal and scholarly qualifications. Temperament is not easy to describe or predict, but it is the best way I know to get at the quality of fairness that is essential to the judicial role. My focus is upon Judge Scalia's open-mindedness and willingness to engage in legal debate, what I might call his exuberant argumentativeness. These qualities translate into fair-mindedness. I first had an opportunity to know Judge Scalia as a professional colleague 15 years ago when he was chairman of the Administrative Conference of the United States, and I was a consultant to that organization. From the outset, our professional relationship was marked by a good-humored exchange of views. The first issue I recall debating in depth was the role of the courts on judicial review of informal agency rulemaking. This issue, that is, determining the proper relationship between the courts and agency in the promulgation of rules, has occupied the courts for years. I found Judge Scalia to be a thoughtful, persistent, and insightful student of the law. The article and conference recommendation that came out of these efforts was much in debt to his efforts. Later, I had the opportunity to work with Judge Scalia on the administrative law section of the American Bar Association during the period he was chairman. Here, he not only demonstrated his usual astuteness on the issues, but he displayed a remarkable ability to distill and integrate widely differing views into effective statements of position. In fact, I have never seen a better coalition builder than Scalia. He uses his charm, humor, and intellect, frequently in that order, to bring people to a common position. This quality is indicative of a temperament that will, and I'm sure does, serve the judiciary well. It also speaks to his likely success as a justice on the High Court. My most extended exposure to Judge Scalia was during the summer of 1984, when we both participated in the Anglo-American Legal Exchange at the invitation of the Chief Justice of the United States. This program dealt with the role of judicial review of administrative action in England and the United States, and involved a visit by a group of 8 American lawyers and judges with a light group in the United Kingdom. Judge Scalia led many of the discussion groups and did so in an informed and entertaining manner that made him a favorite of the British team as well as our own. To a country that is embarking on a more active period of judicial review over administrative action, he offered some sobering words of caution, yet in a manner that rallied many to his side. The ability to build a case, defend it, and where the occasion demands, abandon it, is his in substantial measure. Senator, I see my time is up. I'm going to let you refer to my written testimony for his scholarly works, which I've commented upon, and I would only conclude that I hope this justice meets your standards, your demanding standards here of the committee and the Senate. Thank you.
Thank you very much, and if you want the rest of your statement put in the record, we'll put it in. Honorable Irvin Griswold, Dean Griswold, we're honored to have you appear before us.
Mr. Chairman and members of the committee, I'm Irwin Griswold, now a practicing lawyer here in Washington, having been a dean of the Harvard Law School and Solicitor General of the United States, and I may add, by appointment of President Kennedy, a member of the Civil Rights Commission at a time when it was active and effective. My first acquaintance with Judge Scalia was more than 25 years ago when he came to the Harvard Law School as a student. I can't say that I have any memory of him during the first year, but at the end of the first year, he achieved a distinguished record in the very top ranges of the class, and I did observe him and see him during the next 2 years. He became a member of the board of the Harvard Law Review, and at the end of his second year, became note editor of the Law Review, a post which he filled during his third year at the school. He received his degree magna cum laude, which meant that he had an A average throughout his work at the law school. The year following his graduation, he spent as a Sheldon Traveling Fellow abroad, and I was a member of the university committee which recommended him to the Harvard Corporation for that appointment. The next 6 years he spent in private practice in the firm of Jones Day, Cockley and Revis in Cleveland. I'm now a partner in that firm, but I had no connection with it at the time. This was, however, one thing that occurred to me, and I made some inquiries. Why did Scalia leave the firm after 6 years? Was it because he had been, it had been intimated to him that he probably wasn't going to become a partner? And I asked a couple of my present partners who were members of the firm at the time, and they said, on the contrary, he was doing very well. He was very highly regarded. He would have soon become a partner, but he found that his interests were broader, and he had an urge to teach, and he deliberately made the choice himself to move to teaching. He then went to the University of Virginia Law School. Then he was in Washington as chairman of the administrative conference, where I saw him on various occasions. Later he became Assistant Attorney General for the Office of Legal Counsel. I not only observed his work there, it was an office I was familiar with, but I had contacts with him where I found that he was tough-minded but fair. After that, he went to the University of Chicago, wrote law review articles. The past few years has been a judge writing opinions, which I have observed. I regard him as a person of top legal quality, with a broad mind, great intellectual integrity, and very well qualified to be a justice of the Supreme Court. I hope this committee will recommend that he be confirmed.
Dean Griswold, thank you very much for your appearance. Mr. Cutler, be glad to hear from you.
Chairman, I have also filed a written statement, and I will summarize it only briefly. When I was counsel to President Carter, unfortunately, he never had an opportunity to nominate a justice of the Supreme Court. If such an opportunity had arisen, I probably would not have recommended to him that he appoint Judge Scalia, even though at that time he was a most distinguished professor of law. Yes, sir. But in the unlikely event that I were serving as counsel for President Reagan, I would certainly have included Judge Scalia among the 3 or 4 most qualified people in the country for the post. I make that point because I believe it draws the right distinction between a president's role in nominating a Supreme Court justice and the Senate's role in deciding whether to grant its advice and consent. Since Supreme Court vacancies occur so infrequently, the president has ample reason to select a well-qualified nominee whose broad political and legal philosophy the President believes to be consistent with his own. The President, of course, may be disappointed in the event, as was true of President Teddy Roosevelt in the case of Justice Holmes, and we understand President Eisenhower in the case of Chief Justice Warren and Justice Brennan. But as the appointing authority, the President certainly has the right to take compatibility of philosophy into account. The Senate, in contrast, doesn't play the affirmative role of selecting the nominee, but the negative role of withholding its consent to an improper appointment. What is an improper appointment? In my view, it's improper to nominate someone who is not professionally qualified, no matter how compatible his views may be with the President. I also believe it's improper to nominate someone, however well qualified professionally, whose ideology so dominates his judicial judgment as to put his impartiality in particular cases into question. Measured by those standards, it seems to me that the nomination of Judge Scalia is clearly a proper one. You've heard his academic and professional qualifications, and they are certainly very impressive. As for his political and judicial philosophy, I find from reading his opinions, he is nearer the center than the extremes on the major issues that arise in our political and legal system. Perhaps the best evidence of that is his record on the Court of Appeals. So far as I can determine, his major opinions on that court have been supported as frequently by what are colloquially called the liberal wing of the court as by the conservative wing. In one recent libel case involving important First Amendment values, he was one of 5 outspoken dissenters, along with 4 members of the liberal wing. And in the recent Graham-Rudman opinion, which I didn't like on other grounds, his views were sustained by a Supreme Court majority that included 3 of the so-called liberal members of that court. Finally, he possesses a special quality that can never be an oversupply in the Supreme Court, and that's an enthusiasm for appellate argument, a joy in the tough question and the persuasive answer, and an openness about his own state of mind that are a great help to the advocates in the case and to the journalists and scholars who study the work of the court.
The distinguished senator from Ohio.
I have no question.
Distinguished senator from Maryland.
Well, Mr. Chairman, I cannot imagine a more distinguished panel to render an opinion on an appointment to the Supreme Court, and I want to thank each of them for being with us. I really have very few questions, but this thought does occur. In Judge Scalia's judicial experience, he has had relatively few criminal cases. The District of Columbia Appellate Circuit simply doesn't generate a lot of criminal work. Do you have any thoughts as to whether that is a limitation in his experience, and do you have any thoughts in general on the breadth of his legal experience and his judicial experience?
Any of you care to answer that?
Senator Mathias, may I perhaps, as a point of personal privilege, first of all say how much I regret that you will retire from the Senate and from this committee. You have been one of the most enlightened forces in debates on law and constitutional questions. I'm deeply regretful that you leave. I hope I cannot believe that you will enjoy what you will do afterwards, but I hope you will.
Well, I thank you for those kind words, and also thank you for the assistance that you have given very generously and spontaneously over these many years.
Thank you, Senator. Senator, I think while it may be true that Judge Scalia has not had much exposure to criminal law on the circuit, it is also true that the Supreme Court's exposure to criminal law is of a peculiar kind. Almost all the criminal law cases the Supreme Court takes are those which involve large constitutional questions. The Supreme Court, after all, does not sit as a court of last resort and review in criminal cases. It will take only the cases which matter in terms of constitutional interpretation, and there in particular in terms of constitutional criminal procedure. And I have really no question that Scalia is well qualified to deal with those issues.
Yeah. One other question, Mr. Chairman, I might put to Dean Griswold. President Reagan has appointed an unusually large number of professors, law professors, to the courts of appeals in the last few years. This is the first law professor to go to the Supreme Court since Justice Frankfurter. Does this have any significance for the law faculties of the country, do you think?
No, I don't think so. It still remains an outside chance. Although, of course, Justice Stone, later Chief Justice Stone, was a dean of the Columbia Law School before he became Attorney General. Other presidents have appointed a good many professors to the courts of appeals, less often to the district courts because the professors usually have not had trial experience. But I remember in particular Judge Calvert Magruder, who was Chief Judge of the First Circuit for many years and surely one of the distinguished judges of his time. I don't think that on the whole...
He had the good fortune to have Maryland roots and to live in Massachusetts.
Yes.
And Matthias, not having attended the great law school, I urge you not to overlook for the record Justice Douglas, who survived well after Justice Frankfurter.
What?
I stand corrected.
Senator, I might just add that one effect it will have upon the law professors of America is that they'll be sending their articles to Justice Scalia in the hopes that they will be cited by the Supreme Court.
So at any rate, you think this will generate academic interest?
Yes.
Once again, I thank this panel very much for their help to the committee.
As I look at this panel this morning, I don't know that there's been a more prestigious group of people, 5 people, sitting at one table since I've been in the Senate. Every one of you have outstanding reputations, professional competence, judicial temperaments, and integrity. You'd all make good members of the Supreme Court yourself. Now, I want to thank you for coming here and taking your time. Distinguished Senator from Arizona.
Mr. Chairman, thank you, and I echo those accolades for this panel, and I thank them for taking the time here. I have great envy for those of you who have had an opportunity to know and work with Judge Scalia. I have not. I know him by reputation. Yesterday when he was here, I don't know if you observed any of his testimony, but he was probably one of the most evasive nominees I've ever seen, far more than Mr. Rehnquist or Mrs. O'Connor or any other ones that I've asked, which caught me somewhat by surprise, particular, Dean Casper, in your statement of indicating of your analysis and lawyers that have analyzed his cases and your process that you've gone through and knowing him, how open and direct he is and non-evasive and decides it the way it is before him, whatever that comes down to. I asked him a question on the 14th Amendment due process clause. I didn't ask him how he was going to rule. Just asked him if he agreed with Justice Rehnquist that there was more than one standard. And he just said, I can't say it, can't do it. I then asked him a question on an article in a magazine that he was quoted in 1982 regarding the Freedom of Information Act, which stated, and I'll just read it quickly, the defects of the Freedom of Information Act cannot be cured as long as we are dominated by the obsession that gave them birth. The first line of defense against an arbitrary executive is do-it-yourself oversight by the publics and its surrogates, the press, end of quote. I merely asked Judge Scalia if that was, did he stand by that today? And he said, well, I don't know, and I just have great envy for those of you who know him, because I'm extremely disappointed. I indicated and I probably will vote for him because of his fine reputation, but maybe you can share with me any of those feelings that you think are just hearsay, as that's all they are, realizing that, of opinions of how you think he would look at the 14th Amendment. I couldn't find out from him. I have no idea whether or not he agrees with Justice Rehnquist or doesn't, or has an opinion of his own without asking him how he's going to rule. Maybe, Mr. Casper, you have a comment.
Well, Senator DeConcini, I had no opportunity to observe the testimony yesterday. I would just assume that if, let us assume Judge Scalia was evasive, that he displayed tremendously good judgment yesterday, and it shows what a judicious man he is in not committing himself too far before your committee, and in particular not in dealing with matters which could come before the court. Let me say a word about a matter which came up earlier this morning in the testimony of the ABA and in the questioning from senators, and then respond to another part of your question, Senator DeConcini. It was often asked this morning whether Judge Scalia was open-minded. Now, I'm not so sure whether I am open-minded. When you listen to the questioning here this morning, you sometimes had the impression that to possess a mind which is like a sieve is a virtue. I'm not sure it is a virtue. Obviously, a man of 50 years of age, law professor, has opinions and has a framework of analysis. No question about that. There are limitations to on the open-mindedness of all of us. Certainly that is true for me. However, there's something very important. Antonin Scalia was a law professor, and he was a very good law professor. And the best law professors in the country do indeed have no question that they are bound to standards of verification, standards of validation. When I had arguments with my colleague, Professor Scalia, he most certainly could see when the strength of the argument was on my side rather than on his side. That is very important.
Well, excuse me,
yes, sir.
Dean Casper, I agree with that. What I guess I'm asking, one thing I'm asking, and it certainly wasn't clear in my observation first, is that knowing the process of this committee, of what we go through, don't you believe we're entitled to ask him opinions as what he thinks about the Constitution without pinning him down on one member asked him how he would vote on Roe versus Wade? Well, obviously, he can't and should not comment. But refusing to give us an opinion or any idea of how he delves into the Constitution, I was extremely disappointed. And that's why I asked some of you, because you know him, you're not in the same boat, but it would be helpful to this senator if I had any idea how he thinks about the Freedom of Information Act other than a 1982 article.
Right.
And I could not get that, and you know him and I don't, and that's my quandary.
Senator, let me respond to that. I do think, of course, that this committee has the right to ask any and every question it wants to ask, as I do indeed believe that its power to consent is plenary. With respect to the difficulty Judge Scalia is in, there is no controversial issue which you want to debate, no matter of constitutional law, which will not potentially come before the court. And so at this point, he has to be very reserved. But now comes the good news. That's the bad news. But now comes the good news. The good news is, in particular in the case of academics, you are much better off than in the case of most other people. There are writings. They have a record, a rather elaborate record most of the time, as does Judge Scalia. And while I have not recently discussed his views of the Freedom of Information Act with him, I would rather assume that it is a good and strong hunch that if you want to know Scalia's views on the Freedom of Information Act, his article pretty much represents those views, unless, of course, they become strongly challenged later on.
Why just couldn't he say so? That's what bothers me. Professor Griswold, you have a
yes,
comment?
I'd like to venture and answer to the question. In the first place, I think this is an extremely delicate and difficult situation.
I agree.
With respect to the nominee. He must not make anything which somebody else can interpret as a commitment of some kind or other. And even a question about the Freedom of Information Act, which is almost, the area is almost sure to come before him sometime, is one on which I can see how it is very difficult. Now I would like to recount some history. I think that at least till World War II, it was the practice of this committee and the Senate not to have any candidate for judicial office appear before the committee for that very reason. In particular, it is my recollection, though historians could show me to be wrong, that Mr. Brandeis of Boston was not a witness before this committee during the long drawn-out hearings with respect to his nomination. Other people appeared, other people on both sides. The question was explored very thoroughly, but it wasn't thought appropriate for the nominee to appear. Sometime after World War II, that changed. I recall that then Professor Frankfurter did appear before this committee with counsel. Dean Atchison was his counsel. And I think that a review of the hearings of that time will show that there were many questions which he thought that it was inappropriate for him to answer. I must say that within very wide limits, I regard it as a plus for Judge Scalia, that he takes a very careful and delicate view as to the range of questions which he feels it appropriate for him to answer.
Well, thank you, Dean Griswold. My problem is, I guess a little bit of knowledge is dangerous for some people, and a little bit of experience may be the same way. But we had Justice O'Connor here, and some questions she did not answer, but she gave us an opinion, her personal opinion, not saying that and qualified it, that it was not to be interpreted as an indication of how she would hold on the bench on different constitutional questions, as did Mr. Rehnquist, under the tremendous barrage that he had here of hostility from a few members. He responded to the 14th Amendment. Yes, he said that there may be two different standards, one for race and one for sex, based on his opinions. And it's just a frustrating situation of such an eminent jurist and an individual that Judge Scalia has, and I don't degrade him at all by my comments here, that he was so unforthcoming, and you give the explanation that I have great respect for, because you know him, and I don't, and I have to very much rely on testimony rather than coming from him, and I would like to have had both. Thank you, Mr. Chairman.
Distinguished Senator from Iowa.
Mr. Chairman, I'd have a question for Mrs. Hills and Mr. Cutler, and the reason I picked those two out of the panel is because they've served in the executive branch in recent years, and because Judge Scalia seems to have some strong views on the doctrine of separation of powers, and as far as I can figure out, he tends to favor the executive branch if there's on very close questions. Do you two see anything out of balance in Judge Scalia's views in this regard, separation of power?
None whatsoever, Senator. I think Judge Scalia demonstrates great integrity of intellect and has addressed a large number of issues, as the Dean aptly said, that there is no issue that you could think of that he has not written about in a rather prolific fashion, and I'm not at all concerned about his jurisprudential approach.
Mr. Cutler.
I happened to collaborate with then Professor Scalia in the preparation of the briefs in the legislative veto case, which I think was decided unanimously by the Supreme Court. I was one of the growing number of losing counsel before Judge Scalia in the Graham-Rudman case. I disagree, as you might expect, like any good advocate, with the ultimate opinion, but it's worth noting that in the Supreme Court opinion, as I mentioned, the majority included not only Justice Stevens and Justice Marshall, who happened to disagree with Judge Scalia on one ground of the opinion, but also Justice Brennan, who concurred fully in the opinion of the Chief Justice, which I would say concurred fully in the lower court per curiam opinion, which I would bet a lunch was written by Judge Scalia.
Then I would ask all to respond to accusations or inferences, let me say, that maybe he's too rigid, too ideological, from the standpoint of assuming professional competence for any judge that might be before this body for confirmation. Can, from your standpoint, a judge nominee be too ideological, too rigid, assuming professional qualifications are high? And how do you respond to whether or not Judge Scalia, is he too ideological, too rigid?
Senator, my 15 years of experience and working closely with Judge Scalia belies the accusation that he has a rigid mind. The statement made by the representatives of the American Bar Association preceding us suggested that there were one or two comments that he may have strong views closely held, but balance that against the fact that he is perhaps one of the best prepared judges on the appellate court here, and that it is very difficult to have studied the briefs, engaged in argument with your law clerks, and not have some view of the case with precise questions. He is overwhelmingly applauded at the bar by lawyers who have appeared before him for the excellence of his preparation and for his ability to participate qualitatively and qualitatively in the discussion. So rigid he is not, intelligent he very much is.
I agree with what Ms. Hills has said as to Judge Scalia in particular. As to your hypothetical, I think yes, a nominee could be so ideologically convinced on a particular set of issues that he would give the public perception of having his mind closed on cases that came before the court. And the illustration I used in my written statement was any nominee who gave the public perception that he would decide any case involving a claim of minority rights either always for or always against the minority group does not belong on the Supreme Court or any other federal court.
Anybody else?
Senator, I would just add also that I do personally think that ideological qualifications could be examined, and I would be uncomfortable at extreme ends. This is certainly not that case with this nominee from my experience. I think he is a conservative person, but he is someone who practices judicial restraint and will do so, whatever the issue. The Sinar case is, in my view, a good example of that. He did not, participating in the decision, go for the much broader basis of non-delegation, which I think would have given this body much more difficulty in a continuing sense, but he was much more narrow in his view of how that separation of powers issue ought to have been resolved. And I think that's the kind of approach he would have to legal issues generally in the future, no matter what the, if you will, the political cast might be.
Senator, I agree with the other members of the panel. In my opening statement, I criticized the concept ideological in this context. I don't really know what it means. Ideology is usually what the other fellow has and not what I have. And it is my opponent who's ideological, while I am fair-minded and oriented only towards the truth. Ideology, of course, in one meaning is a comprehensive worldview, such as that of the Communist Party of the Soviet Union or something like that. It's ideology. The question is what is Judge Scalia's view? I don't think he's ideological. I think he's deeply committed in this kind of sense I just threw out a general worldview. He's deeply committed to constitutional government as it has come up in the United States and to his view of it. Now, I disagree with some of his views on that matter, but he is definitely committed to the rule of law. Now, that you can call an ideology, of course. I wouldn't.
Prestigious and in many ways unique panel. Certainly one of the most prestigious ones I've seen in the various committees I sit on in 12 years I've been here in the Senate. And so while I will owe apologies to those of my colleagues who wanted me to be at the other matters, I did not want to leave before I had a chance to hear each of them speak and hear some of the questions and answers. I have some of the same concerns expressed by Senator DeConcini on the question of Freedom of Information Act. I had a long discussion in my own questions of Judge Scalia about that yesterday. I discussed it at great length with him in my office back 2 or 3 weeks ago. I'm concerned because I think we're in an era where the questions of First Amendment, of freedom of the press, of the ability to look into what our government is doing and to determine when our government makes mistakes as well as when it does something right, all of these things I think are under more attack than any time in my adult life. I cannot think of a time when there are more forces, more individuals, in fact, many my time. Thank you, Mr. Chairman. Mr. Chairman, like so many others, and both sides of the aisle in this committee, I'm supposed to be another matter on Senate duties here in the Hill today, but I agree that this is such a prestigious and in many ways unique panel. Certainly one of the most prestigious ones I've seen in the various committees I sit on in 12 years I've been here in the Senate. And so while I will owe apologies to those of my colleagues who wanted me to be at the other matters, I did not want to leave before I had a chance to hear each of them speak and hear some of the questions and answers. I have some of the same concerns expressed by Senator DeConcini on the question of Freedom of Information Act. I had a long discussion in my own questions of Judge Scalia about that yesterday. I discussed it at great length with him in my office back 2 or 3 weeks ago. I'm concerned because I think we're in an era where the questions of First Amendment, of freedom of the press, of the ability to look into what our government is doing and to determine when our government makes mistakes as well as when it does something right, all of these things I think are under more attack than any time in my adult life. I cannot think of a time when there are more forces, more individuals, in fact, in many instances, more people who know better, attacking the ability of the press to go into stories in detail, of people's rights of free speech, untrammeled speech, all the various First Amendment matters. An attempt was made a couple of years ago in the Congress to gut the Freedom of Information Act, and it was only because a number of us were willing to stand up that we were able to stop it. So I think that the questions asked by the distinguished senator from Arizona were legitimate questions. I am concerned that they were not answered as fully as I think someone could without stepping over that line that a designee to a court cannot step over. That is a line which requires them to give answers here that prejudge cases. On the other hand, I do also, though, commend Judge Scalia for offering in response to a question I asked to recuse himself from a case coming up which also raises serious First Amendment issues, and one in which it was legitimate for him to recuse himself. I might ask the panel, you obviously know Judge Scalia well, have analyzed his works and know them. I would also assume that each of you have analyzed the statements, the cases, and the positions of Justice Rehnquist at some length. Do any of you see any significant ideological differences between Judge Scalia and Justice Rehnquist? Cutler, I'd be glad to start with you and just go down the line if you'd like.
Well, it's a difficult question, I think, for most of us. We're drawing shades of comparison.
Talk about significant differences.
I don't see any significant difference myself. I think it's, in the case of Justice Rehnquist, we now have some 12 to 14 years of his opinions on the court. We haven't seen that much of the jurist Scalia up to now, but I'll bet another lunch that we will see several cases every year on the Supreme Court, if you confirm Judge Scalia, with Scalia on one side and Rehnquist on the other. It's very hard to typecast members of that court.
Does that go to their judicial interpretation or ideology?
Well, it shows, I think, that their sense of what is judicially right in a case will overcome their broad ideology or philosophy. I'll give you one example that involves Judge Scalia, and that is the Liberty Lobby libel case decided in the Supreme Court this year, in which Judge Scalia's views were reversed by the Supreme Court. There were two dissenters in that case who agreed with one another and with Judge Scalia, and their names were Rehnquist and Brennan. And if in an important First Amendment case, Bill Rehnquist and Bill Brennan could be on the same side against the majority of the Supreme Court, that suggests to me that so-called ideology and philosophy is a lot less important.
For those who do thumbnail sketches of justices, they normally do not put Justice Rehnquist and Justice Brennan on the same thumbnail.
Normally they wouldn't, and it may be if you made
I understand.
one of those Harvard Law Review analyses of all the opinions of the court in the course of a year, you can separate them quite widely.
Well, as being Harvard Law School, Dean Griswold, I also appreciate so much having you here. When you were Solicitor General, I had the opportunity on more than one occasion to hear you argue, watch you. I always found that as a lawyer one of the greatest thrills I had, and I appreciate having you here. How would you respond to the same question? And I must admit that in asking the question, and I understand in Mr. Cutler's answer, I mean, this is something you could spend hours going back and forth, and I don't mean to in any way detract from the question by I want to emphasize, I know that it's something you could go on for hours and put the shadings back and forth. But Dean Griswold.
Well, Senator, I will venture an answer. In short, I don't think there's that much difference. I think there may be an appearance of difference, which I do not regard as very significant. And let me try to explain that. I think that Justice Rehnquist is a loner. I think he does his own thinking, comes to his conclusion, and in the past has felt a considerable pressure to state that conclusion. On the other hand, Judge Scalia is a very gregarious person. He thinks in terms of what the other judges are thinking. And he has not expressed himself so widely or so emphatically as Justice Rehnquist has sometimes in the past. But I think that if, apart from the way it is expressed, you look at what the positions actually are in a series of cases, you would find that Justice Rehnquist is not as conservative as he is commonly regarded to be. I wouldn't want to say that Judge Scalia is more conservative than he is commonly regarded to be, but I will stand by my opening statement. I don't think there's that much difference, and I have tried to suggest an explanation which makes reasonable people think that there may be such a difference.
Thank you very much. Sir.
Senator Leahy, I'd just like to say I'm here to testify on behalf of Judge Scalia's nomination, and I'd prefer not to engage in comparisons. I would add a point, though, about your concern, also Senator DeConcini's concern over the Freedom of Information Act article and Judge Scalia's positions. As I recall that article, it was in Regulation Magazine, I believe. It's called something like the Freedom of Information Act has no clothes. It was meant to be provocative. He's trying to sell copies.
It was. It was.
And it was, I'm sure. I think if I recall the article, the substance of it correctly, to allay your concerns about the First Amendment issue, is that his concern, and not only his, but many people's concern with the Freedom of Information Act, is not that its current utilization somehow helps the press and hurts other things, but what it does is the large users of the FOIA are businesses, and they're seeking competitive information, and it imposes an enormous cost on the government to implement it. And I really believe that the thrust of his comments went to that, not to the First Amendment concerns, the access to the press, but more or less to the fact that an instrument designed for the press, if you will, for the public to know, has become the favorite of competitors seeking business information, and that has imposed many burdens on the government.
May I just follow up on that, Senator? I entirely agree with Mr. Berkay in his assessment of the Freedom of Information Act article. Judge Scalia, when he was an academic in any event, but I'm sure it's a quality which continues, possesses a highly developed sense of the absurd, especially when it comes to discovering unintended consequences of regulatory reform, a field in which he is a master. And that was really his main concern with respect to the Freedom of Information Act. Here is this great liberal reform measure, and see who uses it most, businesses, to find out about their competitors. And that suggests a very important point, Senator. Even the Freedom of Information Act is not all good. The Freedom of Information Act does not only impose burdens on the government, which perhaps a former head of the Office of Legal Counsel might have been critical of, but rather it also imposes burdens on the rest of us. There's a lot of privacy which goes when the Freedom of Information Act is invoked. And privacy is supposedly also a prime constitutional value.
Senator, I have nothing to add with respect to your question on the comparison issue. I would urge you to understand that a candidate who is asked about a particular statute or a particular amendment finds himself in extremely difficult circumstance. These cases come to the court on facts, and it is the justice's obligation to give an opinion based upon those facts. And statements made at a confirmation could prove to be enormously embarrassing and really not too helpful in these circumstances, in my view, to this committee.
And you'd prefer not to answer the question of the comparison, the ideology of the two?
Oh, no. I simply said I could add no more than that had been contributed so much more articulately by my colleagues on the panel.
Thank you. Well, the red light is gone and my time is up. I would like to, maybe some other time we can discuss further the aspects of the Freedom of Information Act, because I do have very strong views on that. Mr. Chairman, I appreciate your courtesy in letting that time run over.
Distinguished Senator from Maryland. Senator Mustafa.
Nothing
Distinguished Senator from Alabama.
You've
asked by Senator Leahy and given your views on the close alignment of the ideology views of Judge Scalia and Justice Rehnquist. Now, let me ask you, what is your opinion of Judge Scalia as a consensus builder on an appellate court? And what do you anticipate that he would contribute or not contribute or detract from consensus building on the Supreme Court?
Are you addressing that question?
Well, I'll address it to each one of you.
I would be most delighted to address that question, having worked with Judge Scalia at the administrative conference at the Department of Justice and subsequently even in the American Bar Association. He has a phenomenal capacity to draw together diverse points of view and to build a consensus. He is inordinately articulate and can better phrase the issue than almost any other lawyer that I know. So as a consensus builder, he is without peer, in my opinion.
I agree with Secretary Hill, Senator, and I do think it is important to have somebody on the court who approaches the court from that perspective, because the divisiveness of the Supreme Court of the United States in recent years, I think, has become a real and considerable problem.
That's the heart of my testimony, Senator. Well,
I think
I would say at this point, as I did when I appeared before this committee in support of the nomination of Justice Rehnquist, that I think that Justice Rehnquist, if he is confirmed as Chief Justice, will in fact be much more of a consensus builder than he has been as a side justice. All the evidence indicates that his internal relations are good, and he will have a new pressure to lead the court, which I think he will rise up to. I recognize that this is the hearing on Judge Scalia, but the question makes that observation relevant.
Mr. Cutler?
I'd say his qualities as a consensus builder are so strong that if he had turned to politics instead of bench, I wouldn't want him running for my seat.
All right, so now we've got pretty well unanimity on consensus builder and his abilities there. We have had your expression, each of you individually, on the similarities of ideology between Associate Justice Rehnquist and Judge Scalia. Now, assuming that both are on the court and that President Reagan appoints 2 additional members to the Supreme Court with similarities of ideology and the consensus ability of Judge Scalia and the titular position of Justice Rehnquist as Chief Justice, would you expect that the court will follow a sizable different trend than it is presently following in the field of civil rights, women's rights, freedom of the press, freedom of speech, basic constitutional rights?
Well, the whole history of these things has been that, generally speaking, there is not a great change from changes in the people on the court. I think it could well be that if there is a more conservative majority on the court, that there will be less reaching out, less extending the law than there has been in the passed. On the other hand, I would not anticipate that there would be widespread overruling of past decisions, repudiation of what was done in the past. I would anticipate that the court would continue to build on what has been done, although it might not build as fast in some directions as some people might want.
If President Reagan had the opportunity to appoint 4 members of the court, as you hypothesized, Senator Heflin, certainly it would be a different court. It occurs to me, however, that President Nixon had that opportunity, and the court that Chief Justice Burger has just indicated a willingness to stand down from is probably not all as conservative as many would have thought at the time those appointments were made. So I'm not sure one can predict with any assurance exactly where it will be 10, 20 years out, even though obviously a president would like to leave a mark in that sense after his term of office is over.
Senator, if I may say 2 things about that. First of all, 4 Reagan appointments is of course unlikely. I wish there would be then more diversity. He could achieve that by appointing any member of this panel. I think that would be unlikely, though, that the president might do that. But it is very important to remember 2 things. The Supreme Court and the country are not really radically out of step at all times. And of course also the Supreme Court agenda changes as the country changes its own agenda. And therefore it is very hard to know how the Supreme Court will be and what it will rule 5, 6 years down the road, because it's very hard for us to predict the agenda. But I think it is very important to remember, furthermore, that many of the issues coming before the Supreme Court, even though styled constitutional in some form or another, are actually issues which come there as matters of interpretation, of long-standing law, statutes, and so on. If you don't like what the Supreme Court does in some areas, you can recapture a lot of power by passing more liberal or more enlightened or more forthcoming legislation in all areas of life. Let me just give you an example. Judge Scalia had to pass recently in a case which involved attaching the label political propaganda to an import of a film from Canada. And he upheld the labeling. Well, this was done under an extremely offensive act of Congress. And you should not get upset about the Supreme Court or other judges not upholding First Amendment values when you have it in your power to see to it that the First Amendment values are incorporated into the statutes.
Senator, I would say that if the President were so fortunate as to have 2 more appointments, and they were equally as good as Judge Scalia, that the practicing bar, of which I am a part, would be fortunate in having fewer fragmented decisions and greater clarity and lucidity in expression. And that would be a great help to the public at large and to the body politic. And that was, in fact, one of the points I sought to make in my opening remarks.
You didn't answer my question. My question was, would you expect the trend to change relative to certain constitutional rights, not the fragmentation of the opinions?
I find it difficult where there are fragmented opinions to discern the trend. And that is what troubles the bar. And forgive me because I have adopted the remarks that have been made preceding me and have just added this small postscript to it, acknowledging the limitations of time, but I do adopt the comments of my colleagues on the panel.
Bless you.
And I think the trend is very difficult in the 4 areas that you specified often to find.
Well, you've answered that.
Senator Heflin, the bête noire of the neoconservative legal philosophers today is the Warren Court. The Warren Court included the Chief Justice, Justice Brennan, Justice Harlan, Justice Stewart, all, I believe, appointed by President Eisenhower. the first Republican president in a great many years. They were pillars of the Warren Court decisions in the field of minority rights and First Amendment rights, among others. I'm not going to sit here and say to you, I think the trend of this court's opinions are going to be exactly the same if President Reagan has 4 appointees as if President Carter had 4 appointees. But it may turn out, and history tends to confirm this, not only the institutional history of the court, but the tremendous value of the lifetime appointment, that whatever President Reagan's intentions or his advisors' intentions may have been, he may be in for a big surprise. And the court will stick to the values that you and every member of this panel think are important.
Well, basically, to summarize, you as a distinguished group of legal scholars, practitioners, and generally leaders in the legal profession, and you don't have as much fears as some have in this area. Is that a fair summary?
No.
That's all right. That's all.
He's through, Judge. The distinguished senator from Illinois.
Thank you, Mr. Chairman. I shall be very brief. First, I agree, Mr. Chairman. Mr. Chairman, if I may have your attention. If I may have your attention, Mr. Chairman, I agree with you. This is a very distinguished panel, as fine a panel as we've ever had. And I note that they're very credible because 3 of the 5 members of the panel opposed the Mannion nomination, Mr. Chairman. I think that gives them added credibility here.
Well, anybody can make a mistake sometimes.
Let me, and not a question because I think they have addressed this. I'm one who has not made a commitment on this nominee. I am leaning toward voting for him, but the question that has been addressed, and I mentioned this for other panels who will be appearing, the question is the open-mindedness. And I think, Mr. Cutler, you phrased it well, that we should reject a nominee, and I'm quoting now, whose ideology so dominates his thinking that he cannot make impartial judgments. I am concerned in the affirmative action area, in the First Amendment area. Will Judge Scalia be as open-minded as President Verkyle has suggested in his remarks? That is my concern. You have addressed it, and I appreciate your appearing here today. I have no questions, Mr. Chairman.
You through with it?
Well, let me just say something, if I could, Mr. Chairman.
You won't ask any questions.
Sure. Let me just say something to this panel. I don't know of a more distinguished panel we could have before this committee. And I have been, I myself had to go back to the office, but I watched you on television and listened to what you've had to say. And it's not only impressive, but I think very erudite and accurate. And I just want to personally compliment all of you for coming here and testifying to this committee. I have admiration for each of you, as you know, and appreciate having heard.
Thank you.
I want to interrupt the proceedings just a moment here, make an announcement. There has been an apparent leak of information contained in confidential internal documents of the Internal Department of Justice documents provided yesterday to this committee. This is a serious breach of the agreement we reached on the review of these documents. It is also a breach of trust. Staff viewing these documents was admonished yesterday about unauthorized disclosure of any information in the Office of Legal Counsel documents. I am personally angered by this action and consider it irresponsible and unbecoming of anyone entrusted with the task of living by the letter and spirit of the agreement we reached on these documents. That is precisely why the President was reluctant about turning over these documents in the first place. As chairman of the committee, I will not tolerate these kinds of disclosures. These are confidential documents, and as such are not within the public domain. For that reason, I am today asking that the FBI determine whether the matter should be investigated.
Mr. Chairman?
Same senator from Utah.
Mr. Chairman, to my knowledge, I'm the only senator who has looked at every page of these documents, other than the 6 Senate staffers who have been reviewing them themselves. And I will not discuss any of the contents of those memoranda, but I can assure everybody that these were legal memoranda on legal issues. And I don't think anybody would find, any true lawyer would find fault with the memoranda themselves. You might differ with opinions, legal opinions, and different interpretations of legal cases, but I don't think anybody would differ with them. And frankly, the memoranda basically contain advice to their client that would not be objectionable to any lawyer or citizen upon careful review, it seems to me, although I can say lawyers differ on various legal cases, on various interpretations and twists of legal cases. Now, it was my understanding that these documents were to be held fully confidential, and that was the only reason that they were to be shared to aid in this constitutional process. So if they have in fact been leaked, it's an ethical violation, I think, of the highest order under these circumstances. Now, I will just say this, Mr. Chairman. I respect every colleague on this committee. And I think every colleague here has acquitted himself well. But I also have been privy to basically all of the outside of committee discussions. And I've been privy to some of the other discussions as well. And I can tell you that there have been some threats thrown around, and there has been some I think, tendency to not be totally fair in the Rehnquist hearings. And I've been personally very disappointed in that. Because we're not just talking about any nomination, we're talking about the nomination for the Chief Justice of the United States. And I think that's pretty important. So I'm really disappointed if any of these staffers has disclosed one line of those documents. But I assure everybody here that, yeah, I think activists, extreme activists on either side could point to a line here or a line there that they might not like, but basically they could not say that these were not appropriate legal memoranda or that they gave inappropriate legal advice. So I just want to put that in the record. I agree with you, Mr. Chairman. I will join with you. If, in fact, the committee rules and ethics rules of the Senate have been violated, and if, in fact, any laws have been violated, I would join with you in doing everything I can to see that that's rectified. I just want to thank you for sharing this and raising this, but it's terribly disturbing to me, because we worked out among senators and staff were there, I think, a totally inviolate agreement. And if this is the way these matters are going to be handled, then I think it lends not only great credibility, but it lends absolute legal sanction to any president saying, I'll never give up. I will never give up any confidential legal memoranda from the Office of Legal Policy. Just that simple. I wouldn't have blamed any president for not wanting to have that office intruded upon by a legislative process. We surely, under the speech and debate clause, never give them anything. Now, true, that is explicitly mentioned in the Constitution, but executive privilege is also a time-honored constitutional right, and especially in this instance. And I don't think there's a constitutional authority alive who would say that if the president had held his ground and said, we're not going to give those documents, that the Supreme Court of the United States in the ultimate instance would have force the president to give those documents up. I think the Supreme Court would have undoubtedly reached the conclusion in the future that it was a political question, even though there are lots of other questions and peripheral questions surrounding that issue. But it's a very disappointing thing to me, and frankly, if it's true, I think something has to be done about it. Thank you, Mr. Chairman. I don't want to be rated, but I'm very disappointed.
Mr. Chairman.
Senior Senator from Alabama.
I know nothing about this, and I happen to be the only Democrat that's present, and there may well be some type of response that they would like to make. I think there are a good deal of charges being made, and the opportunity is being taken here, perhaps unfairly. I'm just saying perhaps, I'm not saying it has been, to make certain charges. I would also say that I'm not in the position of being as a member of the Ethics Committee that this matter would come before us. So at this time, I don't have any response one way or the other because I don't know, and otherwise I might be in a conflict of interest between the committees. But I would say that if there has been any violation, certainly from the Ethics Committee's viewpoint, they would want it thoroughly investigated and thoroughly explored. And if any person has violated any agreement or anything else, I think that they would certainly want to look into it and take appropriate action.
Any more questions of this panel? Again, I want to express my deep appreciation to the able and distinguished members of this panel who have come and testified. We appreciate your presence, and you're now excused, and we're going to recess now until...
Be Ms. Eleanor Smeal of the National Organization for Women, Mr. Lawrence Gold, General Counsel of the American Federation of Labor and Congress of Industrial Organizations, and Mr. Joseph Rao, who will appear for the Americans for Democratic Action. Joe, before you sit down, if you'll all rise, be sworn. Raise your right hand. You swear the testimony you will give in this proceeding will be the truth, the whole truth, and nothing but the truth. So help you God. I do. I do. You didn't know how Southern I was when I said you all. Ms. Smeal, do you want to begin this panel's discussion? We will observe the rule, the 3-minute rule. The lights will indicate the time.
Okay, thank you, Senator. I'm delivering this testimony on behalf of the National Organization for Women and the National Women's Political Caucus. As the president of the National Organization for Women, I am representing the largest feminist organization in the United States that is interested in sex discrimination, eliminating sex discrimination in many different areas. The National Women's Political Caucus is the largest organization of its kind. It's a bipartisan organization determined to eliminate sex discrimination in the political arena. Our testimony is based upon a review of some 120 law cases that Judge Scalia wrote at the circuit court level. Of course, the bulk of these cases are in the area of administrative law, so it is we have to only review those cases that cover on point those issues that we're very, very concerned with. Because the court record was very brief, he's only been on that court 4 years, we'd also turn to his writings in journals, and we also turn to his speeches for his opinions in the areas of constitutional law. There are 3 significant areas that concern us, and for the reason that we stand today to oppose his nomination as a Associate Justice of the United States Supreme Court. Those three areas are affirmative action, his hostility towards the enforcement of the remedial anti-discrimination laws passed by Congress, and his philosophy on individual constitutional rights. Let me move quickly to the areas, and of course 3 minutes won't give me adequate time to review his writings and his work, but let me move quickly to the area of affirmative action. He has been quite clear on what he thinks of affirmative action. To quote, "I have grave doubts about the wisdom of where we're going in affirmative action and in equal protection generally." He goes on to say, "I frankly find this area an embarrassment to teach." He says that there are examples abound to support my suggestion that this area is full of pretense or self-delusion. He essentially takes the position of being a foe of affirmative action. I don't think an objective person could read his writings and come up with any other conclusion. In fact, he has a concept that as the son of Sicilian immigrants, he shares no burden to repay a debt to a group his ancestors he believed never wronged. I wanted to call attention to his quotes in this area because at a personal level, I find it very difficult to sit here in opposition to the nomination of the first Italian American. I am a person who believes in breaking down barriers, and am a daughter of Italian American immigrants. But my experience has led me to the exact opposite conclusion. I believe it is necessary to have affirmative action. I'm also very, very concerned with his use of the law and the cases. He seeks to strike down or to most limitedly interpret both race and sex discrimination laws, and he seeks to give the most narrow interpretation on remedies. For example, on the 9-0 decision in sexual harassment that was just handed down, he would have been the lone voice against it, saying sexual harassment does not fall under the sex discrimination restraints laws of Title VII.
I'm afraid I have got to enforce the 3-minute rule, but we'll have an opportunity to ask some questions and get back to some of the examples you're interested in. Mr. Gold?
Thank you, Senator. The AFL-CIO is not asked to testify to argue for or against Judge Scalia's nomination, but to voice certain concerns about his conception of the Constitution and of the lawmaking process, and to ask the committee to explore in depth certain issues we believe are of great consequence. Our views are tentative because while we have read all of his legal writings, that effort has yielded only a limited number of relevant pieces of information, principally in his occasional academic pieces. Against that background, we wish to make the following points. First, it appears to us that Judge Scalia is intent on demoting Congress from its primary place in making national policy. His views on statutory construction, on standing, on the president's appointment power, on the non-delegation doctrine, and on the legislative veto are tied together by the common thread that in each instance he would hobble Congress and aggrandize executive power. Second, we would suggest that Judge Scalia's conception of the judicial role in interpreting and enforcing the Bill of Rights leaves little, if anything, of substance. His most telling quote is that the Bill of Rights, to some degree, is like a commercial loan. You can only get it if at the time you don't need it. What that would leave of the legitimacy of Brown versus the Board of Education, New York Times versus Sullivan, or Baker versus Carr, to note only 3 decisions which we believe were not only right but necessary, is difficult for us to discern. Finally, we wish to point out that the discontinuity in Judge Scalia's approach to issues concerning the allocation of power between Congress, the President, and the judiciary, and his approach to issues concerning the power of government over the individual indicates that his legal positions are not the product of the doctrine of judicial restraint, but of his own social and political views. His inventiveness in finding limitations on the legislative power stands in stark contrast to his quietist position on the guarantees of individual rights. It is the committee record on these matters that will determine our position on Judge Scalia's nomination, and that we hope will determine the committee's position. Thank you.
Mr. Rao. My name is Joseph L. Rao, Jr. I appear here this afternoon on behalf of the Americans for Democratic Action and the Leadership Conference on Civil Rights. Mr. Kerr, who was to appear and whose statement is submitted for the record, is unavoidably detained in Pittsburgh. The Leadership Conference, as Senator Mathias so well knows, is made up of the leading civil rights groups, blacks, Hispanics, etc., and I speak for them. A few groups don't take positions, but all who do take positions are opposed to Judge Scalia. I have a preliminary point, sir. I think this committee is out of order. There is no vacancy for which this Judge Scalia is being proposed. I know what the trick is. The trick is to make it look to the public as though the Rehnquist nomination was obvious. Well, I think after what has happened here last week, it is perfectly clear that there is a real question whether Mr. Rehnquist will be confirmed. If he is not confirmed, there is no vacancy. I think the idea of going ahead with a argument of this kind, with a hearing of this kind, when there's for a job for which there's no vacancy, is a terrible mistake. As far as the using of the 3 minutes is concerned, well, I'd simply like to say that I think the prestigious pre-lunch panel proved the case against their own arguments. They answered a question which I thought was a very good question from one of the members of the committee. What's the difference between Scalia and Rehnquist? All you got out of them was that there was no difference. Well, then if the decision of the Senate is against Rehnquist, as I hope and trust it will be, I think they made their case. Mr. Kerr makes a very good point in his statement to be submitted, in which he says, Judge Scalia believes in all checks and no balances. If you took his theory, you'd still have Plessy against Ferguson. You wouldn't have the Gideon case. You wouldn't have Mapp against Ohio. You wouldn't have Loving against Virginia. You wouldn't really have any of the great advances that were made, because he says, if we've gone on a certain society, we've gone on a certain way, you don't change that until society changes. Well, I don't think that's the way the Constitution's to be read. I've never seen a situation where a judge so threw himself really out in the open as clearly, and it's all in the record of this hearing, as Mr. Gold said. Look at this record. There's only one way you can decide, and that is that neither of them should be confirmed. Thank you. I see my time is up.
Thank you very much, Mr. Rao. Let me start with Ms. Meehl. You quoted from a lecture that Judge Scalia had given that it was an embarrassment to teach on the subject of affirmative action. Do you know the date of that lecture?
It's 1979, I believe. Yes, winter of 79. It's at least it appeared in a law quarterly at that date.
Right. That was prior to the recent decision in which Justice O'Connor noted that the court had reached a consensus in this area. Won't that affect the situation? Won't this new consensus be articulated in a very strong way to sustain the doctrine of affirmative action?
Well, I noticed, sir, that I think it was you, that Senator, that asked him this question yesterday, or at least Judge Scalia was asked the question about the new consensus that was articulated by Judge O'Connor. And essentially what he said was he didn't answer. He did not assume that there was a new consensus, nor did he assume that it would, whatever this new consensus, the new consensus for, would be affirmed. He said it would depend on what 5 judges would say. Essentially, from his writings, I would have to say that I think that he will not be a person supporting a strong consensus for affirmative action. I think that he will try to find every loophole. You don't have to find this just in his writings, such as a law journal article like this. You can look at his own court cases. I admit there are not many of them, but he talks about intent. He talks about, is there intent to discriminate on the basis of race? And essentially, I think my ears are very attuned to the words of the opponents of of affirmative action. Those who are opposed now want us to say that there really isn't a discrimination unless there is an intent to discriminate, a motive. And when you go down that path, you really aren't going to see much discrimination. You're going to only be able to see it when it bites you in the nose. And yet, even in some cases where I would say that it was naked discrimination, I cite another case where a woman was totally segregated in her workplace, et cetera. He didn't see this as really apparent discrimination. So I would say from his interpretation of the cases and his views on affirmative action that he will be a part of that consensus narrowing it. And let's face it, the decisions on affirmative action, some parts of them have been very close, 5-4 decisions. And so I think that he could indeed cast a vote against. That would be decisive.
Mr. Rao, you said that the panel, the pre-lunch panel, had come to the conclusion that there was very little difference between Justice Rehnquist and Judge Scalia. Without challenging either you or them, let me suggest that for the purposes of a confirmation hearing, it might be more interesting for the committee to speculate about the differences between Judge Scalia and the departing member of the court, Chief Justice Berger. What differences do you see there?
May I first say that one of the members of the pre-lunch panel spoke of you and what you had done, and I felt remiss that I hadn't done that when I testified last week. I can think of no one that the civil rights movement is going to miss more, or that I will personally miss more, than you, Senator Mathias, after your departure. You and Clarence Mitchell and I go back a long way together. I guess I go back the longest way together. And I don't know of anyone who's done as much for the cause of civil rights as you have. And at times I wonder, heavens, what courage it took, not in a state where the minorities were such a big part, but in a state with some Southern tradition, that you should have been able to accomplish what you have. And I personally want to thank you from the bottom of my heart.
You're extremely generous, and I appreciate it. And I appreciate those sentiments all the more because I know they're not unanimous.
With respect to a comparison of Judge Scalia and Chief Justice Berger, I would say there will be a significant drift to the right as a result of that change. Justice Berger really only dealt with the interstices of the matter when he dealt with one of the old Warren advances. In other words, Justice Berger did not try to reverse anything of the Warren Court. There were times when he nibbled at it. I'm not saying that Justice Berger doesn't have some pretty bad decisions, but they are not a head-on collision with the Warren Court. I think Judge Scalia is going to take a head-on collision for the things he wants to change. Furthermore, one should say of Justice Berger that there are some things in there that are great advances. Many people have referred to the abortion decision as a great advance on the civil rights front, but I will not go into that, as that happens to be an issue on which the Leadership Conference does not have a position. We are a coalition of 185 organizations, and some of the Catholic groups do not agree with the majority in that respect. But you have the busing case, Charlotte Mecklenburg. That was a tremendous advance for civil rights. You have some of he's been on both sides on the affirmative action, but it only illustrates the point I'm making, that he wasn't trying to upset what the Warren Court did. He simply, on occasion, sort of drew it back a bit. I think now the shift of Scalia for Berger is going to have a real major effect. Now, one may say, well, you have to wait for one more justice or so forth. I don't know whether that's true. Some of the 5-4 decisions where Berger was on the liberal side may go. So I think this is a very serious thing that's being considered here in regard to Judge Scalia, and I agree with you. From the point of view of the long run of the court, the substitution of Scalia for Berger is probably a greater right-wing swing than the substitution of Rehnquist in the Chief Judge spot for Chief Judge Berger.
Would you like to comment on that, Mr. Gold?
Yes, thank you, Senator. It seems to me, first of all, that to judge him from his writings, because his judicial opinions are not that numerous, and as a junior member of the D.C. Circuit, he seems to have drawn his fair share of the less enviable assignments in opinion writing, that Judge Scalia is a much more doctrinaire person than Chief Justice Berger was. I'm uncomfortable, too, with treating both the what I would call the questions concerning the allocation of power between the different branches of the government and the questions concerning the Bill of Rights as conservative liberal issues or left right issues. On the questions concerning the role of Congress, it seems to me, as we note in our testimony, that Judge Scalia promises to be a more wrong-headed figure than Chief Justice Berger ever was. Again, while we have very little information on how he would view the Constitution in terms of his judicial writings, what we do know suggests that Judge Scalia takes an extremely skeptical view of judicial enforcement of the basic guarantees of the Bill of Rights. I do think that the one point, and probably the only point I agreed with the distinguished panel which preceded us on, is that if you judge from the secondary writings, Judge Scalia's constitutional decisions concerning the Bill of Rights are apt to look very, very much like Justice Rehnquist's record over the past 16 years. In other words, the most limited view of those guarantees among a group of jurists who overall take a very limited view. And in those terms, certainly we were very disappointed to hear what we did hear of yesterday's testimony, a point that Senator DeConcini referred to today. It was our hope, and it continues to be our hope, that this committee will be able to ascertain more about what Judge Scalia's overall approach is on Bill of Rights questions. Right now, we don't know much, and what we do know is most disconcerting.
We're going to...
I wanted just to throw one in the area of sex discrimination. He would be definitely a big a move to the right from Berger. For example, in that sexual harassment case that was just decided, part of it was a 5-4 decision on whether the person should be strictly liable. According to Scalia's interpretation of the decision at the lower level, he would have had no liability on this case for an employer, which would have been narrowing Title VII even more. And on individual rights, what he keeps saying is that he thinks that the court should not invent any right, and what rights are to him is what the majority says they are, or whether there's a consensus about a right. And if we have to depend on consensus for rights for women, we have a long way to go. And then he even modifies it and says it either has to be a current consensus or a past consensus. Well, obviously, we can't look to past history for consensus for equality for women. And what does he call a consensus? What percentage? Majority? Much more than majority? According to the dictionary, it means almost everyone. So I think he would be definitely narrowing the rights, and of course the right to privacy he has disparaged. He has said that he would not be for it, and of course Berger did vote for Roe versus Wade.
Well, I thank all of you for being with us.
Senator, some of the Democratic senators had indicated they did want to...
Well, I was just about to address that problem.
Thank you, sir.
I've just been advised that there's some developments in the Senate which have delayed other members of the committee. First of all, let me say that your written statements will all be included in the record as if read. We will keep the record open because Democratic all senators, both sides, who have been delayed and unable to be here may have questions. And we can propound those questions to you in writing, or we can call you back as the need may be and subject to your availability.
Well, can we remain here and in the hope that we would be here after the vote? I understand there's a cloture voted too. Is that right, sir?
Well, that is apparently being delayed, but that's some of the uncertainties of this moment. So what I'm going to suggest is that we take a 45-minute recess, at which time we will resume if you're able to stay and if there are questions for you, why we can deal with that.
I've talked to the two panelists.
But we'll stand in recess for 45 minutes.
Yeah.
I'm going to get you the floor.
The hearing of the Committee on Judiciary will reconvene, and at the adjournment or at the recess, there was a suggesting that other members may want to ask panel 2 questions. On the Democrat side, are there members desiring to ask questions of panel 2? If so, we'll call them back.
Who was,
Schmiel.
Schmiel, Gold, and Ron.
Schmiel,
Yeah.
Lawrence Gold.
Mr. Chairman?
Joseph Ralph.
Yeah, I would just have one question.
Okay, then the panel 2 will come back to the table. Okay, and staff advises the panel that they're still under oath, and so we'll go to Senator from Illinois.
And forgive me for not being here, and specifically, now I have panel, Larry Gold, I guess I'm directing this question to you. The position of the AFL-CIO on both nominees.
Senator, in the testimony, we outline our position, and it is the following. First of all, we oppose the nomination of Justice Rehnquist to be Chief Justice. We oppose his nomination to be an Associate Justice, and 16 years on the court have unfortunately confirmed that we were right in opposing him at that time. We oppose him primarily because his record on individual rights is one of the most negative and unforthcoming of any judge in recent memory. With regard to Judge Scalia, we have posed a series of questions. His judicial record is so much briefer than Justice Rehnquist's. His writings are so relatively sparse that we are not yet prepared to take a position. We have raised questions. We do hope that the committee will explore those questions. As I did in my statement, I want to particularly underline our intense concern about Judge Scalia's stated positions with regard to the relative power of Congress to make national policy. We find his views on statutory construction and the freedom of the executive branch to disregard congressional intent on standing, particularly with regard to to acts of non-enforcement of broadly phrased congressional acts by the executive. His rejection, so far as we can judge from his writings, of congressional power to set up independent agencies and otherwise to control the executive branch to assure fair and effective enforcement of congressional actions, and of his position on the non-delegation doctrine, which I think would hobble the legislative branch, to be all part of a piece which tends to shift power to the executive, to limit Congress's power, and to make it extraordinarily difficult for Congress to act effectively, to regulate the myriad of things, particularly in the economic life of the country, that need to be regulated in the public interest. If Congress isn't willing to protect its own prerogatives in this regard, nobody will. And to the extent that the appointment power is used by the President to affect the balance of power between the legislative and the executive branch, we look to this committee to satisfy itself either that we're wrong or not to confirm this nominee. In that regard, I want to say that our position is in no way one without self-interest. The labor movement has attempted to make its way by lobbying, by political action, by making arguments to the popular branches. We're content overall, against the background of a Bill of Rights, to proceed in that way. We don't believe that Congress's authority in the areas not covered by the Bill of Rights ought to be ceded to the executive branch. And we press these views on all members of the committee, both the Republican members and the Democrats, the conservatives, and the liberals, because we think these balance of power issues are not ones which divide the Congress in the same way that certain of the other issues that judicial nominations raise may do.
I thank you. I might add for members of the committee, talking about Justice Rehnquist, I received a letter, maybe the other members did too, that he has resigned from the Alfalfa Club. Matter of some interest.
Senator from Ohio.
Chairman, I just have a couple of questions. I wasn't here earlier when Ms. Smeal spoke. Do I understand now opposes confirmation of Judge Scalia?
Yes, I'm speaking for now in the National Women's Political Caucus also.
And the what?
And the National Women's Political Caucus.
And do you find acceptable the distinction that the judge made between discrimination against women and that which is described by the American Bar Association as invidious discrimination? Does it make you and your members feel better if it's not invidious, it's just plain good old?
I'm so glad you asked the question of me. Obviously, his statement about the Cosmos Club, that he didn't think that it was a club that engaged in invidious discrimination when it totally excludes women, is distressing and upsetting. But I personally think it reflects what he has written on the subject of sex discrimination. Essentially, he does not view it as strongly as he does race, and on race discrimination, he's disparaging. There's a lot of ridicule and hostility, but really a lot of joking around about the remedial solutions that are. I think it's more demeaning when you joke. In the decision on sexual harassment, he doesn't see it as sex discrimination or something that a lawyer would have any liability on because it's personal. Well, if all sex discrimination could be looked at as personal, and he, in this position, has the most extreme position, because even the court, he didn't view it as a form of discrimination at all, and 9-0 they did now, but on liability, he has a position that wasn't even voiced. So I would say it was upsetting. How could anybody say it's not an unfair form of discrimination or a harmful form or invidious that you exclude women simply because they're women in this day and age?
Joe Rall, you're appearing on behalf of whom?
I appear this afternoon, sir, on behalf of the Americans for Democratic Action and the Leadership Conference on Civil Rights. I spoke for both when I said that we feel very strongly that the shift to the right that Justice Scalia would be over Chief Justice Berger would make a very tremendous difference. I guess if I had to put it in a simple sentence, I'd say Judge Scalia's got ice water in his veins when a Supreme Court justice ought to really have a feeling of compassion. He makes jokes. Mrs. Smeal made that too. He makes jokes about things we believe in deeply. He laughs at affirmative action. That stuff has been quoted in the record here. I can't understand putting on the Supreme Court someone who laughs at affirmative action. I'm not saying I'm right that you have to do everything I want on affirmative action. I'm saying it's a serious problem. How do we remedy the past wrongs that have been done women and blacks and Hispanics? That's a serious problem, ought to be discussed. Scalia, as a professor, laughed at that problem. I say he's not qualified to be on the Supreme Court.
Does the Leadership Conference have a position for or against Judge Scalia's confirmation?
The Leadership Conference voted unanimously in its executive session to oppose both Justice Rehnquist and Judge Scalia.
And Mr. Gold, I read your statement, which I read to indicate maybe. You say, like this committee, we will resolve these doubts and base our final judgment on his nomination on the record that this committee develops in the course of these hearings. We've now heard from Judge Scalia. The rest of the witnesses are either pro or con. They will indicate their position. Will probably be no great surprises. But the inquiry concerning Judge Scalia himself is now concluded. On the basis of that, how does the AFL-CIO vote?
I have to admit to you, Senator Metzenbaum, that yesterday the AFL-CIO Executive Council was meeting, and we were tending to the business of that meeting, which comes once every quarter. I haven't had an opportunity to review the transcript or to see the television tapes. I only know what I heard this morning from Senators DeConcini and Heflin, and it doesn't sound as if Judge Scalia was very forthcoming in responding to inquiries on
Neither are you.
his position.
Neither are you. I don't know what you're saying. I mean, you're
I'm saying
that there are lots of problems, but we can't vote maybe. And I think that your views are relevant. You think they're important enough to come up here and testify. I think that AFL-CIO or any other group comes before us, just can't say we're concerned, now it's your baby. Because without taking a position, I don't find...
Senator, first of all, I never despair about the possibility of reasoned discussion. And secondly, we have no intention of taking no position. We want to know more than we know now before we take a position, and I'm never ashamed of that either.
Well, I would hope that before this matter comes to the floor, at the very minimum, that you have a position, you share it with us, and not wring your hands in dismay after that decision's been arrived at.
We have never been shy at stating our views, and there isn't enough time with all the things that are going on to wring one's hands.
Thank you, Mr. Gold.
Senator Biden. Thank you. Question for all three of you. Yesterday, Judge Scalia indicated that, as he put it, and I quote, he has no fully framed omnibus view of the Constitution, that he is not committed to any particular agenda on the court, and that he would recuse himself if he felt so strongly on a moral or personal basis that he could not rule impartially. How do you square these comments with your assessment of Judge Scalia?
I find it very difficult. I mean, the judge is a professor. He has I would say, just my humble opinion, a well-developed view of the Constitution. I don't happen to agree with it, but it's certainly developed. He's written about it. His notions about individual rights, that they must be based on a consensus, either a present consensus or a past consensus, I feel are just fly in the face of everything we know about individual rights and the pursuit of them in the history, a 200-year history of our country. I don't understand how he thinks we could have fought racial discrimination if we had to wait for a consensus. I don't understand how we're ever going to fight successfully any form of discrimination if we have to wait for consensus. He uses his words very, very carefully. He also has an idea that essentially that what rights are is what the majority says. A democracy, I think you referred to it again yesterday, but I view and I think that those of us fighting for elimination of discrimination, that there are certain guarantees and rights under the Constitution that are not according to the whim of what the majority might be at a given time. So anyway, I think that he has a very well-developed view. As far as about recusing himself, if you noticed when he was asked about questions on abortion or Roe versus Wade, he did not say he would recuse himself. He said he did not have an opinion on this, but in my review of his writings, he was very critical of the Roe versus Wade decision.
On the substance or its logic? Because I reviewed his writings too, and I could not find, and you'd be very helpful to me if you could point out for me, and I don't mean to put you on the spot now, you don't have to do it now, you can now, but also before this, we close this vote out. As I reviewed his writings, there wasn't any particular place where he said that Roe v. Wade was in fact incorrectly decided. It is in fact now there may be where he said that, but I'd like to know. And secondly, there is an overwhelming universal criticism by proponents of pro-choice and opponents of pro-choice that Roe v. Wade was not a very well-reasoned decision. Most constitutional scholars do not offer that as an example of, whether they're for or against abortion, a decision that is well-written and well-reasoned. Not the conclusions, but it's not offered as a way to write a decision. And so that my understanding, I searched long and hard, and I asked my staff, excuse me, did we find anything? And we could not find anything that would be able, or I'd be able to say, that Justice Rehnquist indicated that Roe v. Wade was wrongly decided.
Well, Senator, it was my understanding, and I'll show you our quotes or our cites, is that he uses it as an illustration of when the court invents a right that is not specified anywhere else and is not a consensus in the public and not a consensus in the past, and therefore was erroneous. I mean, that is the only inference that you can draw from his illustrations as the invention of a right.
I apologize for not being here for your testimony. As you know, we had a little tempest in a teapot here a moment ago, that I've been spending more of my time during the Scalia hearings being a traffic cop than I have being able to thoroughly and consistently interrogate Judge Scalia. But I would really, I will read your statement, and I apologize because I take your criticisms and your position very seriously, and I will go back and read the statement. But if it's not in the statement with any specificity, to the extent that you can augment the statement, I'd find it very helpful.
It's in the statement briefly, but we will augment it. We feel strongly that that he illustrates it, he uses this as an example, but also, frankly, it troubles me when he says that rights must be based on a consensus. Because just the word consensus even worries me, because if you look it up in a dictionary, that means almost everyone must agree, and if women are going to wait that long, my children, grandchildren, and their children's children will be not seeing equality for American women.
Well, let me point out one other thing. And I'd like Mr. Rao to comment on this because it's a good place to, if you will, jump off to the next point and ask Mr. Rao to comment. When I pressed him yesterday, before I was humorously and somewhat summarily cut off by the distinguished senator from Maryland, I understood that he was making a real distinction based upon his use of the phrase consensus, the word consensus. My understanding of his response to my question along the lines of whether or not you required a societal consensus to affirm a right that wasn't explicitly granted in the Constitution under his doctrine of original meaning, which he distanced himself from yesterday with some rapidity, that he said that no, Senator, I'm paraphrasing, no, Senator, you don't require a consensus to acknowledge a right existing where, in fact, it's clear that it was intended there was a right to exist, and he made a distinction between race discrimination under the 14th Amendment, which didn't require a consensus, even though it didn't specifically mention race, and other kinds of other rights that might or might not be viewed in the context of the 9th Amendment or any other amendment. And the second thing, and this is more a recitation, Mr. Rao, than a question, but I'd like you to respond to these three because I think they all three fit. The third piece was that, as I saw it, he was making the case that he acknowledged the existence of certain rights within the Constitution that were not specifically enumerated within the Constitution. And I quite frankly found if you took only his answer was a fairly reasoned, rational answer. Because as he points out, that the court, all members of the court, all sitting members of the court, put it another way, none of the sitting members of the court have used the same standard for determining whether or not discrimination existed as a consequence of the violation of the Due Process Clause or Equal Protection Clause of the 14th Amendment. None of them have used the same standard under the 14th Amendment, judging discrimination against women as against blacks. They all make gradations. Now, how does it paint him outside the mainstream, if that's necessary, and you may conclude it's not? How is he markedly different than any other judge? Because Ms. Schmiel makes a compelling case that women should be treated precisely like blacks for purposes of the 14th Amendment, yet not a single justice, to the best of my knowledge, has so treated them. How do you respond to those three areas, or in any way you want to speak?
Very hard even to remember the three areas, but I'll do the best I can, Senator. First, on the question of whether he has an agenda, Judge Scalia is fooling somebody. He's either fooling the President of the United States or he's trying to fool this committee. Because the President of the United States in a speech yesterday said that through the appointment of over 40% of the courts, meaning federal and lower courts, and the Supreme Court, he, the President, had an agenda on the abortion prayer and other matters. Well, the President had a talk with Scalia before he appointed him, and either the Scalia fooled the President that he had an agenda, or he's fooling you when he says he hasn't. I don't know which way it goes, but I do know that you can't have it. He can't have it both ways. Second, on the question of consensus, all I can say is that's not what he wrote, Senator Biden. He wrote that if there's something in our society where rights are fixed by for a long time, you can't change that till you get a consensus. He said, for example, you'd still have Plessy and Ferguson. My God, we had it for almost 60 years.
But his response to that was that clearly was not what he meant.
Well, all I can say is that is nonsense. Because if all I listen to are all these people saying he's probably the most articulate writer in America, and now he's telling you he didn't mean exactly what he said. Now I don't know. You can't have, again, he's trying to have it both ways. He's a great writer. He gets everything exactly right. He's the most articulate man in America. But now on this most important subject like this, he says he didn't mean what he said. And thirdly, I'm not enough of a scholar of the 14th Amendment and on the sex problem to say that every Supreme Court judge has accepted a differentiation. They may have, I'm not sure, but at least he has always gone for the lowest standard, the one that will make it the hardest to prove discrimination against women.
Let me ask you, and again, before the record closes out, because it's a very important point to me, and I want to be fair to him, and I must acknowledge I'm inclined to the view that you hold. But if I look at his writings, he did not say what we're saying he said. I ask you to read, not at this moment, but if you read the so-called panhandle speech, where he in fact makes the assertions that we're speaking to here. He says, and I quote, "I do not care how analytically consistent with analogous precedent such a holding might be, nor how socially desirable in the judge's view. If it contradicts a long and continuing understanding of our society, as many of the Supreme Court's recent constitutional decisions referred to earlier do in fact, it's quite simply wrong. There will be no relief from the most far-reaching intrusion of the modern society until the Supreme Court returns to essentially common law view of approach to constitutional interpretation." Then you go back and look at what he's referred to. He has not referred to any race matters. He has not referred to any matters. He's referred to the question of obscenity, discipline for high school students, prayer in school, and I don't know what else. I have to go back and read it all. But he does not refer to abortion, women, race, or the things that concern me the most. Now, so it is, if we were, in fact, if he is as skillful a writer as we say, he is just that. He says, referring back to what he spoke to earlier. And in the above paragraph, he talks about certain things that are established, and he makes reference that the race and other things are established. And the reason why I asked him the question I did yesterday, Mr. Rao, if he subscribes to that position, then it seems to me, ironic as it may seem, he's going to be hard-pressed to overrule Roe v. Wade. Because if, in fact, he argues that there is, in fact, precedent, unless there's a clear consensus to change it. Roe v. Wade occurred how many years ago now?
1972.
1972, so what's that? 16 years ago, or 14 years ago.
1973.
73, 13 years ago. I became a senator because I couldn't add. But all kidding aside, it seems to me that you could easily make the argument that, in fact, he would be bound by that statement to, in fact, uphold Roe v. Wade.
But do you want me to read other statements?
Sure, yeah, no, I do. I truly want to know this. I'm not playing a game.
Well, here's a statement on, in the abortion situation, for example, what right exists? The right of a woman who wants an abortion to have one, or the right of the unborn child not to be aborted? It goes on for some things and then says, the court has enforced other rights, so-called, on which there is no societal agreement, from the abortion cases at one extreme to school dress codes and things of that sort. There is no national consensus about those things and never has been. The court has no business being there. That is one of the problems. They are calling rights things which we do not all agree on. And there's stuff in the middle that, to the bottom line.
What are you reading from? Can you tell me that? My time's up. I'm sorry, but tell me, what are you reading from, if you could, beyond your statement?
I'm reading from an article, but I'll give you the exact site on it.
Okay, you don't have to do it now. And I will come back because I didn't realize my colleague was waiting. I apologize.
It's all right. Go ahead.
May I finish the answer?
Sure.
Because I'm very glad that Ms. Smeal gave you that quote, because I think it was a very good one. I was going to read you the same thing you read me, so the same quote from Judge Scalia. The fact that he refers to a part of the constitutional problems and says uses those as examples certainly doesn't mean that he doesn't say the same thing with regard to race and sex. Indeed, since race and sex are really more important than these kind of problems, since discrimination, it seems to me, much more important, say, than pornography. Discrimination is the heart of our problem in America today. To stop it, I'd say that, for sure, what he's saying about those examples, he's saying about race, and he intended it to be interpreted that way.
But he specifically said yesterday it did not intend it to be race.
There's no logic on saying that this applies to the less important things, and that his views apply to the less important issues and not the more important issues.
Well,
sir.
I have no argument with you on philosophy. I do have an argument with you on interpretation of what he's saying. I mean, because in fact, anyway, you wanted to come.
Yeah, I wanted to say a few things about this. I find it difficult to determine whether he has an agenda or not, and that's one of the reasons we submitted the kind of testimony we submitted, and I'm very interested in what you've told us about his responses yesterday. He has relatively few judicial opinions on matters of great substance, and much of what we've brought to your attention is in these occasional academic pieces, most of which are not extraordinarily profound, at least as we read them. But it does seem to us, to go back to what I've said several times, that what he has chosen to say, and one of the panelists who preceded us said there's a great advantage in having an academic nominated for the court because he leaves a record in his writings of the kind that a practicing lawyer does not. What he has chosen to say in his writings does seem to be an agenda. And it is an agenda primarily which is designed to hobble the affirmative use of federal legislative power, and to transfer, as we've said, to the extent that the legislature chooses to act, the final trump card from the legislature to the executive.
Assume that to be the case. Is that a radical view, or is that just a difference in philosophy?
To me, it doesn't matter whether it's a radical view.
Well, it does to me.
All right.
I'm asking you whether you think it is.
I think that it is one which profoundly changes the balance of power that the Constitution envisages. To say that it's radical asks me to say whether it's shared by others. To me, that isn't the question. I would hope that the question for members of the Senate is whether the view is deeply held and sufficiently wrong that the president should not be able to steal a march in that particular way.
Not you philosophically agree or disagree with them. What you think is wrong, what I think is wrong, is not what a majority of this committee thinks is wrong, probably.
It may be or it may not. And to us, the test is the nominee's view of the Constitution sufficiently wrong that he's not worthy of confirmation. That's 50 plus 1. It is not a...
That's what's right and wrong, right? 50 plus 1.
It's 50 plus 1 people making up their mind about what's right or wrong.
That makes it wrong.
Right or wrong.
I don't have any further questions. I yield.
Let me make one comment, which you'll hear some speaking about well-reasoned opinions and consensus building. Sometimes well-reasoned opinions are sacrificed in order to build a consensus of a majority. Let me ask you basically the same question that I asked the other panel, in which they established, I think, fairly well, two assumptions that would be involved in this question. One, that Judge Scalia is an excellent consensus builder, and second, that he and Justice Rehnquist are closely aligned with some distinctions, as they pointed out, in ideology. Basing those assumptions that they are closely aligned and that that he is an excellent consensus builder, and make the further assumption that President Reagan appoints two other members of the court during his term of office. Then the question, what would be the trend of such court, is the first question. Second, as to whether you would expect any wholesale reversal of present holdings in areas that you might want to identify? And third, what position do you predict that history would give Judge Scalia if such a reversal movement occurred? Each of you can ask.
Well, on the first part, on building a consensus, you know, it's very hard to tell that, except that if he builds a consensus against what he has written on the subjects of minority rights and women's rights, and all I can deal with is what he's either publicly stated or written in his cases, it will be one that will pretty much gut affirmative action as we know it. It will be for sex discrimination even more disastrous because there are, I give you just a quote, under Title IX he writes an article which he questions what sex discrimination in federally assisted educational programs means, finds these too vague, even though there are federal regulations that have been enforced since 1974 saying what they mean. He says sexual harassment is individual and it's not discrimination in conditions of employment because of gender and should not be viewed as violation of Title VII. Right now, that is the most extreme position. That's even to the right of Mr. Rehnquist. So if he and Rehnquist build a consensus into that viewpoint, we are undoing, literally, the gains of the last 25 years for women's rights under the law. And of course, on race, it would be narrowing the remedial corrections of the past, because he questions whether the court should enforce enforce the measures to correct past discrimination. And without enforcement, I just don't think you can wait around for magic consensus. So I think that it would be a disaster, and that's why I think it's important enough for me and for our organizations to be up here testifying. And I think that more people should think of the philosophical viewpoint of these judges are important enough to just judge on themselves. I mean, these are hard. Everybody has to go with what they have before them. But to me, it indicates a direction away from the dream of equality for all. And I don't think we have, in 1986 going into the 21st century, I don't think we should be rehashing these 19th century problems under all kinds of rubrics, the role of the court, the role of this. But every time he discussed the role of the court, and by the way, Senator Biden, that article that I had, that other quote on abortion was an imperial judiciary, fact or myth. It was a public discussion of the American Enterprise Institute of 1978. But every time he discussed, does the role of the court go too far, his examples are in moral, social, discrimination type questions. That's why we're up here. The examples given are in the area of sex discrimination or the area of racial discrimination. And they are the ones that I think need the most protection of a Constitution that is not viewed as one of just getting consensus of the day or of the past, for heaven's sakes, where indeed we had a deplorable history of discrimination on the basis of race, ethnicity, and of sex. And so I feel that it's enough for us to be not only concerned about, but I think that we put too much on people's affability, too much on people's ability to be, to write, and we should take those as given that people are good-natured and that they can write well. I think what they write about should be what the issue is.
Senator Heflin, my answer to your question one on consensus building is you don't build a consensus from an extreme. I don't care how much affability you have, how much charm, and these were referred to by all five of the gentlemen, I think, about this great affability and great charm. You don't build a consensus from one end. You build it from some more moderate position. Second, I think he and Chief Justice Rehnquist are very closely aligned. I agree with the pre-lunch panel that our views are very close. Finally, with the idea of 2 more Rehnquist-Scalia type appointments, which I take it as the presumption of your question, God help us, is one of the things I would answer. But in addition to that, I'd say your affirmative action cases will be overruled, your school prayer cases will be overruled, your abortion cases will be overruled. That's not the worst of it. Rehnquist has been trying to get cert. Every time we win a big civil rights case in a court of appeals, these 4 would have whatever votes they need for cert. They could make the good courts of appeals say uncle on their support of civil rights. Your very fine 4th Circuit and 5th Circuits are going to go by the boards. They're going to have to follow whatever they do, even on factual things. Rehnquist wants to take cert. Well, you get 4 judges on that court like Rehnquist and Scalia, and it isn't only with the cases you're going to reverse, it's the reversal of the decisions you get enforcing the things that are the law now. And I would say that would be a tragedy for our country.
I've never met Judge Scalia, and I can't comment on his affability or his consensus-making powers. In terms of our best judgment from his writings, as the panel members this morning said, his votes are very likely to be similar to Justice Rehnquist. We have different degrees of certainty about what we know, but that would seem to be the probabilities, aside from what Senator Biden said about yesterday's discussion may have revealed. I think most to the point, though, is that the questions you raise get us back to the discussion I was having with Senator Biden. There is no doubt from what we know about the appointing process as it's being practiced. The President and his advisors have certain tests that they are applying to nominees. These are not individuals who have made their reputation through broad acceptance.
A priori, that would mean anyone that this administration sent up you'd be against, right? Any person at all.
I would begin with a healthy skepticism. And Senator Heflin's question is if the views of those who know him far better than I do, that Judge Scalia lines up with Justice Rehnquist, are taken as correct. And if 2 more people who share those views are appointed, what kind of a court would you have? I'm trying to answer that question, and I'm saying that the kind of court you would have would be a court which would rarely, if ever, uphold claims of individual right. And that's why, and it would be a court structured on that hypothesis to perform in precisely that way. And that brings us to the question of what is the role of the Senate? And it seems to us the role of the Senate is in the system of checks and balances to determine whether or not that tendency has to be checked and balanced. I see no escape from that, and it seems to me, as we argue in our testimony, to be inherent in the constitutional plan. The President doesn't have the right to shape the judiciary. He has the power of the initiative. And then there are 100 people with very difficult decisions to make about what the Constitution means, when enough is enough, and what the role of the court is, both with regard to the legislative power and with regard to the guarantees of individual rights.
I understand the point. The senator will yield for a question. I just remind my friends that in 1988, we will have a different president. And it may be a president that shares the point of view that I have, which is generally consistent with the point of view represented by the panel. And we may not have the Senate. And I hope we don't get read back all the remarks that are made here today about who has what choices and under what circumstances. I'm not at all certain, by your standard that you're outlining for me, which is technically correct in my view from reading of the intention of the Founding Fathers, that in fact, were I advising the next President of the United States and I found myself 3 Thurgood Marshals and sent them up here, that in fact, there would be no prospect of those 3 Thurgood Marshals being put on the court, applying the reasoning that you're applying here, if in fact the Senate were controlled by the Republican Party still.
May I remind the senator from Delaware that you have a good case for reading things back to the other side. When Abe Fortas was nominated for Chief Justice, the chairman of this committee, and there are undoubtedly others in the Congress and the Senate today, they opposed Fortas on philosophical grounds, wouldn't permit a hurry up, filibustered it, and beat it. And they beat it with through having a third plus one who said, well, all we're interested in is Fortas's philosophy. The issue of Wolfson had not come up at that time, and what they did was to beat him on philosophy. I hope that you will read some of that record back to them. You got a chance now. It's 88.
I'll read the record back to them, but I hope I act more responsibly than they did.
I hope so too, sir.
Senator,
I'm sorry. If I could finish with one point in light of what you.
Up to the senator from Alabama.
Well, since they are answering your questions and since they are attacking you on this position, I think it is proper for you to go ahead.
I hope we're not attacking Senator Biden. It would be both foolish and unworthy. He's raising serious issues. We didn't choose to testify against Justice Stevens, and looking back in terms of people whose votes we sometimes get for the positions we advocate in court, and for sometimes we do not. We didn't oppose Justice Harlan. There are different types of nominations. There are nominations of people who promise to bring a wide disinterestedness to their task. We have the capacity, I know you have the capacity, and I believe there are many Republicans who have the capacity to judge nominations of that kind on their merits.
I'm about where you are. Great doubt, but no decision. When you make a decision, then you can lecture me on my making a decision. And before my friend from Maryland, who takes great pride in making comments about when I'm speaking, I'll yield before he has a chance to say anything more.
No, I'm just the servant
of the people,
of the committee.
I want to. I'm dying over here because this thing on philosophy. Can I answer that?
Up to the chairman.
I just want. It's just in comment on his question about if anybody coming up here would be opposed and if this is a philosophical bad precedent.
We thank you all for being with us. Did you want to respond?
I'd like to hear her answer, but I don't want to run the risk of your wrath. I'd rather them have it.
I'm never wrathful.
Well, why don't you let her answer the question?
All I wanted to say real quickly is that I think that you would not have to worry if in 1988 it changed and anything like this was quoted back, because I think we should come to a point in the United States of America that we're not rediscussing race discrimination and sex discrimination every 4 years. I think we have been very careful. We're not giving partisan Republican or Democratic philosophical broad sweep testimony here. We're saying that there's certain things that should be sacrosanct, that there should the principle of equality of justice for all has to have meaning, that indeed that people who have views on individual rights and on sex discrimination that put in question our whole records on how to end discrimination and affirmative action should not be confirmed, because all we will be doing is reliving the battles of the 50s and the 60s again and again, and it's enough.
Thank you. Once again, I think for the second time, I thank you for your attendance at this meeting and for your very helpful comments. We appreciate it.
Thank you, sir.
Thank you all.
May I inquire if Mr. Roy C. Jones of Liberty Federation is in the room? Mr. Jones in the room? Yeah. Then our third panel will be composed of Mrs. LaHaye, the President of Concerned Women for America, Mr. Bruce Fine of United Families Foundation, Ms. Sally Katzen, a lawyer with Wilmer Cutler and Pickering, and Mr. Jack Fuller, the editorial editor of the Chicago Tribune. If you will all raise your right hands. You swear that the testimony you will give in this proceeding will be the truth, the whole truth, nothing but the truth, so help you God? I do. Mrs. LaHaye, do you want to start? I'd remind you of our 3-minute rule. The red light will indicate the 3 minutes have expired. Without objection, all statements will be included in full in the record as if read.
I'm Beverly LaHaye, President of Concerned Women for America, which is the nation's largest nonpartisan activist women's group. We have 565,275 members as of this morning, and we're growing. We're in all 50 states representing women from many professions, many different races, and many religious backgrounds. Concerned Women for America was formed to help protect the family, to promote constitutional freedoms and traditional values. CWA lobbies on various issues and has a legal department that recently won a case before the U.S. Supreme Court. The members of Concerned Women for America support the nomination of Antonin Scalia to the U.S. Supreme Court, and we urge quick Senate approval of his nomination. On credentials alone, Judge Scalia shows sterling qualifications for the Supreme Court. His scholarly works influence the legal community with their well-reasoned arguments. CWA supports Judge Scalia's nomination largely due to a strong commitment to judicial restraint. He is a judge that interprets the Constitution in light of the intent of the framers. He resists the temptation that many judges have fallen into of creating new constitutional or legal rights out of thin air when they have no textual or historical justification. His vigilant philosophy of judicial restraint will help protect the Constitution from judge-made erosion. In these changing times, with many voices espousing their positions, all Americans, men and women, need a written Constitution that stands firm, changed only by the will of the people expressed through the amendment process. Judges and courts must not sit as unelected perpetual constitutional conventions and impose their moral values on the majority. We need judges who live by an active commitment to judicial restraint and respect for the principles placed in the Constitution by the Founding Fathers. Antonin Scalia fills that need. It has been said and reported that women's groups all oppose the nominations of Justice Rehnquist and Judge Scalia. As a president of this largest women's organization in the United States with over 500,000 members, I'm here to inform you that that statement is wrong. Concerned Women for America has over double the membership of the next largest women's organization, and CWA supports the nomination of Judge Antonin Scalia to the Supreme Court and William Rehnquist as Chief Justice. Judge Scalia's intellectual abilities, experience, and deep understanding of the Constitution are plain to all. Concerned Women for America urges the Senate to confirm Antonin Scalia to the United States Supreme Court.
Supreme Court than any nominee since Charles Evans Hughes over 50 years ago. Judge Scalia has taught law, and taught law is intellectually tough law. Judge Scalia has occupied high-level positions within the executive branch. The experienced has honed Scalia's mind to a deep appreciation of the Constitution's separation of powers, its subtleties, and its indispensability to energetic, accountable, and unoppressive government. Finally, Judge Scalia has served several years on the United States Court of Appeals for the District of Columbia Circuit. His judicial performance has been exemplary, always well prepared for oral argument, incisive in opinion writing, and a close intellectual companion of any judge searching for constitutional or statutory principle in expounding the law. Judge Scalia will bring to the Supreme Court desperately needed mental rigor and analytical power. Three areas of constitutional law illustrate the Court's recent departures from constitutional intent and substitution of social policy concerns as a basis for decision-making: abortion, obscenity, and church-state issues. Now, the Roe v. Wade case has already been referred to today, and I could perhaps even rely on Senator Biden for suggesting that it was ill-reasoned and not a vindication of the intent of the 14th Amendment architects.
That's going a little far. I didn't say that.
We can come back to that. But as Senator Biden at least tacitly acknowledged, the Court's opinion consulted ancient attitudes, the Hippocratic Oath, the common law, the English statutory law, the American law, the views of the American Medical Association, the views of the American Bar Association, the views of the American Public Health Association, but where were the views of the constitutional architects?
I wasn't going to fight with you today until this.
Hey, Mr. Fine.
My name is Bruce Fine, and I represent United Families of America. United Families enthusiastically urges the Senate to confirm Judge Antonin Scalia as Associate Justice of the United States. Judge Scalia is more richly endowed with the experience and attributes necessary for outstanding performance on the Supreme Court than any nominee since Charles Evans Hughes over 50 years ago. Judge Scalia has taught law, and taught law is intellectually tough law. Judge Scalia has occupied high-level positions within the executive branch. The experienced has honed Scalia's mind to a deep appreciation of the Constitution's separation of powers, its subtleties, and its indispensability to energetic, accountable, and unoppressive government. Finally, Judge Scalia has served several years on the United States Court of Appeals for the District of Columbia Circuit. His judicial performance has been exemplary, always well prepared for oral argument, incisive in opinion writing, and a close intellectual companion of any judge searching for constitutional or statutory principle in expounding the law. Judge Scalia will bring to the Supreme Court desperately needed mental rigor and analytical power. Three areas of constitutional law illustrate the Court's recent departures from constitutional intent and substitution of social policy concerns as a basis for decision-making: abortion, obscenity, and church-state issues. Now, the Roe v. Wade case has already been referred to today, and I could perhaps even rely on Senator Biden for suggesting that it was ill-reasoned and not a vindication of the intent of the 14th Amendment architects.
That's going a little far. I didn't say that.
We can come back to that. But as Senator Biden at least tacitly acknowledged, the Court's opinion consulted ancient attitudes, the Hippocratic Oath, the common law, the English statutory law, the American law, the views of the American Medical Association, the views of the American Bar Association, the views of the American Public Health Association, but where were the views of the constitutional architects?
I wasn't going to fight with you today until this.
A right of privacy found nowhere in the constitutional text or constitutional history was invoked to justify the court's general denunciation of laws that regulated abortion in order to safeguard potential life. And even last month, the Supreme Court extended its right of privacy concept to invalidate a state law that simply required the truthful provision of information relating to the abortion decision because the court thought that truthful information might convince the mother to choose childbirth over abortion. Judge Scalia, we believe, will employ constitutionally pertinent criteria in examining abortion issues and lead the court out of its current confusion and constitutional lawlessness. As Associate Justice White recently warned, the court is most vulnerable and comes nearest to illegitimacy when it deals with judge-made law having little or no cognizable roots in the language or design of the Constitution, and Justice White was speaking for a majority of the court. Now, as in the case of abortion and in other areas, rectifying the Supreme Court's decision will not require that abortions be restricted. The rectification will simply return the question to state and local officials to struggle with the anguishing issues involving the fetus, the mother, the father, children, and social ethics. It would be slanderous to the good name of the American people and contrary to experience to suggest that questions of abortion will not be responsibly handled by elected representatives of the people. I have amplified on similar sentiments regarding abortion and church-state issues. I simply would close with these observations. Responsibility is the mother of courage and individual growth. If, in contravention of constitutional intent, the people are denied responsibility over most questions of abortion, obscenity, or church-state relations, then nothing prevents the courts from arrogating responsibility for virtually any contentious public policy issue. The consequence would be a demoralized citizenry, unconcerned and untutored in the arts of self-government. In conclusion, we strongly support Judge Scalia for confirmation as Associate Justice of the Supreme Court.
Thank you very much, Mr. Fine. Ms. Katzen.
Thank you, Senator. My name is Sally Katzen. I'm a lawyer in private practice, a partner at Wilmer Cutler Pickering here in Washington. I am speaking today on behalf of myself only in support of the nomination of Judge Scalia. As you know, several women's groups have voiced concern about Judge Scalia. I understand that they are concerned because, based on his opinions and other statements, they believe that if he were confirmed, he would undo much of what the women's movement has accomplished in the courts in the last decade. In essence, they disagree with Judge Scalia's position on a number of issues of importance to women. I, too, disagree with Judge Scalia on many of these issues. But whereas they believe him to be closed-minded, or perhaps affected by a personal bias or insensitivity to women, my experience is very much to the contrary. As Dean Verkyle noted this morning, Judge Scalia, who was then Professor Scalia, served as chairman of the Administrative Law Section of the American Bar Association in 1980-81. I had been elected to the council of the section, which is the decision-making body, in August of 1980 when I was serving as the general counsel of the Council on Wage and Price Stability in the Carter administration. My 3-year term on the council of the Administrative Law Section coincided with Judge Scalia's tenure as chairman-elect, chairman, and past immediate chairman. As a result, I had an opportunity to see firsthand Judge Scalia's stewardship of the Administrative Law Section and how he chose to exercise the leadership role that he had. During those years, I found Judge Scalia to be very bright, strong analytical skills, well-versed on administrative law issues, and intellectually curious. He rarely, if ever, accepted positions, arguments, or contentions just because they were forcefully presented. He frequently challenged positions, including his own, in the spirit of collegial decision-making and debate. He attempted to bring his colleagues around to his point of view, but he was equally willing to be persuaded by well-reasoned, well-documented arguments. And I wish to stress that he never demonstrated any bias against women, nor did he ever indicate that discrimination against women is appropriate or even acceptable. On the contrary, during these years, when he had no basis for knowing that his statements and actions would be subject to the intense scrutiny to which they are now being subjected, he was fair and non-discriminating to all members of the section. He solicited and listened to my views, notwithstanding that we often disagreed. And as best I recall, he related or responded to the other women in the section with the same courtesy and respect, and treating us no differently than our male colleagues. In fact, it's my clear impression that he actively encouraged women to participate in the work of the section, and as chairman-elect, he nominated and appointed 6 women as chairs of committee and 16 vice chairs of committee, and he appointed a woman to the 3-person nominating committee, which had responsibility for selecting the following year's officers and council members. When I served on the nominating committee several years later, I undertook as one of my assignments to call past chairmen to get their views as to bright, young, or not so young, rising stars. And I recall that Judge Scalia was very enthusiastic about women in leadership roles in the section generally, and very high on some women candidates in particular. I should add that within the last few years, I have appeared before Judge Scalia in oral argument before the D.C. Circuit. And the traits that I discerned in the early 80s, being well-prepared, analytically quick, and intellectually curious and fair, were very much evident in his performance on the bench. I therefore urge your favorable consideration and confirmation of Judge Scalia to be Associate Justice on the Supreme Court.
Thank you, Ms. Katz. Mr. Fuller?
I'm Jack Fuller. I'm editorial page editor of the Chicago Tribune. Though I don't speak today in the voice of the newspaper, since it confines its say to the printed page, I should tell you at the outset that the Tribune has applauded Judge Scalia's nomination. I'm here because I've known Judge Scalia.
Surprised if you were here and it didn't.
I have known Judge Scalia for more. I don't know why you would be, but I have known Judge Scalia for more than a decade, since working with him in the Department of Justice, where I served as a special assistant to the Attorney General at that time, Edward Levy. In the department, I worked with Judge Scalia closely on a wide range of issues of federal legal policy, many of them difficult and controversial matters that touched on fundamental concerns of liberty and the structure of constitutional government. Judge Scalia brought to bear the lawyerly virtues of attention to detail, close analysis, and clear, direct expression. He was open-minded in the examination of legal questions and scrupulously honest in the presentation of his views. If character, intelligence, legal craftsmanship, and a passionate regard for the tradition and responsibility of the law are the marks of excellence in a justice of the Supreme Court, then Judge Scalia will fit and honor that high office. One of the important functions of the Supreme Court is to explain the law to the people it serves. And Judge Scalia brings to this work a remarkably clear and vivid writing style. As a writer myself, I must tell you that I read Judge Scalia's articles and opinions with a deep sense of professional envy. The Supreme Court, like all institutions of self-government, ultimately depends on public understanding and acceptance, and Judge Scalia's gift for writing will serve the institution and the public well. Finally, I do not believe, as some of my colleagues in journalism have said they do, that Judge Scalia lacks a proper reverence for the value of free expression. First of all, I do not think that we in the press should succumb to the temptation to behave like a single interest lobby group, demanding lockstep agreement in every doctrinal dispute that touches upon its own particular interests. In a matter such as the evaluation of a person for a position on the Supreme Court, the press's responsibility, like this committee's or the public's, is to measure the individual against a much broader and more appropriate standard of character, skill, intelligence, and commitment to the rule of law. Second, through my years of acquaintance with Judge Scalia, I've come to know him as a man utterly committed to free debate of public issues. As an executive branch official, as a writer and editor, and as a scholar, he's not only articulated his belief in the importance of free debate, he has lived it. I have no doubt that as a justice of the Supreme Court, he will take seriously the court's responsibility as a guardian of the system of free expression. Finally, I believe that a careful, lawyerly excellence of the sort that has marked Judge Scalia's career is the best indicator of what he will accomplish on the Supreme Court. His care and caution and meticulousness are, like the laws, the best and most lasting defense against encroachments upon our liberties, and I'm more than willing to entrust what is to me the most cherished of our freedoms to an individual like Judge Scalia, whose whole being has been wrapped up in serving and honoring the American legal tradition.
Thank you, Mr. Ford. Senator Biden.
Sir, is it usual for you to testify? I mean, is this a precedent set, or I mean?
Highly unusual for me to know very well a nominee for the Supreme Court of the United States. It is very unusual for me to testify in someone's behalf.
I see. The witness list. Which one's fine? Thank you very much. Ms. Katzen, I want to speak to you later about the guy sitting behind me, and what kind of job he did. I've been informed I should disclose to the staff that my staff person used to be accountable to Ms. Katzen in her law firm, and I would like to talk to you later about him, if I may. I'm well-trained. He's done a heck of a job, as a matter of fact. Mr. Fine, is there a right of privacy in the Constitution?
There certainly is not in explicit terms. However, there are certain privacy values definitely protected by the Constitution. The First Amendment, for example, protects absolutely the freedom of belief. It also protects a freedom of religion.
How about the
Ninth Amendment? The Ninth Amendment does not protect anything. Indeed, the Supreme Court was required to refer to it as having emanations and penumbras in order to strain to find substantive significance to the Ninth Amendment, and a majority of the Supreme Court has never thought that it itself conferred any right of privacy. But privacy values are protected in the Supreme Court, not explicitly, and it was intended to preserve certain core elements of privacy.
Tell me what some of those rights of privacy that are protected
Certainly,
are
the
that
Fourth
are not
Amendment, the Fourth Amendment right against unreasonable searches of seizures.
But they're all enumerated.
They are enumerated.
Are there any unenumerated rights of privacy?
In the Constitution?
Yes.
No.
No more questions. Thank you very much, Mr. Chairman.
Senator Metzenbaugh.
Fine. I heard you on TV the other day when Senator Biden invited you to his office, and I was just sort of curious to know what this United Families deal is. How many thousand members do you have?
I will provide you a specific number if you would like that.
Oh, I didn't ask for a specific number. How many thousand? You have 1,000, 5,000, 100?
I do not know, Mr. Senator.
Isn't it the fact, Mr. Fine, it's a paper organization, and it's your organization, and it's just funded by some right-wing conservatives. Isn't that actually the fact?
No, I think that's absolutely false, Mr. Senator.
Well, tell me the truth. Where do you get your money?
I did not found the organization, and I can refer you to those who run it on a day-to-day basis in Washington and provide any of the details with regard to the funding and the expenditures, et cetera. But I had nothing to do with the foundation of this particular organization.
You're very smart. Tell us about the organization. What is it? I mean, it's just a name. I've never heard of it before.
I am not intimately familiar with the United Families of America. I can tell you I had nothing to do with its foundation. I have sympathy with their views in promoting family values. They contacted me and asked that I prepare testimony and represent them in these proceedings. And that is my association with this organization.
You were with Gray and Company one part of your life?
At one time, yes, sir.
And did you hold a position with this administration at any point?
Yes, I did.
What did you do?
I was Associate Deputy Attorney General for 2 years during the first term of the Reagan administration. I served for 2 following years approximately at the Federal Communications Commission as General Counsel.
And who asked you to speak here?
The United Families of America asked me to represent them here.
Are you a private practicing lawyer, is that it?
Yes, I am.
And you're here just as counsel for the organization, an organization about which you know absolutely nothing?
I think that's an overstatement, but I am counsel for them at this proceeding, yes, sir.
Well, well, tell me what you know. I mean, I guess what I'm really asking you is, you're asked to come here to speak on behalf of an organization.
It's an organization that promotes family values in the United States as a matter of law and policy.
Well, my understanding of the organization is that it's just a paper organization that doesn't exist. It doesn't have members. So I asked you how many members. You said you don't know. You're very smart. That's the second time I've said that, so that I might pull you out in order to give me some indication as to truly what is the United Families Foundation if it's something more than a front organization.
Mr. Senator, I gave you the complete reservoir of my knowledge as to the values it promotes, the fact that I had nothing to do with its inception as an organization, and I would be speaking on things of which I was ignorant if I hazarded a guess.
Who's the president?
Excuse me?
Who's the president?
Bob Bartleson is the one who I spoke with regard to preparing the testimony and appearing here today and last week as well.
He's the president, is he?
I don't know what his particular title is. He is the one that operates the Washington office.
I have no further questions.
I have a couple questions after you.
Go ahead.
Mr. Chairman, could I ask that there be held open the record to permit the information to be included that would refute the allegation that the United Families of America is simply a paper organization?
The record will be open, and I think Senator Metzenbaum would be glad to have you provide that information.
Thank you, Mr. Chairman.
Incidentally, may I just ask one more question? According to the designation on our sheet, it indicates you're appearing on behalf of United Families Foundation. You state you're appearing on behalf of United Families of America. Is there a foundation, or I guess I'm just asking you, what is the fact?
I am representing the United Families of America. There is my understanding is that there is a foundation that's a separate organizational unit, but when the record is held open, I will provide the details on the relationship between the two.
Thanks, Mr. Fine.
Chairman, Ms. LaHaye, let me ask you, Concerned Women for America, which you state is the largest organization, women's organization, nonpartisan women's organization, I think is the phrase used. Is your organization involved in the trial that is attempting to withdraw certain books from schools because they violate Christian values? Are you
We are involved in a trial in Tennessee, but let me just correct that for the records, that we're not trying to withdraw books from the school at all. That would be, we're simply asking for 7 families to have the right to have an alternative textbook in the Hawkins County School District.
And the alternative textbooks are, for example...
They've requested the textbooks called Open Court, published by Open Court. The series that they're being asked to read in the school, or forced to read, is the Holt series, Readers.
But your organization has no objection to the schools, for example, including the story of Leonardo da Vinci?
No, not at all. That was
because this press report
that
indicates...
Is not correct.
I didn't think you were that. I mean, that's kind of crazy. You'd agree, right? Screw it.
We're not that crazy.
Or a visit from Mars should be taken out of the school. Because it says a visit from Mars, for example, seemed to Mrs. Frost to embody through transfer or telepathy supernatural attributes that are properly God's alone, therefore the children should not read it. You don't believe in that, do you?
The thing that they were objecting to were really causing them to experience other religions and not the history. They approved of the history, but they did not want to have to...
Is that experience in other religions?
No, I'm not saying that is. This is part of their testimony.
Okay.
And they did not disapprove of the 3 bears, as some of the press reported they did, or Cinderella.
Because it is kind of confusing. It says, Mr. Ferris is one of 4 lawyers on the staff of Concerned Women for America, who are representing a dozen Hawkins County residents who are seeking alternative books for their children. The Washington-based organization was founded by Beverly LaHaye, who is married to the television evangelist Tim LaHaye, a strategist for the religious right. That's how it's characterized. I'm reading, in fairness to you, I'm reading from the New York Times
He's never been a TV evangelist, but they can call him what they wish.
I cannot read this writing, if whoever gave me this note, so if you rewrite it, I can read it. I can't read the books or the writing, I'm getting old. It says, concerned women also paid a Tennessee lawyer to represent Mrs. Frost in a separate case earlier this year in which she was awarded $70,000 in damages by a jury for false arrest. A local police officer had arrested Mrs. Frost for trespassing when she came to try to remove one of her children from a reading class at the school. Officials acknowledged that the arrest was not authorized by the local ordinance. The textbooks are being defended here by lawyers retained by the insurance company of Hawkins County, by Tennessee Advocate General William H. Farmer, and by 5 lawyers of a prominent Washington firm of Wilmer, Cutler, and Pickering. Yeah, the plot thickens. Next thing you know, you're going to find out my staff guy was on this case. Is that the note you're passing me?
If I may, Senator, I would just note for the record that perhaps...
Your husband was a school board lawyer?
Yes, sir. My husband was on the, represented the school board on the other side of the case.
This is like Dallas.
And I think this demonstrates that while many of us have very different views about basic issues, we here today agree on what may be the only thing we agree on, and that is the qualifications of Judge Scalia, because otherwise there are many areas of disagreement between us.
That would be very true.
Very. Make sure the firm agreed to
much diversity of opinion. Wilmer Cutler.
The firm agreed to contribute its time and talents to the case after being approached by the People for the American Way, the American Civil Liberties Lobby founded by television producer Norman Lear to monitor the religious right. Well, you've helped me clear up what seemed to be an inconsistency, and at some point, if we had the time, I'd like to know how you reach your editorial decisions, but it's the first time in my 14 years here that there's been a, other than speaking on a First Amendment issue, where there's been an editor that's shown up. It's just... Oh, are you? Are you speaking on behalf
I thought there had been a lot of concern on the part of this committee and in some parts of the press about Judge Scalia's attitudes toward the First Amendment.
Yeah, but you went way beyond that. That's all right. I'm just pointing out that I've never seen that before. That's all. There's nothing wrong with that. I welcome you here. I truly do.
Thank you.
Because after reading some of your editorials, I'm as confused as you are listening to us.
I don't think we should forget the most recent editorial writer we had here.
Who was that?
J. Harvey Wilkinson.
That's true. Jay Harvey. How could I forget Jay Harvey? I don't have any further questions. Thank you. Thanks for clearing it up. It was more a point of interest I had. I found it kind of interesting.
I wasn't here when you spoke to
amazing.
Mrs. LaHaye, but did I hear somebody say that your organization is the largest organization of women in the country?
I'm quoting what Time Magazine said. Time Magazine gave credit to that about 4 or 5 months ago.
How many members are there in your
We
organization?
have 565,275 as of this morning, and it changes every day.
They're all dues-paying members?
Yes, they've all identified on paper that they want to be part of CWA, yes.
And is this, are you the president?
Yes, I am, and the founder.
How do you get your membership?
Through many different means, through personal appearances where I speak, through books I may have written, or contacts that we have area representatives all over the United States, and they solicit members in their area. And when we have a court case like Senator Biden just referred to, that gives us new members because they support what we're saying.
Give all your secrets.
Okay, I'll save a few.
And where are you most active, in the North, the South, or all over the country?
Oh, our biggest membership is in California, and so we are all over the United States.
Did I hear you say that you were concerned, maybe I didn't hear you correctly, about the school books that are used in the South? Did you say something about...
No, that would be too general. It would be specific books called the Holt series readers, that one series that is published for elementary school grades that 7 families have objected to, And they simply asked that the school board approve alternative books for them to read, which the classes were reading 3 and 4 different kinds of books at one time. They asked for an alternative book for their children. The school board denied that request and then expelled the children from school when they would not read the books.
Let me ask you, do you think that it would be good policy if outside groups, or in groups for that matter, those who have children in school, started to try to tell the school boards where their children go to school, or if they don't, even if they don't go to their school, what choice of books should be used in the classroom? Do you think that's good policy?
Well, I think it's not good policy for the public education system to be becoming a wedge between the parent and the child, which was what we were seeing happen.
Well, I know that point of view of yours, but I don't think you answered my question. My question was, do you think it's good policy for some group of parents in the school, or a group such as yours outside the school, to be telling a school board what books should or should not be used? Do you think, just forgetting about what the books are, do you think that's a good policy position?
Well, of course, a good policy is a very general statement, and this happens many times. We see people reporting that the books they object to may have had a story of the Bible in it or creation in it. So it's been going on for a long time, where parents have objected and tried to see that the school would support basically what they're trying to teach their children at home without conflict.
Well, I understand that, but I don't understand what kind of America we'd be if Concerned Women for America was at the school board advocating certain books beyond or off the list, or whether now would be there with another group of books, or whether the Concerned Women lawyers would be there for another group of books.
Yes, now that was not the case. That was not what they were doing. They merely asked for the open court series, which is already on the approved list for the Tennessee Education Association. It's already on the approved list. So that it's not new books they'd be purchasing. They asked that their children could be granted the privilege of reading those books.
Well, I just say that whenever I hear of somebody interfering with choice of books for schools, I do have some concerns, and maybe that's the right thing to do, but I myself have some doubts.
The courts will be deciding that very soon.
We have 2 more panels who are anxiously awaiting to give their testimony. But let me call on Senator Simon, see if he has any questions of this panel.
Just one question, and I regret I wasn't here to hear the panel, but my friend Jack Fuller from the Chicago Tribune, I have this quote from Judge Scalia, written before he was a judge. He says, "The defects of the Freedom of Information Act cannot be cured as long as we are dominated by the obsession that gave them birth. That the first line of defense against an arbitrary executive is do-it-yourself oversight by the public and its surrogate, the press." Does that bother you at all?
Well, let me tell you what I think about Judge Scalia's attitude toward the Freedom of Information Act. My understanding of Judge Scalia, and I'm just from what I've read of what he's done and from what I've read of his opinions, my understanding of his approach is that he is very deferential to the legislative branch of government in enforcing the rules that the legislative branch writes. My prediction, and you can never predict these things very well, is that this Congress would have few difficulties with Judge Scalia overruling its intention in the enactment of legislation like the Freedom of Information Act. It's very fundamental to his approach that those decisions be left to the majoritarian institutions. So he may have, and he does have, he does oppose parts of the Freedom of Information Act, but I don't think that there's a very grave risk that he would try to eviscerate that law from the court. That is just exactly the kind of approach he wouldn't take, I think.
But the statement says that the defects are dominated by the obsession that obviously he thinks is not accurate, that the first line of defense against an arbitrary executive is do-it-yourself oversight by the public and its surrogate, the press.
Well, I'm, of course, fully in favor of do-it-yourself oversight on the part of the press.
I would think so.
But I also think that I understand what he was writing about. And what I think he's writing about is his view that the first line of defense of liberty is really in the majoritarian institutions of the government, that it is through the separation of powers and those constitutional provisions that you have the first line of defense, through the oversight, not of the press in his view, but the oversight of this institution. I mean, I happen to think that the press is plays a very important function in that whole process. But I think I understand what he's trying to drive at too.
All right. I would just add, I'm probably going to be voting for him. I do have some concerns in this whole First Amendment area. His record so far, and is a limited record, is not one that shows great sensitivity for this freedom of the press and freedom of speech. I have no further questions, Mr. Chairman.
30 seconds. Lest I appear in an editorial, let me point out that I want to compliment you. I think your testimony, Mr. Fuller, warrants some considerable credibility in light of the positions you've taken on other nominees that have come up also. It clearly is one that demonstrates you have a consistent demand for excellence on the part of the judiciary, and I compliment you on your good judgment.
You said it was breadth and comprehension.
Yes, it was the comprehension.
The Chicago Trib isn't making editorial endorsements yet in presidential Democratic primaries, are they?
We certainly have not.
Okay.
Fair to the chair feels constrained to bring this.
Thank you. I wish you would. Quickly.
Thank you all very much for being with us. We appreciate you being here. Our fourth panel, Ms. Ann Ladke, Executive Director of Women Employed, Ms. Joan Messing-Graff, Executive Director of Legal Aid Society of San Francisco, Ms. Audrey Feinberg of the Nation Institute of New York, Ms. Kate Michelman of the National Abortion Rights Action League.
No.
You're the only one.
I swear, I think so.
Well, then, will you please raise your right hand? You swear that the testimony you'll give in this proceeding will be the truth, the whole truth, nothing but the truth, so help you God?
I do. Shall I proceed?
Will you proceed? As you know our rules, that we ask you to make a 3-minute oral presentation. Your full statement will appear in the record.
Mr. Chairman,
yes.
Since the other members of the panel are not here, I assume we will enter their statements in the record.
Their statements will be received in the record if they are received by the committee in a timely fashion. I might repeat that the record will be open until 4 o'clock on Friday afternoon. Yes.
Members of the committee, I am Audrey Feinberg, an attorney with the New York City law firm of Paul Weiss, Rifkin, Wharton, and Garrison, and I am appearing on behalf of the Nation Institute. As a foundation dedicated to the protection of civil rights and civil liberties, the Nation Institute is deeply concerned by the record of Judge Scalia for 2 reasons. First, a review of Judge Scalia's decisions reveals a record that is far removed from mainstream judicial thought. During his few years on the bench, Judge Scalia's rulings have reflected extreme views, far to the right of even traditional conservative legal opinions. Second, Judge Scalia's decisions reveal a remarkably consistent record of failing to support civil rights and civil liberties. I've examined Judge Scalia's opinions in 14 areas, including sex and race discrimination, freedom of speech and press, privacy, legal representation for the poor, presidential power and foreign policy, gun control, criminal law, consumer protection, labor law, and other areas. In case after case, Judge Scalia has shown a closed mind and a relentless insensitivity to the needs of women, minorities, and the poor. And he has slammed the courthouse doors in the faces of the disadvantaged. Further, Judge Scalia's record raises serious questions about whether he has a political agenda that is incompatible with the impartiality required of Supreme Court justices. I will offer just a few examples. On the subject of sex discrimination, Judge Scalia has taken a position that is even farther to the right than the views of Justice Rehnquist. Unlike Justice Rehnquist and the unanimous opinion of the Supreme Court, Judge Scalia's opinion is that sexual harassment in the workplace is not actionable sex discrimination. I refer the committee to the case of Meritor Savings Bank versus Vincent. In addition, Judge Scalia imposes a high burden on all those who sue for race discrimination. The majority of Judge Scalia's court wrote that Judge Scalia's views on race discrimination were, quote, without precedent, and they, quote, would effectively eviscerate the discrimination laws. And I refer to the case of Carter versus Duncan Huggins Limited. Further, Judge Scalia is firmly opposed to affirmative action, calling it the most evil fruit of a fundamentally bad seed. I have merely highlighted the callousness to civil rights that seems to animate Judge Scalia's approach to judging. There must be a conscience in the confirmation process. We urge the members of this committee to weigh whether an extremist, even one as affable as Judge Scalia, belongs on the Supreme Court for the next generation. Thank you, and I'd ask that my full written record be submitted to the committee.
Senator Biden?
Ms. Feinberg, you cited 10 or 12 areas that you looked into his record on. Has he decided cases in every one of those areas?
Yes, he has. He has had at least several cases in all of these areas, and in case after case, he has consistently ruled against civil rights issues, against civil liberties, against women, against blacks, and against the poor.
Let me ask you, your conclusion is that that he in fact is extreme. Is that the phrase you used, or what was the phrase you used?
Well, I would agree that he is indeed extreme, and I would in particular point to the sexual harassment case, where the Supreme Court recently unanimously ruled that sexual harassment is discrimination. While they split on some side issues, the court unanimously felt that that in fact was discrimination, and indeed that opinion was authored, the majority opinion in that case was authored by Justice Rehnquist, and Judge Scalia would not go along with that. And I think someone that is far to the right of every judge on the current Supreme Court would have to be labeled extreme.
Do you believe it's his agenda to overrule Roe v. Wade?
While he's not explicitly stated anywhere whether he would overrule Roe v. Wade, he has very harshly criticized the decision, and I think he has made his views on abortion clear, and he has also disparaged the landmark privacy decisions of the Supreme Court, including the Griswold case and cases that had nothing to do with abortion. So I think we would have to be extremely concerned about whether he would overrule Roe v. Wade.
Why don't you tell me what he said again in the Vincent v. Taylor case? You know, I have that language somewhere. Do we have it? Vincent v. Taylor, his...
Well, the holding of that case was that sexual harassment is not actionable sex discrimination, and I believe he labeled the idea that it might be actionable as quote, bizarre. His view was that the civil rights statutes were not broad enough to encompass something as sexual harassment. And I think that is quite a remarkable idea, because the standard method of constitutional construction is that civil rights statutes and all remedial statutes shall be interpreted broadly. So the idea that something as horrible and as awful for the victims that experience it as sexual harassment is not considered sex discrimination is a quite unusual proposition.
Did he write the decision?
I believe that was a decision that was written by Judge Bork in which he joined. It was a 7-3 decision of the D.C. Circuit Court of Appeals. And then it was overruled. That viewpoint was unanimously ruled against by the Supreme Court, which was a 5-4 decision, which Justice Rehnquist wrote the majority, and the court was split on some evidentiary issues, but they were unanimous on the view that sexual harassment is discrimination.
Now, does he say in that decision sexual harassment is not? Let me just read, and what language do you rely upon for him to suggest, for the suggestion? I'm not doubting
Sure.
you. I just want to.
I think I have one quote here which might clear that
Okay.
up. In the Vincent case, in his dissent, the opinion which Judge Scalia joined said, he was discussing the fact that the civil rights laws may not protect women from unwelcome lesbian advances. And then he said, and quote, that bizarre result suggests that Congress was not thinking of individual harassment at all, but of discrimination in conditions of employment because of gender. So it seems pretty clear to me from that he's saying that Congress, when it passed Title VII and the other sex discrimination statutes, did not contemplate that they would cover sexual harassment, and that indeed they should not cover sexual harassment.
The case in question was the
That's the case of Meritor Savings Bank versus Vinson.
Mm-hmm.
In the court below, it had the name of Vinson versus Taylor.
Right. How about the, is it Boucher versus National Urban League? Casey, you're familiar with that? Where Judge Scalia affirmed the jury's finding of no sexual harassment without reaching the issue of whether sexual harassment is actionable discrimination?
Yes, some people have cited that case as showing that Judge Scalia may in fact believe that sexual harassment is actionable. However, what that case found was against the plaintiff, and it reached a finding of no sexual harassment. And therefore, I think you can't infer any views on whether sexual harassment is actionable or not. In fact, that case held that on the particular facts before it, there was no sexual harassment. And it never at all discussed the broader question of whether sexual harassment is actionable sex discrimination. The court didn't need to get that far in the Boucher case because they were ruling against the plaintiff and found as a matter of fact that there was no sexual harassment.
It may seem like an unfair question I'm about to ask you, but if a judicial nominee were here and they were not on the court, but they were being nominated for the Supreme Court, and they said in testimony that they in fact thought that Roe v. Wade was wrongly decided, but on all other counts they seemed to have positions recognizing the rights of women in this country, would you testify against that person merely because they disagreed on Roe v. Wade?
I would certainly reconsider my testimony. I don't think you can use a litmus test of any one particular issue in judging a nominee. And of course, it would depend on Judge Scalia's views on every other issue. Roe v. Wade is an important case and a long-standing case, and one that is deeply respected by women and women's groups. However, again, I think you have to look at the overall record of the nominee, and in this case, we're not talking about one case or even one issue. We're talking about issues ranging from women's rights to race discrimination to libel and free press to labor law to consumer protection. And on all of these issues, Judge Scalia has come out against people suing to enforce their rights. So as far as looking at his record, and I'd like to point out that it was hard to determine his views from the questioning by the senators here. He seemed to be somewhat evasive and reluctant to go on the record of his views, and he kept saying, I refer you to my record. Look at my record and my writings to see what your opinion of me is going to be. And what I have done here is looked at his record, And in subject after subject, his record has been against civil rights, against civil liberties, against the poor.
Ms. Feinberg, are you an attorney?
Yes, I am.
Do you practice?
Practicing at the New York City law firm of Paul Weiss, Rifkin, Wharton, and Garrison.
How long have you been practicing?
5 years.
You're very articulate.
Thank you.
It's presumptuous of me to suggest, but you are. Let me ask you then, do you believe that Judge Scalia has a closed mind on these issues, that he would not, that he's not subject to being convinced or changing his mind?
I think you're always in a difficult position in trying to predict what a judge will do in the future. But with Judge Scalia, we can only look at his past record, and his past record does indicate a closed mind on certain issues, in particular race discrimination, sex discrimination, Freedom of Information Act issues, and free press issues. And I would have to say, given his remarkably consistent rulings in this area, that he does have a closed mind, yes.
Did your organization take a position on Justice Rehnquist?
No, we did not.
Is it appropriate for me to ask you why you did not and why you did on Scalia?
Well, the reason is because institutionally we set up a system of volunteer attorneys such as myself to study potential Supreme Court nominees. And each of us spent the better part of a year studying someone who might get nominated to the Supreme Court, and we never expected that Justice Rehnquist would be coming here for an additional nomination proceeding. So that's the only reason we did not. I might add, though, that someone did testify several years ago, and Justice O'Connor was nominated for the Supreme Court.
Are you at liberty to tell us who else coming up next? Seriously, how many people did you have you looked at?
Well, we have a list of something like 15 members, and you're welcome to hear the names if you want. It's our guess as much as anyone else's.
I am, well, you...
I seem to hit the right name since I chose to spend my time studying Judge Scalia for the past year.
That's remarkable. Thank you.
Ms. Feinberg, the short time that I've had to peruse your written statement, I have to tell you that it's the best statement I've seen submitted by anybody, either in connection with Justice Rehnquist or Justice Scalia.
You've been working on it a year.
No, with all due respect, I'm afraid if my colleague had 3 years, he wouldn't have done as well. Neither would I. Neither would I.
You probably wouldn't be able to read it.
Yeah. You have succinctly stated the issue in a number of areas, and then having done that, made your point. You've done well, very well.
I appreciate the compliment, and again, I would give part of the credit to the Nation Institute, which set up a system so that we had sufficient time and resources to study the nominee. If we had tried to do a study like this in the last 2-3 weeks since Judge Scalia was nominated, it would have been impossible. Because of the Nation Institute's program of monitoring potential nominees, we've been able to do a comprehensive look like this.
When Mr. Fine appeared, I asked him what his group is. What is the Nation Institute?
The Nation Institute is a private foundation. It is a research organization with primary concerns on civil rights and civil liberties. It sponsors conferences and research and investigations. One of its projects is called the Supreme Court Watch Project, and that project monitors the records of potential Supreme Court nominees. If you want a more detailed explanation, the executive director of the Nation Institute, Emily Sack, I think is sitting right behind me, and she could explain more fully what their work is.
Sorry, not needed. How's it funded? How does the foundation, how is it funded?
Well, it's a private foundation, and it receives donations from various sources, primarily from people who are interested in civil rights and civil liberties.
Tell me, in connection with the Tavalurius decision, you pointed out that Judge Scalia's position was extremely tough as far as freedom of the press is concerned. And as I read your submission, you indicated columnist Sapphire had called Judge Scalia, quote, the worst enemy of free speech in America today, and columnist Anthony Lewis described the opinion as a, quote, radical departure from existing law and a twisting of principle. Would you tell us a bit about the Tavalorius decision and Judge Scalia's role in that decision?
Sure. That decision involved the president of Mobil Oil Company who was suing for libel over an article that claimed that he had set his son up in the shipping business and had diverted some of Mobil's shipping business to his son. Judge Scalia joined an opinion by Judge McKinnon that ruled against the Washington Post on the issue of libel in that case. And I'd like to point out that that decision has now been vacated and is pending before the full D.C. Circuit Court of Appeals. So the opinion joined by Judge Scalia is not currently the law of the land. Not only did Judge Scalia rule against the press in that case, but more importantly, he held that investigative reporting is evidence of malice. The phrase he used is hard-hitting investigative stories, and that searching for such stories is evidence of malice, one of the elements of libel claims.
Just elaborate on that for me. The mere fact that a newspaper does as investigative reporters is in and of itself proof of malice?
That was the holding of the decision, yes.
And that was Judge Scalia's holding?
Yes, it was.
To your knowledge, has any other court ever indicated that the mere fact that a newspaper has investigative reporters is in and of itself proof of malice?
No other court has ever done that, and indeed that's what prompted the strong criticisms from columnists and others about this decision. Investigative reporting is considered a respectable and legitimate practice of the press. It merely means that the press is digging hard for answers, that they ask questions, that they look at documents, that they do the kind of reporting that any good reporter should do. The idea that investigative reporting is evidence of malice would be news to most reporters. I think when this decision came out, it was news to other judges. Investigative reporting is something that is necessary for the press to do a good job, and it was never disparaged as much as it was in this strong opinion by Judge Scalia.
If you followed that to its logical extreme, no newspaper could afford to have investigative reporters because every plaintiff would then have a simple way to get around the earlier decisions of the Supreme Court.
I think if this decision was the law of the land, which again, it's currently vacated, so it is not, but if Judge Scalia's decision were the law, reporters would be opening themselves up to libel suits for every story that they wrote that could be called investigative, and a newspaper would go out of business, paying millions of dollars in libel fines in a very short time.
Let's skip over to a latter point of your memorandum about Judge Scalia's being insensitive to the needs of the poor for legal representation to protect their rights. And would you tell us about the dissenting opinion that the judge had in the case that's to be found on page 17?
Yes, this case of Trackus versus Quality Brands. In that case, Judge Scalia would have dismissed a poor woman's sex discrimination claim because she did not have the funds to travel to the place of trial. She said that she would have the funds within a month because her husband had just gotten a new job, and she asked for a 1-month continuance of her trial date. The majority of the D.C. Circuit Court went along with her and granted the continuance, but Judge Scalia wrote a separate dissenting opinion that would have denied her a continuance. I also would like to point out that the woman's poverty resulted from her being fired from her job as a saleswoman, and she claimed the firing was an act of sex discrimination, that she'd been fired because her employer wanted an all-male sales force. Because she was out of a job, she did not have the funds to travel to trial. I believe she was traveling from Missouri to Washington for her trial, and she could not afford that, and she wanted a 1-month extension of time. And rather than grant her a 1-month extension of time, Judge Scalia issued a very harsh decision dismissing her entire case and throwing her out of court. Do we have a list? You're interested in the names?
Yes, I am. Well, might as well get a name, get it.
I have to. This is a tentative list, obviously, and we're always adding to it as quickly as we can find volunteers to research more people. We add more names, but the current people being looked at include Robert Bork, William Clark, Frank Easterbrook, Richard Epstein, Thomas G. Orrin Hatch of this committee, Cornelia Kennedy, Paul Laxalt, Richard Posner, William French Smith, Ed Meese, Thomas Sowell, Kenneth Starr, J. Clifford Wallace, William Webster, Ralph Winter, and that's all that I have on this list. And I don't know that, in fact, we are investigating all of them, but that's the short list that we made up of people we want to look into at this time.
It's enough to give one nightmares.
Well, we don't know how many more appointments President Reagan may get a chance to make.
Howard Metzenbaum is...
The reason why I've said he's closed the courthouse doors to the disadvantaged.
How do you explain that about Judge Scalia? He appears before us, he's a family man, he seems to be a very sensitive individual, and yet the harshness of that decision with respect to dismissing a case because a woman didn't have the money after she had been fired in order to travel from Missouri to Washington to present her case is just somewhat difficult for me to comprehend.
I think perhaps it cannot be reconciled with his personal attributes. I think this committee has heard and appreciated his affability, his congeniality, his integrity, but that is not the only qualities that this committee should be looking over. You have to look at his record and his decisions paint a very different picture of who he is and what he stands for.
Thank you very much.
Senator Simon.
Thank you, Mr. Chairman. First, Ms. Feinberg, so I know what we'll be working on a year from now. What name are you going to take up next?
Do we have a list? You're interested in the names?
Yes, I am. Well, might as well get a name, get it.
I have to. This is a tentative list, obviously, and we're always adding to it as quickly as we can find volunteers to research more people. We add more names, but the current people being looked at include Robert Bork, William Clark, Frank Easterbrook, Richard Epstein, Thomas G. Orrin Hatch of this committee, Cornelia Kennedy, Paul Laxalt, Richard Posner, William French Smith, Ed Meese, Thomas Sowell, Kenneth Starr, J. Clifford Wallace, William Webster, Ralph Winter, and that's all that I have on this list. And I don't know that, in fact, we are investigating all of them, but that's the short list that we made up of people we want to look into at this time.
It's enough to give one nightmares.
Well, we don't know how many more appointments President Reagan may get a chance to make.
Howard Metzenbaum is not on that list.
Would you like to be added?
No. You say in your conclusion he has demonstrated a lack of commitment to civil rights and liberties, and I don't think there can be too much dispute on that. Then you say, and he has shown no potential for change on any of these positions. There are those who dispute that latter fact, and in questioning him yesterday, he pointed out that he had stood up for a Marxist professor, for example, not a popular position. He would dispute that, and I suppose he would try and dispute the first part of your statement also. How would you respond to that statement?
Well, the problem with his dispute is I think you had great difficulty getting him to answer questions about his future decisions or views on issues. So you couldn't find out from him directly whether he thought he might grow or change on certain issues. And what we have to judge him by is his record. And looking at his record over a long period of time, both as his few years as a judge and before that as a professor, he has always held these views. He has been consistent in these views. We have seen little or no change from these positions. And we can only judge him by the record that we have in front of us. And based on this record, I see no prospects for major changes in his positions.
I have no further questions. Thank you very much. Thank you.
Feinberg, I have just one question. On the copy of your statement, there's a list of the Board of Trustees.
Yes.
Is the position that you've enunciated the position of the Board of Trustees, or is it your individual view, or is it the view of the...
Well, it is the position of the Nation Institute, and what you should understand is there's a separate board of the Supreme Court Watch project of the Nation Institute, and the board of the Supreme Court Watch has been consulted about my testimony before I came here today.
But it is the view of the Institute.
Yes.
Right. Well, I want to join in congratulating you on an excellent presentation.
Thank you.
Very fine statement. Thank you very much for being with us.
Thank you.
Appreciate it.
Further questions?
No further questions. Our next panel, Dr. Robert L. Maddox, Executive Director of Americans for the Separation of Church and State, Ms. Barbara Dudley, Executive Director of the National Lawyers Guild, Mr. Peter Weiss, the Center for Constitutional Rights. Ms. Dudley is not here. Gentlemen, if you will raise your right hand, you swear the testimony you'll give in this proceeding will be the truth, the whole truth, nothing but the truth, so help you God. Mr. Maddox, do you want to start? I remind you of the 3-minute rule and also the fact that your full statement will be included in the record.
Yes, sir. I am Robert Maddox, Executive Director of Americans United for Separation of Church and State. We're a 39-year-old national organization dedicated to the preservation of religious liberty and the separation of church and state. We represent within our membership some 50,000 people, a broad spectrum of religious and political viewpoints, but we're all united in the conviction that separation of church and state is essential. We at Americans United believe that religious liberty is the preeminent liberty of the American Republic, the benchmark of all other civil liberties. We believe in the inherent strength of the American religious community to manage its own affairs, to make its own mark and impart a sense of values to the nation. This rich and diverse community does not need propping up by the government and should at all costs remain free from government entanglement. Therefore, we respectfully suggest that the Senate consider carefully the appointment of an individual to the Supreme Court who seems hostile to the time-honored principle of the separation of church and state. Judge Scalia, in testimony before the U.S. Congress and in other ways, has criticized the direction this court has taken in its decisions on religious liberty. In 1978, he testified on behalf of a bill to give tuition tax credits to patrons of private and parochial schools. He supported the bill. Americans United opposed the bill. At that session, in our opinion, Mr. Scalia demonstrated a disregard for the Establishment Clause of the First Amendment. He characterized the bill, the First Amendment, and told the Senate not to worry about the question of whether tuition tax credits were constitutional, but to decide on the basis of what the fundamental traditions of the society require. Those words coming from a man who has been characterized as a strict constructionist. He argued that the denial of tuition tax credits to parents of students at religious schools was an anti-religious result that the framers of the Constitution had not intended. Fortunately, the Congress rejected the unwise advice and defeated the tuition tax credit bill later that year. Mr. Scalia has also characterized the court as being terribly confused about this and other matters of religious liberty. Mr. Scalia has also questioned the High Court's policy of granting broad standing to taxpayers who want to file lawsuits in First Amendment cases, thus shutting the door of the court to many who would bring up First Amendment cases, establishment cases. Throughout his career, Mr. Scalia has demonstrated an insensitivity to matters of the First Amendment. We think also that the Senate should take stock of the direction in which the Reagan administration seems to be taking the Supreme Court. We fear that a Rehnquist-Scalia axis in the court would further subvert individuals to the power of the state. We Americans thought that many of these issues of personal liberty were settled, but apparently they are not. A spirit of confusion prevails in this country. We make the assumption that Judge Scalia reflects the views of President Reagan on church and state, views we find inimical. On the basis of Judge Scalia's record and in vigorous protest of the attitudes of the Reagan administration who appointed him, we oppose the nomination. We ask you to reject the nomination of Judge Scalia to the United States Supreme Court. Thank you, sir.
Thank you, Dr. Maddox. Mr. Weiss. Mr. Chairman, if I may start on a personal note, I'm here representing the Center for Constitutional Rights, and my grandfather and several other members of my family died in Nazi gas chambers. And that has left me with a lifelong passion for human rights and for using the law to resist or seek redress for the commission of atrocities by governments of whatever political stripe. I'm here today because of my conviction that Judge Scalia does not share that passion, and that this raises serious questions about his qualifications to sit on the Supreme Court of the United States. I base that on one case, which is a rather unusual one that has not been touched on by the other witnesses so far. It was called Sanchez-Espinoza v. Reagan. We brought that case in 1982 in the District Court for the District of Columbia on behalf of 9 Nicaraguan victims of Contra atrocities, people who had been subjected, or their relatives had been subjected to murder, kidnapping, rape, torture, and other gross human rights violations. And the defendants included the President of the United States and the Secretaries of State and Defense, Director of the CIA, and various other high U.S. officials. That case was dismissed in the district on a political question doctrine. And when it came before the circuit, Judge Scalia was his usual courteous self and was very interested in the case and indicated that he would not decide it on that basis. And he then proceeded some 15 months later, maybe that was the time it took him to forge a consensus, decided it on a variety of grounds in which he dealt with every single cause of action that had been alleged. But the net result was a total rejection of these claims. And he rejected them even though he had to accept the facts as true, because this was a motion to dismiss. And he rejected them even though he conceded that the courts, in their discretion, could have granted some relief. But he said it would have been an abuse of the court's discretion to grant that relief. He said that sovereign immunity protected the U.S. officials, even though in another case, which we had had in the Second Circuit, sovereign immunity was held not to protect the officials of a foreign government from a suit for torture. Strange message, it seems to me, to send to the world. And he said that the Fourth and Fifth Amendments did not protect these plaintiffs because of the danger of foreign citizens using the courts of the United States to challenge American foreign policy. Now, in its starkest terms, the message of that decision is this: Nuremberg never happened. No matter what atrocities are committed abroad in the name of or under the direction of officials of the United States, foreigners need not apply for redress. We are now at a time when terrorism and counterterrorism have become preferred instruments of foreign policy. And it would be nice to have someone on the Supreme Court who had the courage to protect the victims of that terrorism and of that counterterrorism. I'm afraid that Judge Scalia is not that person, because although he said yesterday that he believes that the checks and balances are the fundamental structure of the U.S. government because they prevent they will prevent one branch from abusing the liberties of the people. Even though he may believe that in principle, I think what he decided in this case, Mr. Chairman, shows that he would not be prepared to enforce that principle as a member of the Supreme Court. I thank you for your attention.
Thank you, Mr. Rice. Dr. Maddox, you referred in your statement to the Lemon case as establishing guidelines to test the constitutionality of any legislation which might run afoul of the Establishment Clause. You say you worry, or that you wonder, if Judge Scalia would dismantle those guidelines. What is the basis of your concern?
We are frequently known by the company that we keep, and one studies the associations of the judge, particularly the American Enterprise Institute and organizations like that with which he spent a great deal of time. And these organizations are committed to destruction of the wall of separation between church and state. They frequently criticize the Lemon decision, any other of these kinds of protections. And so not only by what the judge himself has said and written, but the stumps from which he is hewn make us look very carefully at Judge Scalia when it comes to religious liberty and the separation of church and state.
And you feel that, in your judgment, that this indicates a bias on his part?
Again, that question's been asked of other witnesses, and one cannot, of course, predict that kind of thing, but it does make us real uneasy, fearful that the judge comes to the Supreme Court with a bias toward some kind of establishment of religion, support of religion by the government.
Now, Mr. Weiss, you have a somewhat similar concern based on the Espinoza case.
I do, Mr. Chairman.
And you feel that this indicates a disposition or a bias on Judge Scalia's part?
Well, I think it indicates a disposition on his part to consider the executive branch as the predominant branch of government. And that is a very dangerous thing at a time when the executive is doing some things that it ought not to be doing, like right now. I think it also indicates a lack of concern for fundamental human rights, which is an area of the law that has developed greatly in the last 20 or 30 years, and to which Judge Scalia, in this particular opinion, showed very little sensitivity. That is, when you dismiss a claim alleging multiple torture and rape and summary execution on the ground that it might be an embarrassment to the foreign policy of the United States, I don't think you're speaking as a judge. I think you're speaking as a Secretary of State. And you ought to be speaking as a judge if the case is presented to you from the other side of the bench.
Let me go back to Dr. Maddox, because you're raising a question of whether or not Judge Scalia will observe precedents, and we did question him on that subject. And at his assurance of the value that he places on precedents. Did you by any chance hear that testimony?
I missed that portion of it. I've listened to a great deal of it. I missed that portion of it.
Well, I'm sorry, because I would like to have asked you whether that allayed any of your fears.
We hear what the man is saying, and we judge him to be a man of integrity, but it is very difficult to change what seems to be a lifelong bent, a lifelong commitment. We've also read that Supreme Court justices do change their minds sometimes. We also have run across a few who do not change their minds or who become more intense in the direction that we find difficult. So our feeling is let's stop it before it gets started.
I see the chairman has rejoined us, and I turn over the floor to him.
Are you through? Well, thank you very much. What does that mean? Oh, you don't have another question, Senator? We want to thank you, and you're now excused. I believe the questions are through. Thank you very much for your appearance. Now, is James Carpenter here? Kenneth F. Collier? Let's see. Will the testimony given this hearing be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Have a seat. You have 3 minutes.
My name is James M. Carpenter. I live in Lime, Ohio. I represent myself as a radio common carrier licensed by the FCC, and I represent my wife, who's also present, my small family business, which includes my family and my grandchildren.
All of them say you're through.
We have a business named Carpenter Radio Company. And on the personal side of it, we started in the business in 1965. We were a pioneer in the paging and radio business. And we had probably the first talkback pagers in the United States in 1965. The president of the telephone company come in with a goon squad, and that's United Telecommunications, United Telephone Company today, unlocked their door, ripped out our equipment, stole our equipment. I had to give you that background because that's the basis of my opposition to Judge Scalia. Judge Scalia has been the General Counsel, Office of Telecommunication Policy, Executive Office of the President, Chairman of the Administrative Conference of the United States, Assistant Attorney General, Office of Legal Counsel, Department of Justice. I've come across him several times in the time that I've been in this litigation, purely because I believed, on a personal note again, no one could unlock my door, rip out my equipment, and steal my equipment, which is against the Fourth Amendment of the United States Constitution. No one could do that. And every time I think of it today, I think of my trip to Berlin, which was prompted by your predecessors for the Potsdam Conference. And in that trip, I still say that I went there to smell 1 million dead in the rubble and to parade and to occupy and watch America sold into the weak position of the world today. Judge Scalia says he's against the Freedom of Information Act. He said that in his writing. I would not be before the Federal Communications Commission if it hadn't been for the Freedom of Information Act. I went there to the Court of Appeals for the District of Columbia Circuit in case 75-1848, and they said that I could open my case upon stipulation of the FCC counsel. They didn't hear the case for a year. I went to the Freedom of Information Act. When I went to the Freedom of Information Act, the FCC became so disturbed, they set the case for hearing without any issues. They spent millions of dollars for years on the case, and at the end of it, they used a judge to tell me that everything I said was frivolous and scurrilous. And as far as I'm concerned, I'd gone to the D.C. Circuit for redress of grievances on the whole matter, and I have not been able to get the information from the clerk or from the archives file, but I believe Judge Scalia was one of the principal judges to deny me a redress of grievances or even to open the case up. So I again had to go to the Sixth Circuit, where they treated me with more disdain than I was treated at the United States Court of Appeals for the D.C. Circuit.
Thank you very much. We appreciate your appearance. Now, the next witness is Mr. Kenneth F. Collier. Is he here? If you hold up your hand, be sworn. Will the testimony given and sharing be the truth, the whole truth, and nothing but the truth? So help you God. Mr. Collier, you have 3 minutes.
I'd like my statement submitted to the record as written, and I'd like to address you directly related to what it's describing. The issue of the integrity of the nominee has been questioned in the statement which the committee has been given. And that statement has been distilled from 4 hours of testimony which investigative reporters from the Dade County Home News in Florida submitted to the Federal Bureau of Investigation earlier this month, within 6 weeks ago. It is a serious claim that Judge Scalia actually created a counterfeit concurrence. And a concurrence is a document which is used in order to express a concurring view with a slightly different twist. And in a very important case that's cited in this document, and in the Federal District Court, and in a case in the Superior Court of the District of Columbia, Judge Scalia is charged with having utilized this concurrence to virtually fix a case for the Republican National Committee. Now, these are serious charges, and we're aware of the gravity of such a charge. But the paperwork has been submitted to your staff, Senator Thurmond, excuse me, Jack Mitchell in particular, and the FBI report and the statements in full and a good 4-hour debriefing of this matter so they wouldn't be held in 3 minutes and some mud slung and some charges made. But instead, there's been 6 weeks for these charges to be evaluated, and in addition, in order to test them on their merits, a lawsuit was instituted against Judge Scalia as soon as it was found out that he was up for this nomination in order to test in the federal court of the District of Columbia. It's right now in front of a judge who has been assigned to it at random. I won't mention his name, it's not important at this point. And that this lawsuit against Judge Scalia directly challenges his integrity and the reasoning that was used and the cronyism and the tampering of records that was implicit in his deliberate concocting of a so-called concurrence, which was nothing but a counterfeit, which served to derail several cases in the courts below, all of which cases involved personal, close associates and friends of Judge Scalia's, and also that certain other judges who ruled in the courts below, utilizing that concurrence in a most unfavorable manner in view of the posture of those cases, were also former colleagues of 13 years duration in one case with Judge Scalia. And so we can see why these lower court judges, particularly in the Superior Court of the District of Columbia, I'm not going to mention that, I see my time is up.
2 more minutes.
I'd accept that, yes, sir. Philosophically, we'll say this. I'm an investigative reporter. I'm not perfect. No one's perfect. These hearings here are not to test anything but deliberate questions as to whether or not this nominee in this time, in this place, is going to be challenged as we did this afternoon. In order to come to these hearings, I was hoping that one question alone even would be asked. And I called up the attorney for Judge Scalia, who is an assistant United States attorney in the Justice Department, defending him against the lawsuit. And I said to her, would you kindly, prior to the time when I have to testify, see if you can reach your client and tell him that we are going to be stating that as of now, since 6 weeks has elapsed since the filing of the suit, it's had a chance to mature. And this maturity, Senator Thurmond, has resulted in not a denial on the merits of the suit which attacked the integrity of Judge Scalia to the utmost and put him as a co-defendant with the Republican National Committee, but the answer instead went to a procedural thing, such as he has immunity to do whatever he did do, and if he didn't file the concurrence, and it was the only concurrence that was never filed in the history of the appeals court, so be it. This kind of behavior should be noted at this time. We felt constrained to come to the committee because we saw what happened when Mr. Brosnahan failed to do so in years past, and now his credibility, which I have no knowledge of, is being questioned, and they're saying, why didn't you come to us when it first was done? This is going to be in the record, and if Judge Scalia had only replied to these charges by not having his attorney state the absolute truth, which he is correct, that there is no requirement for a judicial officer to submit to... May I have 1 more minute, sir? And I will be very concise in what she told me.
Well, if you take 1 more minute.
Yes, I will then.
And I'll give it twice as much as other witnesses have.
Thank you, sir. The attorney for Judge Scalia told me that he was going to plead, that she had discussed it with him, and that he is going to plead procedural defenses to these specific charges. All he needs to do is say, did he know Henry E. Peterson back in the days of 1972 through 74? And did he know Craig C. Donsanto, a material witness in one of the cases that was dismissed and derailed because of the counterfeit concurrence? And why didn't he take himself off the case? And all of those fundamental questions which go to these things. Now, in the face of these hearings, we anticipate that his answers will be forthcoming, and we look forward to those in court, and I'm sure that this committee also does. Thank you, sir.
Thank you very much. And I believe you're the last witness, and this winds up the hearing. We'll excuse you now. Thank you very much.
Thank you.
We'll keep the record open until 4 o'clock Friday afternoon in case any other statements that come in by senators or statements that are supposed to be admitted. We want to thank all the witnesses for their parents. We appreciate their being here, and the committee will take the matter under consideration. Is a vote scheduled on this nomination on August the 14th for Justice Rehnquist and also Judge Scalia. And at that time, the committee will vote, and then the matter will go over until it's acted on by the Senate. We appreciate the presence of those who are here, and we now stand adjourned.